Shripad sir. Court Hall 13. Shripad sir. Umesh sir. Sir ಕೇಳಿಸ್ತಿದ್ಯಾ Court Hall 13. Court Hall 13 ಇಂದ ಉಮೇಶ್ ಸರ್.
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ಕೇಳಿಸ್ತಿದೆ ಅಲ್ಲ?
ಕ್ಲಿಯರ್ ಅಂಡ್ ಇದು ವೆರಿ ಇದು ಕ್ಲಿಯರ್ ವಾಯ್ಸ್. ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
Hello. Hello. Hello.
Hello.
ಹೇಳಿ ಸರ್. ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ದಲ್ಲಿ ಫೋಟೋ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ದಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್
ಸುಮಾರು ಸತಿ ಆಯ್ತು ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
ಯಾವುದು
ಕೊಡ್ಬೇಕಾಗಿರೋದು ಕೊಟ್ಟಿಲ್ಲ.
ಅದೇ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಏನ್ ಬಂದಿದೆ ಅಂತ.
ಅದು ಲಾಸ್ಟ್ 3 times ಇಂದ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ, ತಗೊಂಡಿಲ್ಲ. ಅದ್ರ ಹಿಂದೆ ಬಂದಿರೋದು ಆಲ್ವೇಸ್ ನಾಟ್ ಫೌಂಡ್
ಅಂತ ನಾವು
ಪ್ರದೀಪ್ ಅವ್ರನ್ನ
ಪಾರ್ಟರ್ಡ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಮೇಡಮ್. ಪಾರ್ಟರ್ಡ್ ಅದರ್ ಸೈಡ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ಮಾಡಿದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ.
Serial number 8, my lord. Serial number 8.
8 no mentioning. 8 no mentioning. Page wise करता है. 24, 27, 28 to 34. यार 45 ಹೇಳಿ ಮೇಡಮ್. ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಾ? ಮಾಡಿ ಕೊಡ್ತೀನಿ, ಡೇಟ್ ಕೊಡ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ 53 to 56. 53 to 56.
7 50.
ಹಾ ಹಾ
Taken up after vacation.
ಇವ್ರಿಗೆ ಹೇಳ್ಬೇಕಲ್ಲ ಇನ್ನೊಬ್ರು ಹೆಚ್ಚಿ ಕವಿತೆ
I have informed them also.
ಸರಿ. Appellant counsel seeks time and also submit that already informed R1 and R2 counsel and hence this matter after winter vacation.
serial number 62 my lord.
50.
ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ, ಪೇಜ್ ವೈಸ್ ಕಾಲ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಮೆನ್ಷನ್ ಮಾಡಿ. 59 to 62 ಈಗ ಹೇಳಿ. 62
62 my lord, kindly application my lord. Wakalat is not filed my lord, that's why kindly.
ಅದರ್ ಸೈಡ್ ಯಾರು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರ? ಸುಮಂತ್ ಎಲ್ ಭಾರದ್ವಾಜ್ಗೆ
ಅಲ್ಲ ಅವ್ರು ಮೊನ್ನೆ ಅಷ್ಟೇ ಕಾಪಿ ಕೊಟ್ಟರು ಸ್ವಾಮಿ.
ಸರಿ, ಈಗ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ಡೇಟ್ ತಗೋತೀವಿ ಅಂತ?
ಅಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಇದೆ ಬಟ್ ವಕಾಲತ್ ಬಂದಿಲ್ಲ.
ಮಾಡಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಫಸ್ಟ್.
ಸ್ವಾಮಿ 57 ಸ್ವಾಮಿ.
57 ಏನಾಗ್ಬೇಕು ಹೇಳಿ.
ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ, ಆಪೋಸಿಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ.
57 ನೀವಿಲ್ವಲ್ಲ?
ಎರಡಿದೆ ನೋಡಿ ಸ್ವಾಮಿ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ? ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಮಾಡಿದ್ದೀನಿ.
ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪ್ಲೈಂಟ್ ಇನ್ 1598 of 2016 159 of 99 of 2016 6 time and also submit that already informed other side and this matter after winter vacation.
Public.
Your lordship's kindly.
ವಿಜಯ್ ಕುಮಾರ್ ಅವರ ವೇಟ್ ಮಾಡಬೇಕು, ಪೇಜ್ ವೈಸ್ ಕಾಲ್ ಮಾಡ್ತಾ ಇದೀವಿ, ವೇಟ್ ಮಾಡಿ.
59 serial number 59
59 ಏನಾಗ್ಬೇಕು ಹೇಳಿ.
59 61 and 64. I am out of station my lord, I am sorry my lord.
59
61 64
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ಅದರ್ ಸೈಡ್ ಗೆ?
I will inform my lord.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ, ಓವರ್ ಫೋನ್ ಅಲ್ಲೇ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. ಅವ್ರ ಸೈಡ್ ಇದ್ರು
ಮಾಡ್ತೀನಿ I'll do it my lord.
ಮಾಡಿದ್ಮೇಲೆ ಡೇಟ್
Please my lord.
ಆಯ್ತು
Please my lord.
ಯಾವ್ದ್ರಲ್ರಿ? 59 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಅದೊಂದ್ರಲ್ಲ? ಸರಿ, ಬಾಕಿ ನೋಡೋಣ ಆಮೇಲೆ.
61 and 64.
63 to 68
67 ಮೇಲೆ
67 ಹೇಳಿ.
ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು, ಒಂದ್ 2 ದಿನ ಟೈಮ್ ಕೊಟ್ರೆ ನಾನು ಐ ಟೇಕ್ ಸ್ಟೆಪ್ಸ್.
ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಎಕ್ಸೆಟ್ರಾ
ಲೈಬಿಲಿಟಿ ವಿಷಯ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು.
ತಗೊಳ್ಳಿ. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಇನ್ MSK 7476 of 2017 6 2 days time to furnish the PF.
ವೀಕ್ ಅಂತ ಮಾಡ್ಬಿಡಿ ಸರ್, 1 week ಅಂತ ಮಾಡಿ. ನಾನು ಇನ್ ದಿ ಮೀನ್ ವೈಲ್ ಆಗಿ
1 week and if PF paid issue notice against R2. Finish this matter immediately after winter vacation.
ಓಕೆ.
ನಾನು ಡೇಟ್ ಬರೋರಿ ಫಿಕ್ಸ್ ಮಾಡಲ್ಲ. 59 and 70. ಏನ್ರಿ? ಏನಾಗ್ಬೇಕು? ಏನ್ ಟೈಮ್ ಬೇಕೇನ್ರಿ? ಆಯ್ತು. 72 ಇದೆ ಆ ಕಡೆ ಸ್ಟೇಟ್ ಅಲ್ವಾ? Petitioners counsel 6 time this matter after winter vacation. ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇರೋದೇ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 16th. 16. ಏನ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಟು ಅಪಲೆಂಟ್ ಅಂತಾನೆ ಇದು. No representative for the appellant issue court notice to appellant ಅಂತ ಆಯ್ತು. ಏನಾಯ್ತು ಆಮೇಲೆ? ಸರ್ವ ಆಗಿದೆಯಾ? ಯಾವಾಗ ಕೊಡಿ? The counsel was not represented in the matter. And hence this court ordered to issue notice by order dated 24/3/22. And notice issued. The appellant served person. In this regard, report from the Registrar City Civil Court, Bangalore. This report was received on 4th of April 2022. Until date, the appellant not made any arrangements to engage the counsel. Hence, it shows that appellant is not interested in pursuing the matter. Hence appeal is dismissed for non-prosecution. Non-amendment of valuation, void order dated 19/12/2019. As against 20,000 which was sought in the appeal memo, memo is accepted, the appellant is permitted to amend the valuation in view of the aforesaid amendment to the valuation, the appeal will get transferred to the learned single judge. This is directed to post this matter before the learned single judge by determining the copy of the appeal memo which was filed. ಆರ್ಡರ್ ಆಗಿರೋದು 19/12 ಇಲ್ಲಿವರೆಗೂ ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ ಅವರು. ನೋಡಿ, appellant counsel is absent and even though this court permitted on 19/12/2019 to amend the appeal memo with regard to the valuation, till date not amended. However, one more opportunity is given to the petitioner counsel. ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ವ ಇದು ಆವಾಗಿಂದ 2019 ಇಂದ memo seeking dispensation of notice is a purchase memo is placed on record notice dispense ಆಯ್ತು ಆಮೇಲೆ ಬಂದಿಲ್ಲ. ಆಗಿಂದ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ 19 ರಿಂದ 2022 However, in the ends of justice, one more opportunity is given to amend the valuation within 1 week.
My lord, serial number 3, my lord, 1 week's time I kindly be granted, my lord.
Appellant counsel seeks 1 week time to take notice against R3 and hence 1 week time granted as sought. Rams ಹೇಳಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಜಾಗದಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಎಲ್ಲಿ ಪ್ರೊಸೆಸ್ ಕೊಡ್ತೀರಾ? ಅಲ್ಲಿಗೆ ಕೊಡ್ತೀರಾ? ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳಿ. ಲೆಫ್ಟ್ ವಿತೌಟ್ ಇದು ಇಂಟಿಮೇಷನ್ ಅಂತ ಮಾಡಿದಾರೆ. ಎಷ್ಟು ಸರಿ ಕೊಡೋದು PF? ಈಗ ಏನಾಗಿದೆ? ಈಗ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕು ನೀವು. ಎಷ್ಟು ಒಂದು ವಾರದಲ್ಲಿ ತಗೊಳ್ತೀರಾ? Appellant counsel seeks 1 week time to file necessary application. This matter on 16th. Steps to be taken in respect of R2 since 3 times notice issued. Appellant counsel is absent. Steps not taken.
My lord, serial number 5.
ಹೌದು.
I am appellant for the apparent, madam. My lord, kindly grant 1 week time, my lord, to take steps, man.
ಅಲ್ರಿ is residing in abroad ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ?
ಅಲ್ಲ, respondent number 2, my lord. He is residing in
ಅಬ್ರಾಡ್ ಅಂತ ಬರ್ತಾ ಇದೆ ವಾಪಸ್ ಕೋರ್ಟಿಗೆ. 3 times ಇಶ್ಯೂ ಮಾಡಿದ್ವಿ ನೋಟಿಸ್. ಈಸ್ ರಿಸೈಡಿಂಗ್ ಇನ್ ಅಬ್ರಾಡ್. ನೋಡಿ ಬಂದು ಏನಿದೆ ಅಂತ ಕೋರ್ಟಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಏನಿದೆ ಅಂತ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ.
Please, my lord.
Appellant counsel seeks 1 week time to take steps. And hence 1 week time granted. List this matter on 16/12.
Please.
Sitaram Rao BC furnishing of EPF, FE, etc. to issue notice to R2. Third time list ಆಗಿದೆ ರೀ. ಯಾವಾಗ ಬಂದಿರೋದು? ಅದ್ರ ಮೇಲೆ ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಯ್ತು ಮೇಡಮ್? ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆಯಲ್ಲ ಪಿಟಿಷನ್. ನೋಟಿಸ್ ನಾಟ್ ಕ್ಲೈಮ್ಡ್. Return to sender, not claimed. The notice issued against R who was returned with an endorsement not claimed and hence held sufficient. TG Basuraj, serial number 7. Issue notice to R1. First time. Appellant counsel is, I think first time ಆಗುತ್ತೆ ಇದು 2015. ಓನ್ಲಿ ಕ್ವಾಂಟಮ್ ಆದ್ರೆ ಅವ್ರು ಬಂದು ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಡಿಸ್ಪೋಸೇ ಮಾಡ್ಬೋದಲ್ಲ. ಕೊಟ್ಟಿಲ್ವಾ? ಬಂದ್ರೆ ನೋಡೋಣ, ಪಾಸ್ ಆನ್ ಮಾಡಿರಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಇವತ್ತು ಇರುತ್ತೆ, ಇವತ್ತು ನಾಳೆ ಫುಲ್ ಡೇ ಸಿಟ್ಟಿಂಗ್. PO ಪಾಸ್ ಓವರ್. ಶ್ರೀಪಾದ್ ವಿ ಶಾಸ್ತ್ರಿ.
My lord, I have to file an application for paper publication. I can't dispense.
Appellate counsel seeks time to file necessary application and hence 2 weeks time granted. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪೇರ್ ಆಗುವಾಗ ಫೋನ್ ಎಲ್ಲ ಸ್ವಿಚ್ ಆಫ್ ಮಾಡಿ ಇಟ್ಕೋಬೇಕು ಶಾಸ್ತ್ರಿಗಳ. ಹೇಳಿ. Counsel has filed memo to dispense the notice against R1 and notice is dispensed at the risk of the appellant. Insurance ಏನು ಅಪೇರ್ ಆಗಿದೆ, ಯಾರು ಸರ್ವಾಗಿದೆಯಲ್ಲ, ಅಪೇರ್ ಆಗಿಲ್ಲ. ಮಿಸ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಅಲ್ಲ ಅದು ಇಂಟರ್ಲಾಕ್ಟರ್ ಅಪ್ಲಿಕೇಶನ್ ಬರ್ಬೇಕು. ಈಗ ಬರೀ ಸ್ಟೆಪ್ಸ್ ತೊಗೊಳಕ್ ಬಂದಿರೋದು. ಬೇಡ, ಅದನ್ನ ಅಡ್ಮಿಷನ್ ಅಂತ ಬೇಡದ. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಕನ್ಸಿಡರಿಂಗ್ IA 1/15 ಅಂತ. ಪ್ರೊವೈಡ್ ರಿಪೋರ್ಟ್ ಆಫ್ ನಿಮಾನ್ಸ್ ಬಂದಿಲ್ವಾ? ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು ಹೋಗಿ ರಿಮೈಂಡರ್ ಅನ್ನ ಇಶ್ಯೂ ಮಾಡಬೇಕು. ನೋಡಿ ಏನಾಗಿದೆ ರೀ. Current counsel appearing for the appellant would submit that the injured was evaluated by the Minto Hospital on 21/8. The Nimmans Hospital is directed to get the report from the Minto Hospital and certifies his combined disability and submits. Registry is directed to get the report from the Nimmans and this matter ಅಂತ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಏನ್ ಮಾಡಿದಾರೆ ರಿಜಿಸ್ಟ್ರಿ ಅವ್ರು, ಏನ್ ಮಾಡಿದಾರೆ ನೋಡಿ. ನೆಟ್ ಹೋಗಿದ್ಯಾ? ಯಾವಾಗ? 17/11 ಅಲ್ಲಿ. The registry is sent the letter. So Superintendent, Department of Neurology, Medical Board of Nimmans, Bangalore, on 21/11/22, on the direction of this court, and report is not yet received, and hence issue reminder, or otherwise Superintendent of Department of Neurology to be summoned before the court. This matter immediately after vacation. Palachaya Sripad V Shastri awaiting TCR ಅಂತ ಇದೆ. ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು? Avoid TCR. This matter immediately after vacation. ಏನ್ರಿ ಇದು 1620 ದಿವಸ ಅಡಿಲೆ dated 31/3 by advocate for appellant. ಹೇಳಿ. ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ರಿಟ್ ಹೆಂಗ? ಆಯ್ತು, ರಿಟ್ ಹೆಂಗ್ ಹಾಕಿದ್ರಿ ಅಂತ ಕೇಳಿದೆ. MF ಬಿಟ್ಟು ಫೈನಲ್ ಜಜ್ಮೆಂಟ್ ಆಗ್ತಾ ಹೋದ್ರೆ ಆಯ್ತು. ಏನಾಯ್ತು ರಿಟ್?
ವಾಪಸ್ ತಗೊಳಕ್ಕೆ ವಾಪಸ್ ತಗೊಂಡು ನಾವು
writ petition number 34770 after service of notice and appeared in the state petition and made submission that the state petition is not maintained and only appeal is maintained. So the state court has directed to withdraw the case and file necessary appeal. Hence my advocate had withdrawn the state petition. Since I was not feeling well, I was in Bangalore in my parents' house regarding. ಯಾವಾಗ ವಿಡ್ರಾ ಮಾಡಿದ್ದ? ಅವಾಗ 25/12 ಅಲ್ಲಿ. ಮತ್ತೆ ಇದು ಹಾಕಿರೋದು ಯಾವಾಗ? 15 3 ವರ್ಷ ವಿಡ್ರಾ ಮಾಡಿದ್ನಲ್ಲ.
Wait ಮಾಡಿ.
ಏನ್ ಸಿಗ್ಲಿಲ್ಲ?
Party. Please appellate.
ಅಲ್ಲ ರೀ ಡಿಸ್ಮಿಸಲ್ ಆಗಿರೋ 2000 ಯಾವಾಗ ಇದು ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದಾಗ MSc
level.
2011 ಅಲ್ಲಿ. ಟೂ 2012 ಅಲ್ಲೇ ನೀವೇ ಅಪೇರ್ ಆಗಿದ್ದೀರಿ.
ನಾವೇ
ಹಾ ಡಿಸ್ಮಿಸ್ ಆಯ್ತಲ್ಲ 2012 ಅಲ್ಲಿ. ಮತ್ 2015 ವರೆಗೂ ಯಾಕೆ ಫೈಲ್ ಮಾಡ್ಲಿಲ್ಲ?
ಪಾರ್ಟಿ
ಒಕ್ಕಲತ್ತು ತರ್ಸ್ಕೊಳಕ್ 3 ವರ್ಷ ಬೇಕು.
ಅವ್ರು ಇರ್ಲಿಲ್ಲ, ಅವ್ರ ಲೆಟರ್
ಏನ್ ಕೇಸ್ ಆಫ್ ಡೆತ್?
63 ಹಾಕಿತ್ತು.
ಹಾ ಹಾ
ಅಲ್ಲಿ ಬೇರೆ ಟೀಚರ್ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿ
ನೋಟಿಸ್ ಆಯ್ತಾ? ಏನಾಯ್ತು ಇದ್ರಲ್ಲಿ?
ನೋಟಿಸ್ ಆಗಿದೆ.
ಎಲ್ ಸಂಜೀವ್ ಫಾರ್ ಹೋಮ್? Order I 1 of 15 for CD of 20 days in filing the appeal. ಅಡ್ವೊಕೇಟ್ ಅಪೀಲ್ ಅಫಿಡವಿಟ್ ಏನಂತಿದೆ ಅದು ನೀವು ಹಾಕಿರೋದು ಈಗ ಅದೇ ತರನೇ ಪಟ್ಟಿ ಸಿಕ್ಕಿಲ್ಲ ವಕಾಲತ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದು ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಇದೆ. ಅಫಿಡವಿಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಅಪಲೆಂಟ್ ಅಂತಿದೆ, ಅಡ್ವೊಕೇಟ್ ಬರೀ ಆಮೇಲೆ ಅಪಲೆಂಟ್ ಅಂತಿದೆ. ಫೈಲ್ಡ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಅಂತಿದೆ ಇಲ್ಲಿ. ಅಫಿಡವಿಟ್ ಡೇಟೆಡ್ 31/3/21 ಫೈಲ್ಡ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಅಂತ 21/3 ಅಫಿಡವಿಟ್ ಅಂತಿದೆಯಲ್ಲ ಮೇಡಮ್, ಇದು ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಲ್ಲ. ಪಾರ್ಟಿ ಇದಲ್ವಾ ಅದು? ಪಾರ್ಟಿ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಇವ್ರಿಗೆ we have 1620 days in filing the appeal and in support of the application and affidavit is also sworn to by the appellant. In the affidavit it is stated that was not feeling well and she was in Bangalore in her parents' house. And when she contacted her advocate in the end of February month in the year 2015, regarding status of the case, her advocate had informed the said facts. After trying the respondent have not filed any statement of objections. And the record discloses that petition of the court this court in the appeal the liberty to the petitioners to file appeal. The writ petition was withdrawn. The same order was passed on 26th day of November 2012. And after that also there was a delay of 3 years in filing the appeal. The reason assigned is that it was in the treatment at Bangalore in her parents' house and the same was not communicated to her. And only on verification come to know about the same. And when such reasons are given in the appeal and also it is a case of death of a husband. Yaar Satyradar? Death of an husband of the claimant and taking note of the said ground. It is appropriate to condone the delay of 1620 days in filing the appeal, subject to not entitled for interest. Order on 1 of 17 for condonation of delay of 33 days. Delay of 33 days is condoned. Bro, the appellant counsel 6 times. Missed this matter after winter vacation. ನೀವೇ ಕೈಲಾಶಂಕರ ನೀವೇ PF ಕೊಟ್ಟಿಲ್ಲ ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R1 ಅಂತ ಇದೆ ಎಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ R1 MD ಮತ್ತೆ ಅದ್ ಬಂದಿದೆ ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಬದಲು ಬೇರೆ ತಗೋಗಿದ್ಯಾ ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ಬಂದಿದೆ ಇಲ್ಲಿ ಆಯ್ತು ಬಿಟ್ಬಿಡಿ ಈಗೇನು R2 ಏನ್ ಮಾಡ್ತೀರಿ ರಿಸೀವ್ ಮಾಡಿದಿರಾ ತಗೊಳ್ಳಿ ಈ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ acknowledge the copy of MFA Craft 84 of 2019 and hence no need to take steps. And in connected matter, he is appearing in MFA 6386 of 2016 and hence next admission, post the matter for admission. Delay application idea. Order 1 of 2016 for condonation of delay of 25 days in filing the appeal and the same is condoned for the reasons mentioned in the IA. ಆಯ್ತಲ್ಲ ಮುಗಿತಲ್ಲ ಇನ್ನೊಂದೇನು ಕೆಳಗಡೆ ಒಂದಿದೆ ಅದಲ್ವಾ ಸರಿ 14 order IA 1/17 for there is a delay of 184 days in filing the appeal and for the reasons mentioned in the IA delay is condoned. ಆಯ್ತು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮಹೇಶ್ ಫಾರ್ R2 ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R1 is deemed complete. ಹೇಳಿ ಏನ್ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಓನ್ಲಿ ಕ್ವಾಂಟಮ್
ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್
ಆಕ್ಸಿಡೆಂಟ್ ಡೇಟ್ ಯಾವಾಗ 26/7/2011
issued the on for exhibit basic blood. That's classic.
then
With R6 sent to the owner on 10/8/2011. After that,
exhibit R6 intimation to the RC owner.
postal receipt.
10/8/2011.
File it, but sent on 10/8.
ಆಯ್ತು
After that, much.
after the accident ಒಂದೇ ನಿಮ್ದು ಓನ್ಲಿ ಗ್ರೌಂಡ್ ಕ್ವಾಂಟಮ್ ಹೇಳಿ ಮತ್ತೆ ಎಷ್ಟು ಉಂಡವ್ರು? $4,000. What is his age? 19.
24.
24. ಕ್ಲೈಮೆಂಟ್ಸ್ ಯಾರು? ಮದರ್ ಮಾತ್ರನಾ?
ಮದರ್ ಮಾತ್ರ, ಪೇರೆಂಟ್ಸ್.
ಒಂದ್ರಲ್ಲಿ ಮದರ್, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಪೇರೆಂಟ್ಸ್. ಇನ್ನೊಂದ್ರಲ್ಲಿ ಅವನು ಸತ್ತವನು ಎಷ್ಟು ಏಜ್? 24 ಏನಾ? ಅಷ್ಟೇನಾ? ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಮಹೇಶ್ವರ.
But said to be a carpenter, my lord, then date of accident, my lord, is 2011. Minimum wages, my lord, fixed by the state government, my lord, under the Minimum Wages Act has to be taken into consideration. If that is so, my lord, then the award made, my lord, is reasonable, though it is slightly on the higher side.
ಅಷ್ಟೇನಾ?
And so far as liability is concerned, my lord, there is no liability because policy was not enforced, my lord, as on the date of the accident.
But after the accident only you intimated with regard to the
Yes.
ನೋಡಿ. Heard the appellant counsel and also the counsel appearing for respond number 2. If actual matter is a case of claimant before the tribunal that in MEC 5439 of 2011 is the mother of the deceased, and in MEC 5440 of 2011 are the parents of the deceased. Their case is that on 26/7/2011 at about 5 p.m. when the deceased persons V. Chandrababu and M. Ravi were going towards Uppam town from Palmaner town in a motorcycle. Same was ridden by V. Chandrababu, the deceased in MEC 5439 of 2011. When they reached near Burshetted Palle cross, a lorry bearing number AP 227X5678 came from opposite direction and crashed against the motorcycle. As a result, both of them died at the spot. His claim was made. The contention in MEC 5439 of 2011 that deceased was aged about 24 years and working as part-time teacher and earning rupees 10,000 per month. He was contributing entire his earning to the maintenance of the family. Claimant in MEC 5440 of 2011 contend that he was a carpenter earning rupees 10,000 per month, contributing the entire earnings for the maintenance of the family. Hence made the claim. In response to the claim petition, insurance company appeared and filed a written statement contending that check which was issued was bounced and the same was not valid, and policy was not valid in view of non-payment of consideration. And also counsel and hence the claimant examined himself as PW1. PW1 and 2 and also examined one witness as PW3 and the documents exhibit P1 to 13 are marked. On the other hand, on the other hand, respondent examined one witness as RW1 and documents exhibit R1 to R10. The tribunal, after considering both oral and documentary evidence, allowed the claim petitions granting compensation of rupees 4,62,000 in MEC 5439 of 2011 and 4,72,000 in MEC 5440 of 21 with 8% interest. Hence, and also passing the liability on the insured. Hence, present these two appeals are filed. Main contention of the counsel representing the claimant before this court contained that accident was occurred on 26/2011, and notice was intimated for bouncing of check only on 10/8/2011, after 2 months of the accident. 15 days, sir. 10/8 ಅಂತಿದೆ, 10/8 ಆದ್ಮೇಲೆ
Accident 26/11.
26/11 ಇಂಟಿಮೇಟ್ ಮಾಡ್ರೆ 10/8 ಅಲ್ಲಿ 15 ಹೆಂಗಾಗುತ್ತೆ? 2 ತಿಂಗಳಾಗುತ್ತೆ ರೀ, 1.25 ತಿಂಗಳಾಗುತ್ತೆ.
6/7.
26/7 ಆಯ್ತು.
Intimation 10/8.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಯಾವಾಗ್ರಿ?
26/11.
26/11
2011.
27 or 10/8 ಆದ್ರೆ
7. Right.
26/7.
Right.
26/7. Accident was occurred on 26/7/2011, and intimation was given on 10/8/2011 after the accident, and hence the tribunal committed an error in passing the liability on the insured. And also, counsel could contend that income was taken only 4,000, and deceased was aged about 24 years, and no future prospectus has been added. Per contra, counsel appearing to the respondent to submit that the minimum wages act applies. And claimant claims that one is the teacher and another is the carpenter. Hence, question of awarding higher compensation doesn't arise. Having heard the respective counsel and also on perusal of material available on record, the material clearly discloses that accident was occurred on 26/7/2011. Notice was issued to the insured on 10/8/2011 after 13 days of the accident in terms of exhibit R6.
Exhibit R2 and R5 may kindly be looked into. R2 and R5.
R6. The counsel also would submit that exhibit R2 and R. The counsel appearing for the insurance company would contend that exhibit R2 and
R5.
R5 also to be taken note of. And perusal of exhibit R2. Auto policy ಇದೆ.
R5. R5.
ಅದು ಪ್ಯಾಕೇಜ್ ಪಾಲಿಸಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಅಂತಿದೆ.
R5 ನಲ್ಲಿ it was cancelled, my lord.
ಎಲ್ಲಿದೆ ಕ್ಯಾನ್ಸಲ್ಡ್ ಅಂತ? ಎಕ್ಸಿಬಿಟ್ R5 ಅಂತಿದೆ ಅಷ್ಟೇ, ಕ್ಯಾನ್ಸಲ್ಡ್ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
Check issued or dishonored, my lord. That's why it was cancelled.
Perusal of exhibit R2.
R2 and perusal of exhibit R5. R5 is the package policy endorsement.
Exhibit R3 also may kindly be looked into, my lord. The check which are dishonored.
The notice was issued on 5/8/2011. ಅಲ್ರಿ 5/8 ಅಂತಿದೆ.
ಬಟ್ ಕೆಳಗಡೆ ಪೋಸ್ಟಲ್ ರಿಸೀಪ್ಟ್ 10/8 ಕಳಿಸಿದೆ.
Letter dated 5/8/2011, and on perusal of the postal receipt, it bears the date of 10/8/2011. The same is subsequent to the accident. When the intimation was sent after the accident, the tribunal ought to have taken note of the said fact into consideration. Only after the accident, only check bounce notice was given to the owner, not prior to the accident. When searching the material available on record, the tribunal ought not to have fastened the liability on the insured unless the same is intimated. Hence,
The manner of receipt of premium allowed 2002.
Huh?
Manner of receipt of premium 2002, when the check is dishonored, my lord, contract of insurance will be void ab initio under regulation 4.
In searching the material on record, the tribunal ought not to have fastened the liability on the insured unless the same is intimated.
same is intimated, and counsel would submit that when the check was issued and the same was bounced, regulation 4, the same is void and not liable. And with regard to the aspect, the apex court in the judgment reported in ಯಾವ್ದೊಂದು ಎರಡು ಹಾಕಿ ಮಾಡಿದ್ದೀನಿ ಮೊನ್ನೆ ಎರಡು ಲಕ್ಷ್ಮಮ್ಮ and also ಇನ್ನೊಂದು ಯಾವ್ದು ಆಗಿದೆ ನೋಡಿ ಮೊನ್ನೆ
ಅದು ತಮ್ಮದೇ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಪೋರ್ಟಿಂಗ್
ಮಾಡಿದ್ದೀನಿ ಎರಡು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದೀನಿ ನಿಮ್ದು ಸೇಮ್ in judgment of the apex court in Lakshmama and others in 2012 5 Supreme Court cases 2, 3, 4. ಬೇರೆದಿಂದ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ ಮಾಡಿದೀವಿ ನೋಡಿ ಮೇಡಮ್, ಅದ್ರಲ್ಲಿ ಒಂದು ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. And in this judgment, apex court held that owner of the bus obtained policy of insurance from insurer who cancelled insurance policy only after the accident on ground of dishonor of check. Hence, appellant insurer became liable to satisfy award of compensation passed in favor of the claimants. Held that no interference is required with the order of the High Court. Insurer, however, could prosecute his remedy to recover the amount paid by it to the claimant from insured. You have the principles laid down in the judgment. The insurance company has to pay the compensation and recover the same from the insured. Now, coming to the quantum of compensation is concerned. It is an accident of the year 2011. And notional income would be rupees 6,500, and tribunal taken only 4,000. And the deceased is also aged about 24 years, and 40% has to be added as future prospectus. And if it is added, it comes to rupees also. Yeah, the same as ever. And hence, the claimant is entitled for an amount of 9,82,000, and apart from that, mother is the only sole claimant, and she is also entitled for an amount of 40,000. And apart from 33,000, she is entitled for loss of estate and funeral. In all, entitled for an amount of 10,55,800. In MEC 5440 of 2011, the deceased also same age, Allah?
24.
Same age of 24, and applicable multiplier is 18. And future prospectus has to be added, and if it is added, it comes to rupees 9,100, and after deducting 50%, it comes to rupees 9,82,000. And the claimants are the parents, and hence they are entitled for 40,000 on the head of love and affection. Apart from that, 33,000 on the head of also. In all, claimant are entitled for 10,95,800. Martin. In view of the discussions made up, I pass the following order. Judgment and award of the is modified, and the interest allowed 66% based on the enhanced compensation. Enhanced compensation. The insurance company is directed to pay the compensation and recover the same from the insured. N. Krishnaswamy, nimda. P. Kalpana Gautam Parat. ಪಾಠ ಆಡಂತಿದೆಯಲ್ಲ ಏನು? ಹಾ, ಪ್ರೀಮಿಯಂ ಕಟ್ಟಿಲ್ಲ, ಕಟ್ಟಿದಾರ. ಇದೇನ WC ಇದ್ದಂಗೆ. ಹಾ. ಅವಾರ್ಡ್ ಮಾಡಿದಾರೆ ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಇದ್ರ ಮೇಲೆ ಫ್ಯಾಕ್ಟರ್ಸ್ ತಗೊಂಡಿಲ್ಲ. ಹಾ. ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾರ ಅವರು, ನೀವು ನೋಡ್ರಿ ಫ್ಯಾಕ್ಟರ್ಸ್. ಹಾ. ಅವ್ರ ಕಂಟೆನ್ಷನ್. ಹಾ.
Exception. One, if a vehicle is used for either reward, liability insurance, is not a case. Employee is also excluded. If the employee is excluded, Lord would get it. 2013 ACT SC19, Balkrishna's case.
ಅದೇ ಬಾಲಕೃಷ್ಣ ಕೇಸ್ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಆದ್ರೆ. ಬಟ್ ಅವ್ರೇನ್ ಹೇಳೋದು ಪ್ರೀಮಿಯಂ ಕೊಟ್ಟಿದೀವಿ ಅಂತಾರ ನೋಡಿ. ಪಾಲಿಸಿ ಕಾಪಿ ಇದೆಯಾ ಕೊಡಿ ನೋಡಿ. ಪ್ರೀಮಿಯಂ ಕೊಟ್ಟಿದಾರ 50 ರೂಪಾಯಿ ಏನಕ್ಕೆ ಅಂತ ತಗೊಂಡವ್ರು. 50 rupees ಫಾರ್ ಇನ್ಕ್ರೀಸ್ ಥರ್ಡ್ ಪಾರ್ಟಿ ಪ್ರಾಪರ್ಟಿ ಡ್ಯಾಮೇಜಸ್ ಫ್ರೀ ಅದು. ಹಾ ಕೊಡಿ.
78 ಥರ್ಡ್ ಪಾರ್ಟಿ ಪ್ರಾಪರ್ಟಿಗೆ 6,000 ಅಲ್ಲ 7,000 7,50,000 ಥರ್ಡ್ ಪಾರ್ಟಿ ಪ್ರಾಪರ್ಟಿ
ಡ್ಯಾಮೇಜ್ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ಇಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಅಲ್ವಲ್ಲ,
ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ.
ಜಡ್ಜ್ಮೆಂಟ್ ಏನಿದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಯಾರು ಇದು ಕೊಡ್ತಾ ಇರೋದು ನೀವಾ? ಏನಿದೆ ಅದ್ರಲ್ಲಿ? ಹಾ 11(1)(a). ಈ 11(1) ನಿಮ್ದಿರೋದು 11(1) Roman 2 ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
The remaining part of class A relating to cause of death or injury arising out and in the course of employment of such person by the insurer. In such case, the liability of the insurer is only to extend necessary to meet the requirements of the Act. So far as the national passengers are concerned, there is no limit in the policy as such. Hence, under this term of policy, the insurer is liable to satisfy the award for the liability.
ನಿಮ್ ಕೇಸಲ್ಲಿ ಏನವನು ನಿಮ್ಮವನು? After finishing his job, he was returning in a vehicle belongs to the owner. ಹೋಗ್ತಾ ಇದ್ದ ಅಂತ. ಹಾ ಆಯ್ತಾ?
Nothing has been brought on record that the employee was obliged to travel in any particular manner in the term the employee not even traveling in the office. There is no causal connection between the accident and the employee to be affected. Hence, the claimant is not entitled to any compensation.
How it relates to ಅಡಿಷನಲ್ ಪ್ರೀಮಿಯಂ ಎಲ್ಲಿದೆ ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ. ಅಲ್ಲ ರೀ, ಇದು ಅದನ್ನೇ ಕೊಡಿ. ಸೆಕ್ಷನ್ 11(1) ರೋಮನ್ 2 ಕೊಡಿ. ಅದು ನೋಡಿ ಏನಿದೆ ನೋಡಿ. ಎಂಡಾರ್ಸ್ಮೆಂಟ್ 78 ಇದು ಯಾರ ಹತ್ರ ಇದೆ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? That is with regard to the third party property ರೀ ಅದು. For increased third party property damage risk. Section 11(1) Roman 2 ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಂತ ಇದೆ. ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಯಾರ ಹತ್ರ ಇದೆ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಈಗ? ಮತ್ತೆ ಯಾರ ಹತ್ರ ಇದೆ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಏನಕ್ಕೆ ಇಲ್ಲ?
2001 ಆಗಿದ್ರಿಂದ ಕ್ಲಿಯರ್ ಟ್ಯಾರಿಫ್.
ಅದನ್ನೇ ನೋಡಿ, ಅದು ಇದೆಯಾ ಅಂತ ನಿಮ್ಮ ಹತ್ರ ಕೊಡಿ ನೋಡೋಣ. ಅದು ಕೊಡೋದು ಅದಿಂದಲೇ ಮಾಡಕ್ಕಲ್ಲ. ಇಲ್ಲಿ ಪಾಲಿಸಿ ಆಕ್ಟ್ ಓನ್ಲಿ ಪಾಲಿಸಿ ಅಂತ ಇಲ್ಲಿ ಬರ್ದವ್ರೆ. ಅಲ್ಲೇನೋ 50 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. 50 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಫಾರ್ ವಾಟ್ ಅನ್ನೋದು ಬೇಕು ನಮ್ಗೀಗ.
50 ರೂಪಾಯಿ ಕಲೆಕ್ಟ್ ಮಾಡೋದು ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿಸ್ ಒನ್ ಆಡ್ ಅಂತ ಮಾಡಿ ಫಾರ್ ಇನ್ಕ್ರೀಸ್ಡ್ ಥರ್ಡ್
ಪಾರ್ಟಿ ಪ್ರಾಪರ್ಟಿ ಡ್ಯಾಮೇಜ್ ರಿಸ್ಕ್ಸ್ ಅಂತ ಇದೆ.
6,000.
ಅಲ್ಲ, ಅಲ್ಲಿಗೆ ಹಾಕಿ ಕಾಮ ಹಾಕಿ ಸೆಕ್ಷನ್ 2(1) ರೋಮನ್ 2 ಅಂತ ಹಾಕೋರು. ಎಂಡಾರ್ಸ್ಮೆಂಟ್
78
ಅದ್ ಬೇಕದು. ಎಂಡಾರ್ಸ್ಮೆಂಟ್ 78 ಬೇಕಲ್ಲ?
ಅನ್ಲಿಮಿಟೆಡ್
ಅದ್ ಬೇಕದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ನಿಮ್ಮ ಹತ್ರ ಬೇಕಲ್ರಿ? ಆಯ್ತು, ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕೊಡಿ ಇಂದ. ಅದೇನ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಂತ. ಇಲ್ಲಾಂದ್ರೆ ಇದ್ರ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ. 50,000 rupees ಫಾರ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಕಲೆಕ್ಟೆಡ್ ಅನ್ನೋದು ಬೇಕಲ್ಲ? appearing for the respondent number 2 is directed to place the section 2(1) within bracket Roman 2 endorsement 78 ಅದು 78 ತಾನೆ? 70 na 70. Since a premium of ₹50 is collected in terms of the policy, as this matter on ಯಾವ ಕೊಡ್ತೀರಾ? ಆಫ್ಟರ್ ವೇಕೇಶನ್ ಮಾಡಿ ತಗೊಳ್ಳಿ, ಕಲೆಕ್ಟ್ ಮಾಡಿ. 16th ಲಾಸ್ಟ್ ಡೇ ಕೊಟ್ಟಿರ್ತೀನಿ ನೋಡಿ. 16th ಬಿ ಸಿದ್ದರಾಮಯ್ಯ. ಏನು ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಪೀಲ್ ಏನಕ್ಕೆ ಈಗ ಹಾಕಿರೋದು? ಡಿಸ್ಮಿಸ್ಡ್. ಏನ್ ಹೇಳಿ, ರೀಸನ್ ಏನ್ ಕೊಡಿ. ಫಾಲ್ಸ್ ಇಂಪ್ಲಿಕೇಶನ್ ಅಂತ.
delay in giving the complaint. Pending is page number 7.
Page number 7.
Delay of
PW1 reiterated the person government in his chief examination. Glaring aspect is that the accident occurred on 11/2/2009, whereas claim before came to be filed on 9/8/2009. It is true mere lodging of report itself is not a ground. So the vehicle that is the first and Shivamogga and to the house of so and so. If that were to be the case, petitioner's version could have been considered. But the further says that he was taken to somebody to AC hospital wherein he took treatment for 1 day. And then he was shifted to Preston Hospital at Bangalore. Interestingly, petitioner in the petition says that he was inpatient in Preston Hospital for 30 days. And even after discharge, he is taking treatment as outpatient. But in Exhibit P1, which the FIR along with report that he stayed in a house of his friend at Bangalore and was taking treatment and was under the impression that his family members might have lodged the report before the police. No doubt after petitioner lodged the report, the police had filed the charge sheet as per Exhibit 1. But question how far charge sheet can be accepted. It is not the case of the petitioner that none of the family members came to see him when he was in the hospital. It is not his case that he was totally unconscious during the period of treatment. Even he doesn't produce hospital records or make any attempt to get them produced. No doubt the wound certificate issued by Arts Engineering Hospital marked as shows several injuries on the basis of the records of Niman's Preston Hospital. But the question is whether all those documents the petitioner had produced before Arts Engineering Hospital. Even in Exhibit P2, there is reference only for a road traffic accident that took place on 11/2. No further details are forthcoming. These discrepancies are all of vital importance in view of the delay. Doesn't explain that there was no one in his family to take care of him. He doesn't even disclose the name of the friend in whose house he was staying during the treatment. More interestingly, though petitioner says that he took treatment more than 30 days as an inpatient, did not take pains to inform the police authorities about the accident. In fact, there is no material to show that petitioner disclosed the hospital authorities. ಏನ್ರಿ?
And he was immediately to hospital.
ಆದಿಚುಂಚನಗಿರಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾ. ಆಯ್ತು, ಆದಿಚುಂಚನಗಿರಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾನೆ?
road traffic accident.
RT ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ, ಯಾವ್ದು ವೆಹಿಕಲ್ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ. ಆಯ್ತು, ಆಮೇಲೆ ಎಲ್ಲಿ ವಾಸ್ ಶಿಫ್ಟೆಡ್ ಟು ನಿಮಾನ್ಸ? ಹಾ, 10 ದಿವಸ ನಿಮಾನ್ಸಲ್ಲಿದ್ದ. ಅಲ್ಲೇನು ಹಿಸ್ಟ್ರಿ ಕೊಟ್ಟ? ಆಯ್ತು.
Thereafter, the complaint was given on 9/8/2009. He has explained the delay for giving the complaint. Yes, and he was under the impression that his family members might have given the complaint, but subsequently he came to know that he did not. Family members have not given the complaint. Thereafter, he has given the complaint. Police have investigated the case and they have filed the charge sheet. Megaraju, rider of the charge sheet is challenged by that. Nothing contrary has been proved by the insurance company. Insurance company has not laid evidence.
Yes, madam. ನಿಮ್ಮ ಅನ್ಸಲ್ ಒಂದೇ ದಿವಸ ಅಂತಲ್ರಿ ಅವನ ಪ್ರಕಾರ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ನೀವು ನೋಡಿದ್ರೆ 22 ದಿವಸ ಅಂತೀರಿ, 10 ದಿವಸ ಅಂತೀರಿ. ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ತಗೊಳ್ಳಿ. ಉಬಾಕುಮಾರ್ ಅಂದ್ರೆ ಇವನೇ ತಾನೆ. Immediately I was wherein a first aid treatment at AC hospital. I had been shifted to Niman's hospital, wherein I was admitted as an inpatient for 1 day. And thereafter I had been shifted to Pristine Hospital, Bangalore, wherein I was admitted as an inpatient for a period of 30. ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಸೇರಿದ ವಾಹನದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದ ಅವನಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದು ಬಿದ್ದು ಗಾಯ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 1ನೇ ಎದುರುದಾರ ಹಾಗೂ ಅವನ ವಾಹನ ಚಾಲಕ ನನ್ನ ಪರಿಚಯಸ್ಥರು. ದೂರಿನಲ್ಲಿ 1ನೇ ಎದುರುದಾರರು ಹಾಗೂ ತನ್ನ ದೇವತಾ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಹೋಗಿ ಬಂದಿದ್ದೆ ಎಂಬುದಾಗಿ ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ನಿಜ. ಅಪಘಾತದ ತಕ್ಷಣ ದೂರು ನೀಡಲಿಲ್ಲ. ಅಪಘಾತವಾದ 5 ತಿಂಗಳ ನಂತರ ದೂರು ನೀಡಿದ್ದೇನೆ. ನನ್ನ ವಾಹನಕ್ಕೆ ವಿಮೆ ಹಾಗೂ ಇಲ್ಲದ ಕಾರಣ 1ನೇ ಎದುರುದಾರ ಅರ್ಜಿದಾರನ ವಾಹನದ ವಿರುದ್ಧ ಸುಳ್ಳು ದಾರು ನೀಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು 1ನೇ ಎದುರುದಾರ ಸಹಾಯ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಬಿದ್ದು ಗಾಯ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ ಸರಿಯಿಲ್ಲ. ನನ್ನ ಊರಿನ ತುರುವೇಕೆರೆ 15 ನಿಮಿಷದ ಹೋಗಬಹುದು. ತುರುವೇಕೆರೆ ಆಸ್ಪತ್ರೆ ನಾನು ಚಿಕಿತ್ಸೆ ಪಡೆಯಲಿಲ್ಲ. ನನ್ನನ್ನು ಯಾರು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದರು ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಅಪಘಾತದ ಬಗ್ಗೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ ನೀಡಿದ್ದೇನೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ನಾನು ಹೇಳುವಂತೆ ಯಾವುದೇ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆಯಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಿಕಿತ್ಸೆ ನೀಡಿದ ವೈದ್ಯರುಗಳ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ನಾನು ಹಾಜರುಪಡಿಸಿರುವ ಮೆಡಿಕಲ್ ಬಿಲ್ಗಳ ಮೌಲ್ಯ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಹೇಳುವಷ್ಟು ಹಣ ಚಿಕಿತ್ಸೆಗೆ ಖರ್ಚಾಗಲಿ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಕೊಟ್ಟಿಲ್ಲ, ಪರವಾಗಿಲ್ಲ ಮಾಡಲಿಲ್ಲ. ನಾನು ಮೊದಲಿನ ಈಗಲೂ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಅಂಗವೈಕಲ್ಯದ ಬಗ್ಗೆ ವೈದ್ಯರು ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಿದ್ದಾರೆ.
ಇದು ಒಂದು ಇನ್ಪೇಷಂಟ್ ಆಗಿದ್ದು
12 ಇಂದ 22 ನಲ್ಲಿ ಕ್ರಿಸ್ಟಿಯನ್ ಹಾಸ್ಪಿಟಲ್ ಎಕ್ಸಿಬಿಟ್
ಯಾವ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಯಾವ ವೈದ್ಯರು ಚಿಕಿತ್ಸೆ ನೀಡಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ.
ಎಕ್ಸಿಬಿಟ್ B2. That as per exhibit B2, 12/2/2009 ಕ್ರಿಸ್ಟಿಯನ್ ಆಸ್ಪತ್ರೆ ಆದ್ಮೇಲೆ ಒಂದಿನ ನಿಮ್ಮ ಅನ್ಸುತ್ತೆ
ಹೇಳ್ತಾರ ನೀವು ಮತ್ತೆ ಪ್ರಿಸ್ಟೈನ್ ಅಂದ್ರೆ ನೀವು 12/2/2009 22/2 ಪ್ರಿಸ್ಟೈನ್ ಅಂದ್ರೆ ನೀವು ಇರೋದೇ ಪ್ರಿಸ್ಟೈನ್ ಹೇಳಿ 10 ದಿವಸ ಅಷ್ಟೇ, ನಾಟ್ ಇನ್ ನಿಮಾನ್ಸ್.
ಇಮಿಡಿಯೇಟ್ಲಿ B2 ನಲ್ಲಿ insurance officer has but he is not a witness.
ಆಯ್ತು, ನಿಮ್ಮ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಏನು 6 ತಿಂಗಳು ಡಿಲೇಗೆ?
And we are under the presumption that our family members have given the complaint.
Thank presumption book.
Subsequently, we came to know that they have not given that.
6 ತಿಂಗಳ ಮೇಲೆ ಇವ್ನು ಪೊಲೀಸ್ ಬಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾನೆ. No explanation at all. He was only in the hospital for a period of 1 day in Adichinchirigiri, 1 day in Nimans, only 10 days in Christian hospital. No explanation at all. At least ನೀವು ಇದನ್ನ ಹಾಕಿದೀರಾ ಆದಿಚುಂಚನಗಿರಿ ಹಾಸ್ಪಿಟಲ್ ಏನು
Exhibit B2 ಹಾಕಿದ್ದೀವಿ
Exhibit B2 ನ
ಸರ್ಟಿಫಿಕೇಟ್ ಅದನ್ನೆಲ್ಲ ಡೀಟೇಲ್ ಇಸ್
ರೋಡ್ ಟ್ರಾಫಿಕ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಂತ ಬಿಟ್ರೆ ಇನ್ನೇನೂ ಇಲ್ಲ.
ಏನು ಇಲ್ಲ
ಅಥವಾ ನಿಮಾನ್ಸಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ರು ಅಲ್ಲೂ RTN ಅದ್ರ ರೆಕಾರ್ಡ್ ಹಾಕಿಲ್ಲ. ಹೋಗ್ಲಿ 3ನೇ ಹಾಸ್ಪಿಟಲ್ ಪ್ರಿಸ್ಟೈನ್
ಹಾಕಿಲ್ಲ ಯಾವುದು B2 ಅಷ್ಟೇ
ಯಾವ್ದು ಇಲ್ವಲ್ಲ, ಏನಿಲ್ಲ. ನೋಡಿ, how did the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the judgment and award passed in MEC number 1079 of 2009. With order dated 4th day of May 2013 on the file of additional senior civil judge and MSCT at Tumkur.
ಉಳಿದ ಎಕ್ಸಿಬಿಟ್ B29 to 32 ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಇದೆ ಬಟ್ ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದೆ. ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದೆ ಏನೋ ರೆಕಾರ್ಡ್ ಕೊಟ್ಟಿರೋ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಮೇಲೆ ಇಲ್ಲಿ ಇಂಗ್ಲಿಷ್.
The factual matters of case of claimant that 11/2/2009 at about 7 AM was traveling as a pillion rider in a Hero Honda scooter on Srirangpatna Bidar road, and rider of the vehicle drove the same in a rash and negligent manner and lost control over the same. The vehicle fell into a dig and then dashed to a pig, capsized. As a result of this, he sustained injuries. He was first taken to AC hospital, then to Pristine hospital, and he claims to have spent ₹2 lakhs. The insurance company in the written statement contained that vehicle has been falsely implicated in the case, and vehicle was not involved in the accident. Claimant, in order to substantiate his contention, examined himself as PW1 and document exhibit B1 to 33 2094. On the other hand, respondent examined one witness as RW1. Got marked copy of the policy as exhibit R1. The tribunal, after considering both oral and documentary evidence, dismissed the claim petition and hence the present claim petition is filed. The main contention of the appellant in this appeal is that the tribunal committed an error in dismissing the claim petition. The counsel observed that at the first instance itself, when the injured was taken to the Adichinchirigiri hospital, wherein he has stated that he has sustained injury in the road traffic accident. The tribunal also committed an error in not appreciating the exhibit P2 properly. The appellant was admitted to the hospital on 11/2/2009. Wherein also it is mentioned that road traffic accident. Hence, tribunal committed an error in not considering the same. Per contra, the counsel appearing for the respondent, insurance company would submit that accident was occurred on 11/2/2009. The complaint was given on 9/8/2009. And there was a delay of almost 6 months in lodging the complaint. The tribunal also in paragraph number 9 to 11 discussed in detail with regard to the not producing any material with regard to disclosing the vehicle name involved in an accident, and also not produced any document of AC hospital and Pristine hospital with regard to the involvement of the vehicle. The counsel also submit that the injured was discharged from the hospital on 12/2/2009 itself. Till filing of complaint 9/8/2009, no explanation is given on only the family members might have given the complaint. Hence, the tribunal rightly dismissed the petition. Having heard the respective counsel and also on perusal of material, the case of the claimant that accident was occurred on 11/2/2009 and immediately was taken to the Adichinchangiri hospital, wherein history is given as RTA. And also injured took the treatment at Pristine hospital. And the same is allowed only for 10 days. And in the cross-examination of PW1, in Munja, and the injured in his evidence reiterated the content of the claim petition. And he was subjected to cross-examination, and in the cross-examination, he admits that he has studied up to second QC. He admits in the cross-examination immediately after the accident, he has not given the complaint. And also he admits that complaint was given after 5 months. He suggested that he only driving the motorcycle and he went and dashed against the pig and subsequently twisted the facts. The same was denied. It is also his case that he was a pillion rider, but he admits in the cross-examination that he cannot tell who took him to the hospital. And also he admits that he has not taken any treatment at Turvekere hospital. And also he cannot tell in which hospital, which doctor has given the treatment to him. It is suggested that respondent number 1 is his relative, and the same was denied. Having considered the evidence available on record, and also the evidence of RW1. RW1 evidence. Right. RW1. RW1 in his evidence also he categorically says that accident was occurred on 11/2/2009. RW1 was cross-examined only making suggestion that policy was in force as of the date of the accident. Except the That suggestion, nothing is elicited in the cross-examination with regard to the implication of the vehicle. Having heard the respective counsel and also on perusal of material, admittedly accident was occurred on 11/2/2009. No complaint was given immediately after the accident, and also he was taken to hospital, Christian Hospital on 12/2/2009, and he was discharged on 22/2009. And immediately after the discharge, also he has not given any complaint. And he categorically admits that he gave the complaint only after 5 months. No explanation with regard to the delays concerned except stating that he might have thought that family members have given the complaint. He kept quiet for a period of 6 months and thereafter only complaint was lodged. When such being the material available on record, there is no any connecting material to show that vehicle involved in the accident in which he was proceeding as alien rider. And according to him, rider was one. Huh? Mailarappa. Megharajana, Mailarappa. Megharaju. And he said Megharaju is also not examined before the court. And except mentioning it is a RTA in the hospital at Adichunchanagiri Hospital and also the subsequent hospital, no details of vehicle also given. And vehicle details came to existence only filing the complaint after 6 months of the accident. And hence, the tribunal also not accepted the evidence of claimant and in detail discussed in the judgment regarding delay, as well as no such material is placed before the court with regard to the involvement of this vehicle in the accident. Merely because charge sheet is filed belatedly after 6 months against the rider of the motorcycle, the same cannot be a ground. The deficiencies are of vital importance in lodging the report. No explanation on the part of the claimant, except stating that family members might have given complaint. What prevented in lodging the complaint also nothing is stated. And apart from that, his case is also that the rider of the motorcycle driven the same in a rash and negligent manner. Then he dashed to a pig and the vehicle was capsized. When such material available on record, the tribunal rightly dismissed the claim petition, and in order to come to other conclusion, there is no any substantive piece of evidence, and the tribunal also considered the material on record, and hence I do not find any ground to reverse the finding of the tribunal. ಕೇಸ್ ಹೋಲಿಗಿದಾರಲ್ಲ
ಕ್ಲೈಮೇಟ್
ವೆಂಕಟಪತಿ ಇದಾರ YPV ಇದಾರಲ್ಲ ಮಹೇಶ್ವರ ಪರಾಟು
It has not been challenged by neither rider of the nor the insurance company. That insurance company has not proved the contrary. In spite of which, the tribunal come to conclusion that there is 50% of negligence.
How much? 50%.
No material. And they have filed the charge sheet. Charge sheet has not been challenged. And even the respondents have not laid any contrary evidence. They have not marked.
What is the basis for coming to 50% of negligence? Well, In the light of the above, it was the argument that
Exclusive finding is that.
due to rash and negligent driving of the motorcycles also, the claimants have suffered injuries in the accident. The second respondent has filed his written statement argument, written argument. Both motorcycles in support of also relied upon two decisions of the superior courts. So therefore, it is clear that respondents have not denied the occurrence of the road traffic accident and so on so on. So it is also not in dispute that the said accident has occurred due to collision of two motorcycles. A point to be noted that the complainant in a criminal case with respect to accident was filed by the none else in claimant numbers also. In the complaint, she has clearly stated that it was a head-on collision between two motorcycles. However, she has blamed the rider of the opposite motorcycle for the accident. This is clear from Exhibit P2. Based on the said complaint, FIR was made as per Exhibit P2 against rider of the opposite vehicle. Said to be rider of so and so so. So the copy of the Panchanama in this is also the spot of the accident is also shown to the middle of the road. Both the motorcycle are shown to have sustained damages, headlights also. So this is very clearly makes out the collision was a head-on collision of two vehicles, even though the charge sheet which is at Exhibit P6 shows that 1615 also said to be the rider of the motorcycle is the cause for causing the accident, but is only a charge sheet and the so criminal is not made known to the criminal. On the other hand, the claimant which collision between two vehicles. Middle of the road on Torsak, dakle?
Injury case as in the state has not been prepared. Only on presumption, yellow vehicle involved.
Head on to between two vehicle anta.
Finding is that it lost parameter. Court discussion collision between two motor vehicles. In place of accident, it's exactly in the middle of the road and both have sustained severe damages. Therefore, it is clearly established of accident occurred due to contributed both the motors.
RW1 evidence ಹೇಳ್ತಾರೆ ಕೊಡಿ. ಯಾರದು RW1?
Murthy. The officer of the
PW1 ಅಲ್ಲಿ ಏನಾದ್ರು ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡಿದಾರಾ? ಏನಾಗಿ ಮಾಡ್ರಿ? Yes, YPV. YPV ನಿಮ್ದೆ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
Yes, my lord. Idರಲ್ಲಿ complaint itself speaks for the collision of two vehicles in the middle of the road.
ಆಯ್ತು, ಏನಂತ ಎರಡು ವೆಹಿಕಲ್ ಡಿಕ್ಕಿ ಆಗಿದೆ ಅಂತ ಮಿಡ್ಲ್ ಅಂತಿದ್ಯಾ?
ಡಿಕ್ಕಿ ಆಗಿದೆ. ಬೋತ್ ದ ವೆಹಿಕಲ್ಸ್ ಆರ್ ಸಿವಿಯರ್ಲಿ ಡ್ಯಾಮೇಜ್ ಅಂಡ್ ಇದರಲ್ಲಿ ಪಂಚನಾಮನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್ ಹೋಗಿಲ್ಲ ಅವರು.
ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ
ಪಂಚನಾಮ ಇಸ್ ದೇರ್ ಓನ್ ಡಾಕ್ಯುಮೆಂಟ್. ಐ ವಿಟ್ನೆಸ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರೆ ದ ಇಶ್ಯೂ ವುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಸಾಲ್ವ್ಡ್. ಅದು ಮಾಡಿಲ್ಲ. The main reason for holding contributor negligence is the Panchanama and complaint.
ಇಲ್ಲ ಎದುರುಗಡೆಯಿಂದ ಬಂದವನ್ ಬಂದು ಡಿಕ್ಕಿ ಹೊಡೆದ ಗಾಯಗೊಳಿಸ್ತಾ ಅಂತಿದೆ. ಮಿಡ್ಲ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಇದರಲ್ಲಿ ರೆಸಿಪ್ಟ್ಸ್ ಆಲ್ ಅಕ್ವಿಟರ್ ಸ್ಪೋಕನ್ ಅಬೌಟ್ ದ ಇನ್ಸಿಡೆಂಟ್. ಅದರಿಂದ when the incident speaks for itself, there is no necessity of other evidence ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಮ್ಮ ಕಡೆಯಿಂದ ಆ ತರ ಇದು ಹೋಗಿಲ್ಲ.
ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರಿಗೆ ಮಿಡ್ಲ್ ಆಫ್ ದಿ ರೋಡ್ ಅಂತ ಎಲ್ಲಿ ಸಿಕ್ತು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ನಿಮ್ಮನ್ನ.
ಟ್ರಿಬ್ಯುನಲ್ಗೆ ಅದೇ ಪಂಚನಾಮ ಅಡಾಪ್ಟೆಡ್ ಅಂಡ್ ಕಂಪ್ಲೇಂಟ್ ಆಲ್ಸೋ ಇಟ್ ಇಸ್ ಅಬ್ಸರ್ವ್ಡ್.
ಎಲ್ಲಿದೆ ಹಾಗಂತ ಅದ್ರ ಪಂಚನಾಮದಲ್ಲಿ ಏನ್ ಮಿಡ್ಲ್ ಅಲ್ಲಿ ಆಗಿದೆ ಅಂತಿದ್ಯಾ?
ಪೇಜ್ ನಂಬರ್ 14 ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಟ್ ಇಸ್ ಡಿಸ್ಕಸ್ಡ್.
ನಾನು ಕೇಳ್ತಾರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ, ವೇರ್ ಇಸ್ ದಿ ಮೆಟೀರಿಯಲ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಮೆಟೀರಿಯಲ್ ಇಸ್ ಪ್ಲೇಸ್ಡ್ ಆನ್ FIR ಅಂಡ್ ಪಂಚನಾಮ.
FIR ಅಲ್ಲಿ ಮಿಡ್ಲ್ ಅಲ್ಲಿ ನಿಂತಿದೆಯಾ ಆಕ್ಸಿಡೆಂಟ್? ಇಲ್ಲಲ್ಲ. ಹೌದು. ಇಲ್ಲ ನೋಡಿ, ನಾನು ಕಂಪ್ಲೇಂಟ್ ಓದ್ದೆ, ಆಕೆ ಕೊಟ್ಟಿದ್ದಾಳೆ ಯಾರು ಇನ್ನೊಂದು ಇಂಜೂರ್ಡ್ ಸಿಸ್ಟರ್. ನಾಲ್ಕಡೆ ಆಗಿತ್ತು. ಆಗ ನಮ್ಗೆ
ನಾವು ತುರುವೇಕೆರೆ ತಿಪಟೂರು ರಸ್ತೆಯಲ್ಲಿ ಬೇಚಗಾನಹಳ್ಳಿ ಗೇಟ್ ಸಮೀಪ ಹೋಗುತ್ತಿರುವಾಗ ಸುಮಾರು 4-15 ಗಂಟೆ ಆಗಿತ್ತು. ಆಗ ನಮಗೆ ಎದುರಾಗಿ ತಿಪಟೂರು ಕಡೆಯಿಂದ ಮಾವಿನ ಕೆರೆ ಕಡೆಗೆ ಹೋಗಲು ಬಂದು ಹೀರೋ ಹೋಂಡಾ ಫ್ಯಾಷನ್ ಮೋಟಾರ್ ಸೈಕಲ್ ಇಬ್ಬರು ಬರುತ್ತಿದ್ದು, ಜೋಲಿಸ್ಕನಹಳ್ಳಿ ಗೇಟ್ ಸಮೀಪ ತಮ್ಮ ಬಾತು ಮೋಟಾರ್ ಸೈಕಲ್ ಅತಿ ವೇಗವಾಗಿ ಅಜಾಗರೂಕತೆಯಿಂದ ಓಡಿಸಿಕೊಂಡು ಬಂದು ನಮ್ಮ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಹೊಡಿಸಿದ್ರು. ಆಗ ನಾವು ಮೋಟಾರ್ ಸೈಕಲ್ ಸಮೇತ ಕೆಳಗೆ ಬಿದ್ದೆವು. ಇದರಲ್ಲಿ both the motorcycles are there in the center of the road ಅಂತ.
ಅದೇ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತೀನಿ.
That is the only crux of the matter to appreciate.
ಆಯ್ತು, ಎಲ್ಲಿದೆ ಸೆಂಟರ್ ಆಫ್ ದಿ ರೋಡ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ?
ಇಲ್ಲಿದೆ, ಪಂಚನಾಮದಲ್ಲಿದೆ.
ಎಲ್ಲಿದೆ ಪಂಚನಾಮ?
ತುರುವೇಕೆರೆ
ರಸ್ತೆ ಆಗಿರುತ್ತೆ, ಸದರಿ ರಸ್ತೆ ಉತ್ತರ ದಕ್ಷಿಣವಾಗಿರುತ್ತೆ. ರಸ್ತೆ ಮಧ್ಯಭಾಗದಲ್ಲಿ ತಿಪ್ಟೂರ್ ಕಡೆಯಿಂದ ತುರುವೇಕೆರೆ ಕಡೆ ಹೋಗಲು, ನಡುವಿನ ಕೆರೆಯಿಂದ ತಿಪ್ಟೂರ್ ಕಡೆಗೆ ಹೋಗಲು 2 ಮೋಟಾರ್ ಸೈಕಲ್ಗಳು ಒಂದಕ್ಕೊಂದು ಡಿಕ್ಕಿ ಹೊಡೆದು ಜಖಂಗೊಂಡಿದ್ದು ಕೆಳಗೆ ಬಿದ್ದಿರ್ತವೆ ಅಷ್ಟೇ. ಸದರಿ ವಾಹನವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸೈಕಲ್ಗಳಾಗಿದ್ದು ಮತ್ತೆ ಉತ್ತರಕ್ಕೆ ಮುಖವಾಗಿ ಬಿದ್ದಿರುತ್ತದೆ. ಸದರಿ ವಾಹನವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮುಂದಿನ ರಸ್ತೆ ಮಧ್ಯದಲ್ಲಿ ಬಿದ್ದಿದೆ ಅಂತ ಎಲ್ಲಿದೆ?
ಪರಿಶೀಲಿಸಿದಾಗ 2 ಫ್ಯಾಷನ್ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು ಆಗಿದ್ದು ಕಪ್ಪು ಮತ್ತು ಉತ್ತರಕ್ಕೆ ಕ್ಲೀನ್ ಆಗಿ ಇದಿಲ್ಲ, ಜೆರಾಕ್ಸ್ ಆಗಿಲ್ಲ. ಇದು ರಸ್ತೆಯ ಮಧ್ಯದಲ್ಲಿ ಉತ್ತರಕ್ಕೆ ಮುಖವಾಗಿ ಬಿದ್ದಿರುತ್ತೆ. ಇದು ಲಾಸ್ಟ್ ಬಟ್ 7 ಲೈನ್ ಅನ್ಸುತ್ತೆ.
ಒಂದಕ್ಕೊಂದು ಡಿಕ್ಕಿ ಹೊಡೆದು ಜಖಂಗೊಂಡಿದ್ದು ಕೆಳಗೆ ಬಿದ್ದಿರುತ್ತವೆ. ಸದರಿ ವಾಹನವನ್ನು
ಇದು ರಸ್ತೆ ಮಧ್ಯದಲ್ಲಿ
ಉತ್ತರಕ್ಕೆ ಮುಖವಾಗಿ
yes, that is a sole thing. And next ಬಂದಾಗ when we peruse the MVI report, ಇದರಲ್ಲಿ 2 ವೆಹಿಕಲ್ ಅನ್ನು ಈಕ್ವಲ್ ಆಗಿ ಫ್ರಂಟ್ ಅಲ್ಲೇ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ಅಂತ.
ಫ್ರಂಟ್ ಶಾಕ್
ಹಾಗಾಗ್ಬಿಟ್ಟು 50% ಹೆಲ್ಡ್ ಮಾಡೋದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಇಲ್ಲಿ ರೆಸಿಪ್ಟ್ಸ್ ಎಲ್ಲ ಕ್ವಿಟರ್ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಿದ್ದಾರೆ.
ಡಾಕ್ಯುಮೆಂಟ್ ಶುಡ್ ಬಿ ಪುಟ್ ಟು ದಿ ವಿಟ್ನೆಸ್ ಅಲ್ವಾ? ಎಲ್ಲಿದೆ PW1
ಬೇಕಾಗಲ್ಲ, because these documents are produced by the petitioner himself. When his own documents speak about that, there is no necessity of counter evidence.
Is there any suggestion made to the PW1 that accident was occurred on account of him and it was in the middle?
ನನ್ನ ಹತ್ರ ಡಿಪೋಸಿಷನ್ ಕಾಪಿ ಇಲ್ಲ.
Only suggestion ಮಾಡವ್ರ ಅಷ್ಟೇ. Middle of the road ಇಟ್ಕೊಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
Suggestion has force from the documents.
ಕ್ವಾಂಟಮ್ ಏನ್ರಿ? ಕ್ವಾಂಟಮ್ ಮೇಲೆ
ಮತ್ತೆ there are 7 injuries.
ಕ್ವಾಂಟಮ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
7 injuries.
7 injuries.
2 ಇಂಜುರಿ ಇದೆ, ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ, ಮಿಕ್ಕಿದ ಸಿಂಪಲ್ ಇಂಜುರಿ.
Severe injuries.
ಹಾ.
Factor line indication to find the lower injuries.
Your lordships will find at page number 16 injuries of the judgment. Suddenly, diffuse swelling over middle and lower third of face, abrasion over chin and left side forehead, subconjugal hemorrhage left side, tenderness over infra-orbital margin, right angle, body of the mandible and parasymphysis region. Deferred conclusion, sublingual hematoma present. Fracture line seen in relation to right lower incisor teeth with fracture fragment. ಇದರಲ್ಲಿ 5-6 ಮಾತ್ರ ಇದಾಗುತ್ತೆ, ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ ಆಗಿ ಗ್ರೀವಿಯಸ್ ಆಗುತ್ತೆ. ರೆಸ್ಟ್ ಆರ್ ಸಿಂಪಲ್ ಇಂಜುರೀಸ್ ರಿಲೇಟೆಡ್ ಟು ದ ಬ್ಲಡ್ ಕ್ಲಾಟ್ ಬರುತ್ತೆ.
ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಾ?
ಎಕ್ಸಾಮ್ ಮಾಡಿಲ್ಲ. ಇದು ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಹಲ್ಲಿಗೆ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ಅಂಡ್ ದವಡೆಗೆ ಇದಾಗಿದೆ, ಅದರಿಂದ ಸ್ವಲ್ಪ ಪೇನ್ ಜಾಸ್ತಿನೇ ಇರುತ್ತೆ.
ಕೊಟ್ರೆ 68,000.
68,000 ಆಗಿದೆ. ಏನಂದ್ರೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಟೇಕನ್ ಕೇರ್ ಟು ಸಮ್ ಎಕ್ಸ್ಟೆಂಟ್ 18,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಬಿಟ್ರೆ ಮಿಕ್ಕಿದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಬಿಕಾಸ್ ಅವರು ಲಿಕ್ವಿಡ್ ಫುಡ್ ತಗೊಂಡಿರ್ತಾರೆ ಸ್ವಲ್ಪ ದಿವಸ, ಅಂಡ್ ಅಟೆಂಡೆಂಟ್ ಚಾರ್ಜಸ್ ಅಂತ ಏನೋ ಎಕ್ಸ್ಟ್ರಾ ಬರಲ್ಲ. ಎಕ್ಸ್ಟ್ರಾ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ 7,398 ಇಟ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಬಿಕಾಸ್ ವಿಕ್ಟೋರಿಯಾ ಹಾಸ್ಪಿಟಲ್ ಅಂಡ್ ನಿಮಾನ್ಸ್ ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ಮೆಂಟ್.
ಲಾಸ್ ಆಫ್ 90 ಇತ್ತು, 29,000.
ಅಲ್ಲಿ ಜಾಸ್ತಿ ಆಗ್ಬೇಕಾದ್ರೆ
ಎಷ್ಟು ಸೇರಿದ್ರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ? 14 days.
26/10/2009 to 10/11/2009. He was inpatient in Nimans. Victoria and Nimans ಎರಡು ಕಡೆ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
Taylor, but nim doctor evidence not. It is true that injuries found on the injured would not cause him any inconvenience or difficulty in pursuing his avocation as a tailor ಅಂತ ಹೇಳೋರು. ಹಾಕಿದೇನು ಇಂಜುರಿ? ಇನ್ನೊಂದು ಸಿಸ್ಟರ್ ಜೊತೆ ಇದ್ರಲ್ಲ, appeal is only one matter. Oh. The appellant counsel and also the counsel appearing to the respondent. This appeal is found challenging the judgment and award. Passing ABC number 2009, dated 13 December 2012 on the file of Principal District and MSCT Tumkur. Questioning the quantum and also the contributory negligence. The factual matrix of claimant that on 25/10/2009 at about 4:15 p.m. both of them were going in their this claimant and also his sister were going in their two-wheeler motorcycle. When they reached near Kadala Kochihalli gate, the rider of the offending vehicle, even the same in a rash and negligent manner, and who came in opposite direction caused the accident. As a result, he had sustained injuries and immediately was taken to Kittur Government Hospital wherein he took first aid and thereafter shifted to Nimans. It is also his evidence that he took treatment at Nimans Hospital and incurred huge medical expenses. After the discharge, also he is taking treatment. It is his case that he was a tailor by profession and earning rupees 35,000 per month. In order to substantiate the insurance company, in response to the claim petition, filed the written statement attending that accident has occurred due to rash and negligent driving of both the motorcycles riders and it is a case for contributory negligence. The Panchanama drawn goes to show that there was negligence of both the vehicles since both the vehicles found on the middle of the road. He also contended that claim report discloses damages to both the vehicle. The claimant, in order to substantiate his case, he examined SPW1 and also examined the doctor as SPW3. On the other hand, respondent examined one witness as RW1. The claimant's got marked document exhibit P1 to 54 in both the cases. The respondent produced document of exhibit R1 and R2. The tribunal, after assessing the evidence available on record, granted compensation of rupees 68,900 and deducted 50% of the contributory negligence. And after deducting, awarded only 34,450. Hence, the present appeal is filed by the claimant. The main contention of the counsel appearing for the claimant that he had sustained 7 injuries. And out of that, injury number 6 and 7 are pertaining to the fracture line in scene in relation to lower incisor teeth with fragment mobile, fracture of right parasympathesis of the mandible. He was an inpatient for a period of 14 days. He was aged about 46 years. Due to the injury, he suffered permanent disability. And in order to do the same, examine the doctor as PW3, the tribunal committed an error in not awarding just and reasonable compensation. The counsel appearing for the appellant also contend that the tribunal committed an error in taking the contributory negligence to the extent of 50%, even though respondents are not let any evidence before the tribunal except examining the official witness. And the very approach of the tribunal with regard to the contributory negligence is erroneous and hence it requires interference. Per contra, the counsel appearing for the respondent insurance company brought to notice of this court the records measure of spot measure wherein it is specifically mentioned as vehicles were lying in the middle of the road. And also take the note of principles of reciprocal acquitter and come to the conclusion of contributory negligence, and hence it doesn't require interference. Counsel also submit that with regard to the quantum of compensation is concerned, they have suffered only 2 previous injuries and other injuries are simple in nature, and hence the tribunal rightly awarded compensation and it doesn't require any interference. Having heard the respective counsel and also on perusal of material, particularly with regard to the injuries are concerned, mainly relied upon the document of full certificate, which is marked as exhibit P. Wherein 7 injuries are mentioned. And also he was an inpatient. For exhibit 9. ಇಲ್ಲಿ ವಿಕ್ಟೋರಿಯಾದಲ್ಲ.
Heading is at page number 352.
And he was shifted to the Nimans, wherein he was an inpatient. Also, he took treatment at Pandurangana. Pandurangana. And he was an inpatient at Victoria Hospital. From 26/10/2009 to 10/11/2009, he was an inpatient. Having taken note of the nature of injuries sustained by claimant, that is facial injury, and also the fractures. In total, 7 injuries he had sustained. And tribunal awarded only compensation of rupees
2009.
ಅಲ್ಲರಿ ಇಂಜುರಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಟ್ಟೆ ಅಲ್ವಾ?
ಇದನ್ನ loss of 90 ಅಂತ ಹೇಳ್ತಾರೆ. ಅದೇ ಬಹುಶಃ loss of 90
ಹೌದಾ?
Struck ಇಲ್ಲ. Number 4.
ಬೇರೆ ಇದೆಲ್ಲ ಇಶ್ಯೂ ನಂಬರ್ 3.
Page number 2 of synopsis.
ಹ್ಮ್
16.
Other column ಮಾಡಿ.
I 21 ನೋಡ್ತಾ ಇದ್ದೀನಿ. 3,000 for the remaining for 4 simple injuries.
It's a finding of that lost 9 teeth. Internal page 13 lost 5 simple injuries. ಅದನ್ನೇ ಅಲ್ಲಿಗೆ 5,000 ಕೊಟ್ಟು ಅದರ 8 ಅಲ್ಲಿಗೆ 3,000. ಏನದು ಹಾಕ್ಬೇಕಾರೆ
Claimant has lost 9 teeth. Don't ಏನಾಯ್ತು ಮೇಡಮ್? Injury is and also the tribunal in paragraph injuries for document exhibit P5. Also the evidence of Dr. PW3. There was a and exhibit P12 and P13 shows that due to the fracture of right parasympathesis of the mandible, the claimant has also lost 9 teeth and also sustained 5 simple injuries. As such, for the loss of first teeth, he is entitled for a compensation of rupees 5,000, and for the loss of other 8 teeth at the rate of rupees 3,000 per teeth, he is entitled for compensation, that is 24,000. And hence awarded an amount of rupees 29,000. It is also observed that out of 5 injuries, simple injuries are there are 5 simple injuries sustained by him towards simple injury for pain and agony. He is entitled for a compensation of 3,000. For the remaining 4 simple injuries, 2,000 each. In all, entitled for an amount of rupees 8,000. And total 11,000. And awarded an amount of rupees 21,000 on the head of loss of income during hospitalization for a period of 14 days. Attendance charges entitled for 1,400. And medical bills are also to the tune of rupees 7,398.
2,100.
awarded future medical expenses of rupees 18,000 based on the evidence of the doctor. And in all granted compensation of rupees 68,000 900
898 ಆಗಿದೆ round up
900. And having taken note of the assessment of compensation by the tribunal, it is not in dispute that there were loss of 9 teeth. And apart from that, he had sustained 5 simple injuries and 2 previous injuries. When such being the material on record, and when he had suffered the facial injury and also the fractures of right parasympathesis of the mandible, the tribunal committed an error in awarding only an amount of 29,000 plus 11,000 for the injuries, and also the loss of teeth at the rate of rupees 5,000 and 3,000, and for other loss of teeth at the rate of rupees 3,000, and hence in all claimant is entitled for compensation of rupees 1 lakh on the head of pain and suffering. The tribunal only awarded an amount of rupees 14 days at the rate of rupees 1,500, at the rate of rupees 150 for a tailor, and also calculated attendance charges at the rate of rupees 100. And having taken note of he is an inpatient for a period of 14 days, it is appropriate to award an amount of rupees 15,000 on the head of food and nourishment and other incidental expenses. The tribunal awarded only compensation of rupees 2,100 on the head of loss of income when he had suffered the 5 injuries, simple injuries, as well as 2 previous injuries, and when he was in the hospital for a period of 14 days, and only that is for only hospitalization, and he has to take the rest when he had sustained the fractures, and the tribunal not taken note of the setback into consideration, and hence it is appropriate to award an amount of rupees 5,000. And having taken nature of injuries, it minimum requires 4 months for uniting a fracture and for rest, and at the rate of rupees 5,000 enhanced to 20,000, granted an amount of rupees 20,000. The tribunal also considering the evidence of the doctor who deposed before the court that he needs dental treatment and it cost about rupees 18,000. The same is also considered and awarded an amount of rupees 18,000, and the same doesn't require any interference. With regard to the quantum of compensation on the head of future loss of income is concerned, when the doctor has been examined, he categorically admitted that it doesn't require any, and the nature of injuries will not come in the way of his avocation, and hence question of considering the future loss of income doesn't arise. However, the tribunal have taken note of the nature of injuries and not awarded any compensation on the head of loss of immunities. And the injured is aged about 46 years at the time of the accident, and hence 25,000 is awarded on the head of loss of amenities. The tribunal awarded an amount of rupees 7,398 for medical expenses, and he was an inpatient for a period of 14 days, and hence it is and the same has to be rounded off as 10,000 as against 7,398. Ella mugita madam alige. Now claimant is entitled for compensation of rupees 1,88,000. Now coming to the aspect of contributory negligence is concerned, on perusal of the judgment of the tribunal comes to the conclusion that in this part measure, vehicles are in the middle of the road, and accident was occurred. Even ಏನಿದು
Pending vehicle is motorbike number.
ನಾರೇ ಎಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿ ರೋಡ್ ಯಾವುದು?
Chittoor and
gate. Accident was occurred on 25/10/2009, and spot measure was conducted.
Chittoor and Turekere also.
on the same day at 4 o'clock. The accident was occurred at 6:45. Accident ಆಗಿದೆ ಎಷ್ಟು ಗಂಟೆಗ್ರಿ? 4:15. ಏನಮ್ಮ 6:45 ಅಂತ ಏನೋ ಬರೀತಾರೆ? 4 o'clock. Accident was occurred at
4:15 ಬೀಚಕನಹಳ್ಳಿ ಗೇಟ್, ಬೀಚಿಹಳ್ಳಿ ಗೇಟ್, ತುರುವೇಕೆರೆ ರೋಡ್.
and the spot Manchanama was conducted on 26/10/2009, and it was an accident in the Turvekere Road. Turvekere Road. And accident and the spot Manchanama on the next day, and vehicles were moving on the very same road in order to reach Turvekere and Tiptur. And during the course of cross-examination, PW1 except suggesting the PW1 that accident was occurred due to his negligence. Nothing is elicited, and the said suggestion was denied. But he claims in the evidence that the accident was occurred on the left side of the road. And respondents have not led any contra evidence against the evidence of PW1. The right person to speak with regard to the contributing negligence is the rider of the other offending vehicle, and he has not been examined. And also no spot sketch is also produced before the court, but evidence reveals that accident was occurred when the vehicles are moved in an opposite direction, and when the document of exhibit and when the document of PW1, and also no contra evidence. And merely because damages to the both the vehicle as found in IME report in terms of exhibit P4, the court cannot come to a conclusion that there was a negligence on the part of the rider of the motorcycle. The other offending vehicle rider also not given any
My authority submission is
account of his negligence, on account of the negligence on the part of the petitioner. And when such being the material available on record, the court cannot presume the negligence on the part of the claimant, and the very reasoning given by the tribunal is erroneous, and unless any cogent evidence before the court that the claimant is also contributed to the accident, and when the charge sheet is also filed against the offending vehicle, and the same is also not questioned, ought not to have considered the contributory negligence. And hence it requires interference of this court and to set aside the contributory negligence taken to the extent of 50%.
My lord, on that issue, my authority submission is recips or acquitter I have been pressing into service. And next to that, when document is produced by themselves, they cannot disown the contents of the document. That
is I answered. That has not been confronted to the PW1.
Answer ಆಗಿಲ್ಲ.
ಅಲ್ಲ ರೀ, ಮಹಾಜರ್ ಇದೆ, ಮಹಾಜರಲ್ಲಿ ಹೈವೇ ನಲ್ಲಿ ಹೋಗೋ ವೆಹಿಕಲ್ ಗಳು ಮಧ್ಯ ರಸ್ತೆಲ್ಲ ಬಿದ್ದಿರ್ತಾವ, ಬೇರೆ ವೆಹಿಕಲ್ ಹೋಗೋದಿಲ್ಲ. ಮಹಾಜರ್
ಹೈವೇ ಅಂತ ಅಲ್ಲ, ಇಲ್ಲಿ ಹಳ್ಳಿ ಬೀಚ್, ಹಳ್ಳಿ ರೋಡ್ ಅಂತ ಹೇಳ್ತಾರಲ್ವ, ಅದು ಹೋಗೋ ಜಾಗ.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಹೇಳೇ ಇಲ್ಲ. ಬಿಕಾಸ್ ಆಫ್ ರೆಸಿಪ್ಟ್ಸ್ ಆಫ್ ಟ್ವಿಟರ್ ಐ ಆಮ್ ಕಮಿಂಗ್ ಟು ದಿ ಕನ್ಕ್ಲೂಷನ್
ಪಾಯಿಂಟ್ ಆಫ್ ಲಾ ಆಗಿರೋದ್ರಿಂದ ಟ್ರಿಬ್ಯುನಲ್ ಅಷ್ಟು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಕ್ ಹೋಗಿರೋದು. ಅದು ಬಿಕಾಸ್ ರೆಸಿಪ್ಟ್ಸ್ ಆಫ್ ಟ್ವಿಟರ್ ಅದು ಪಾಯಿಂಟ್ ಆಫ್ ಲಾ ಆಗೋಯ್ತು.
That has not been invoked while coming to such a conclusion also. We have discussions made up by first the following order. Appeal is allowed, improved judgment and award of the tribunal is modified, pointing compensation of rupees also. The contributory negligence is also set aside. The insurance company is directed to pay the compensation.
Rate of interest 6%.
Rate of interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ? 6 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. L D Karegoda and B.S. Umesh for R2. Sanat Kumar Shetty for R1. ಉಮೇಶ್ ಅವ್ರದ್ದೊಂದು ಅಪೀಲ್ ಇದೆ, ಇವತ್ತೊಂದಿದೆ. ಹೇಳಿ. ಹೇಳ್ರಿ.
For enhancement.
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಹೇಳಿ. ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನು? ಇಶ್ಯೂ ನಂಬರ್ 2.
That amputation of right foot, front right foot.
Amputation.
Palm. He was inpatient for 12 days in the hospital.
12 days.
12 days. Compensation awarded is page number 13 of the appeal. Pain and suffering.
20,000. 20,000 pain and suffering in a case of amputation. Loss of earning during laid up period 15,000.
Special diet 10,000. Medical expenses at government hospital.
Government hospital. Loss of immunity. Loss of future disability. 3 lakh children. Future medical expenses. Disability ಎಷ್ಟು ತಗೊಂಡ್ರು?
Disability 60%.
40% of the whole body.
That only.
Disability at 30% ತಗೊಂಡಿದ್ದಾರೆ.
30%. ಹೌದು, ಎದುರುಗಡೆ ಅವ್ರದ್ದೇನು ನಾವು ಹೋಗ್ತಾ ಇದ್ವಿ, ಮೈ ಸೆಲ್ಫ್ ಅಂಡ್ ಮೈ ವೈಫ್ ವರ್ ಗೋಯಿಂಗ್.
ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ತಗೊಂಡಿದಾರ? ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ಬೇಡ, ಓನ್ಲಿ ಕ್ವಾಂಟಮ್ ಮೇಲೆ ಮಾತ್ರ ಹೇಳಿ. ಓನ್ಲಿ ಕ್ವಾಂಟಮ್ ಮಾತ್ರ ತಾನೆ ಅಷ್ಟೇ.
ಅದರ್ ಸೈಡ್ ಇಸ್
ಅದರ್ ಸೈಡ್ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಇನ್ ಕೇಸ್ ಏನ್ ಮಾತ್ರ ಹೇಳಿ. ಅದರ್ ಸೈಡ್ ಹೇಳ್ರಿ. ನೀವೊಂದು ಅಪೀಲ್ ಹಾಕಿದಿರಾ? ಏನಾದ್ರು ಏನ್ರ ಮೇಲೆ ರೌಂಡ್ ಆಕ್ಸಿಡೆಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಿರ? ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್. R1 ನೀವು ಬರೀ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಮಾತ್ರ ಹಾಕಿದ್ರಿ. P3ನೇನಾ? ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ. ಇಂಜುರಿ ಸೆಲ್ಫ್ ಅಂತ ಇದೆ. ಅಕಾಂಪನಿಡ್ ಬೈ ಸೆಲ್ಫ್ ಅಂತಂದ್ರೆ ಅವನೇ ಬಂದ ಆಸ್ಪತ್ರೆಗೆ ಅಂತ. ಆಯ್ತು. Fallen from a jeep. 11:20 AM at Kadadamali gate near stay of the right foot being crushed. The type of this jeep. A26 M 600. ಎಲ್ಲಿದೆ ಅದ್ರ ಬಗ್ಗೆ ದಾಖಲೆ? ನಾನು ಕೇಳ್ತಾ ಇಲ್ಲ, ನಾನು ಕೇಳ್ತಾ ಇರೋದು MLC ಏನಾರು ಇದೆಯಾ? ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಆಯ್ತು, ಅದೆಲ್ಲ ಆಯ್ತು. ಕಾನ್ಸಿಯಸ್ ಅಂತಾನ ಆಯ್ತು. ಎಲ್ಲಿದೆ ಇದು ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೇನೆ. ಆಯ್ತು. ಇದೇನ್ರಿ ಬಂತು ಆಮೇಲೆ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆಯಲ್ರಿ
Pardon?
ಹಿಸ್ಟ್ರಿನಲ್ಲಿ ಫಾಲನ್ ಫ್ರಮ್ ಜೀಪ್ ಆಮೇಲೆ ಇಲ್ಲಿ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ಬಂದಿದೆ ಅಂದೆ
Tempo tracks,
ನಿಮ್ ಕೇಸ್ ನಿಮ್ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಕಾಲಮ್ ನಂಬರ್ 22 ತಗೊಳ್ಳಿ
column.
ಯು ಸಿ ಕಾಲಮ್ ನಂಬರ್ 22 petitioner and his wife Shakuntalamma were proceeding towards Pavagada Shandy
Standing.
while they were proceeding on Tumkur Pavagada road near Venkateshwara College on left side of the road andre they were pedestrians anta
Next.
the tempo tracks bearing number being driven by its driver with high speed and in a rash and negligent manner antide ಅಲ್ವಾ ನಿಮ್ ಪ್ರಕಾರ
Tempo tracks.
ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರಿ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ಹೊಡೆಯಿತು
ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ
ನಿಮ್
ಇದ್ವಿ.
ಮೂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನ್ ಹೇಳ್ತದೆ ಎಕ್ಸಿಬಿಟ್ P3
Column from jeep ಅಂತ.
ಹ?
ನಮ್ ಕಂಪ್ಲೇಂಟ್
ಕಂಪ್ಲೇಂಟ್ ಬಿಟ್ಬಿಡ್ರಿ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಿದೆ ಹಿಸ್ಟ್ರಿ ಏನ್ ಕೊಟ್ರಿ ಹೋದಾಗ
ಸೆಲ್ಫ್ ಅಂತಂದ್ ಹೇಳಿ ಫಾಲನ್ ಫ್ರಮ್ ಜೀಪ್ ಅಂತಂದ್ ಹೇಳಿ.
ಸೆಲ್ಫ್ ಅಂತಂದ್ರೆ ಅವನ ಒಬ್ಬನೇ ಹೋಗವನೆ ಅಂತ ಹೌದಾ ಹಿಸ್ಟ್ರಿ ಆಫ್ ಸೆಟ್ ಟು ಹ್ಯಾವ್ ಬೀನ್ ಫಾಲನ್ ಫ್ರಮ್ ಎ ಜೀಪ್ ನೋಡಿ ವೈಟ್ನರ್ ಹಾಕಿದಿರಲ್ಲಿ ಮತ್ತೆ ವೆಹಿಕಲ್ ನಂಬರು ಎಲ್ಲ ವೈಟ್ನರ್ ಹಾಕಿ ಕ್ಲೋಸ್ ಆಗಿ ಇದಾಗಿದೆ ಈ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಹೌದಾ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಅಲ್ಲ ಏನು ಇದು ಎಂತದ್ದು ಫ್ಯಾಬ್ರಿಕೇಶನ್ at 11:20 AM at Kadadahalli gate near college and also gives history of the right foot being crushed
ಅಲ್ಲ ನಮ್ಮ
under the tire of the same jeep ಆ ಕೆಳಗಡೆ ಜೀಪಿನ ಕಾಲ್ ಕಡೆಗೆ ಅವ್ನು ಕಾಲ್ ಕೊಟ್ಟವನೇ ಕ್ರಶ್ ಇಂಜುರಿ ಆಗಿದೆ this is the history
issued to me not mentioned any number of the jeep.
ಇಲ್ಲ ನೀವೇ ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ರಿ ಎಕ್ಸಿಬಿಟ್ P3 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ
ನನ್ನ ಹತ್ರ P is marked as exhibit
P3
P3.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅವತ್ತು
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು 11/8 same day 11/8/2008.
ಅದೇ ದಿವಸ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದೀರಿ
ಹೌದು.
ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ಪಾವಗಡನ ಪಾವಗಡಕ್ಕೆ ಹೋಗಿದ್ದೀರಿ ಅಲ್ಲಿ ಹೋಗಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹಿಸ್ಟ್ರಿ
ಅಲ್ಲೇ ಗೌರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಹೋಗಿದ್ದೆ.
ಹಾ
ಕಂಪ್ಲೇಂಟ್ ಸೇಮ್ ಡೇ ಕೊಟ್ಟಿದ್ದೆ.
ಸೇಮ್ ಡೇ ಕೊಡ್ಲಿರಿ ಚೇಂಜ್ ಆಗಿದೆ ವರ್ಷನ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಕಂಪ್ಲೇಂಟ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು
ಸೇಮ್ ಡೇ ಈವ್ನಿಂಗ್
ಈವ್ನಿಂಗ್ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಎಷ್ಟು ಗಂಟೆಗೆ
11
o'clock. This statement was given in the hospital at 11:30 ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಕೊಟ್ಟರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದು The injured was taken to the hospital at 11:30 AM. ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಹೋದಾಗ ಜೀಪ್ ಇಂದ ಬಿದ್ದ ಜೀಪ್ ಕಾಲ್ ಮೇಲೆ ಹರಿತು ಆವಾಗ ಕ್ರಶ್ ಆಯ್ತು ಇಂಜುರಿ ಅಂತ ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಇಲ್ಲ ನಾವು ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದೀವಿ ನಾನು ನನ್ನ ಹೆಂಡತಿ ಆವಾಗ
ದಟ್ ಇಸ್ ದಿ ರಿಯಲ್ ಥಿಂಗ್.
ಏನ್ ರಿಯಲ್ ಥಿಂಗ್ ಅಲ್ಲೇ ಆಸ್ಪತ್ರೆಗೆ ಹೆಂಡತಿ ಕರ್ಕೊಂಡು ಹೋಗಲ್ವಾ ಅಲ್ಲ ಅದೇ ರಿಯಲ್ ಆದ್ರೆ ಇಬ್ರು ಜೊತೆ
ಅದೇನಾಗೋಯ್ತು ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಅವ್ರ ಊರ್ನವ್ರು ಇಬ್ರು ಬಂದ್ ಬರ್ತಾ ಇದ್ರು ಆ ರೌಂಡ್ ನಲ್ಲಿ.
ಗಂಡ ಹೆಂಡತಿ ಒಟ್ಟಿಗೆ ಹೋಗ್ತಾ ಇರ್ತಾರೆ ಯಾವ್ದೋ ಒಂದು ಡಿಕ್ಕಿ ಹೊಡೆಯುತ್ತೆ ಡಿಕ್ಕಿ ಹೊಡೆದಾಗ ಒಬ್ಬನೇ ಹೋಗ್ಬಿಡ್ತಾನೆ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಇಂಜೂರ್ಡ್ ಹೆಂಡತಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾಳೆ ತಾನೆ
ಅದೇ ಜೀಪ್ ನಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಇನ್ನು ಇಬ್ರು ಅವ್ರ ಊರ್ನವರೇ ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಅದೇ ಜೀಪ್ ನಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಅದೇ ಜೀಪ್ ಅಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗೋರೆ ಟ್ರಾಕ್ಸ್ ಅಲ್ಲಿ ಕರ್ಕೋ ಇಲ್ಲ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ಅಲ್ಲ
ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್
ನಿಮ್ ಪ್ರಕಾರ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ಹಾ ಜೀಪ್ ಅಲ್ಲೇ ಕರ್ಕೊಂಡು ಹೋಗೋರು ಕರೆಕ್ಟ್ ಜೀಪ್ ಯಾರ್ದು ಆ ಜೀಪ್ ಬಿಟ್ಟಾಕ ಮತ್ತೆ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ತಂದ್ರಿ ಅಂತ ಆ ಜೀಪನ್ ಬಿಟ್ಟು ಯಾಕೆ ಟೆಂಪೋ ಟ್ರಾಕ್ಸ್ ತಂದ್ರಿ ಹಿಂದೆ ಏನ್ ಹಂಗೆ ಇದೆ ಬಿಡಿ ಎಲ್ಲ ಪೂರ್ತಿ ಇದೆ ಅರ್ಧ ಗಂಟೆಲಿ ಕೊಟ್ರ ಹಿಸ್ಟ್ರಿ ಅದು
ಗೋ ಥ್ರೂ ದಿ ರೆಕಾರ್ಡ್ಸ್
ದಿ ರೆಕಾರ್ಡ್ಸ್ ಹಂಗೆ ಇರೋದ್ರಿ ಏನಿಲ್ಲ ಸೆಟಸೈಡ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ನೀವು ಯಾಕೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ
ಅವ್ರದ್ದೇನು ಎವಿಡೆನ್ಸ್
ಆಯ್ತು PW1 ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಿರಿ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರಾ PW1 ಕ್ರಾಸ್ ಹೋಗಿ ಕ್ರಾಸ್ ಮಾಡಿ ಡಾಕ್ಟರ್ ಹೇಳ್ಸಿದೀರಾ ರಾಜ ಡಾಕ್ಟರ್ ಶಿವನ್ ರೆಡ್ಡಿ ಅದೇ ದಿನ ಬರಗಾಲ ಜೀಪ್ ಅಪಘಾತವಾಗಿ ಕೆಳಕ್ಕೆ ಬಿದ್ದು ಬಲಪಾದಕ್ಕೆ ಜಜ್ಜಿದ ಗಾಯವಾಗಿತ್ತು ದಾಖಲಾಗಿ ನರಸಿಂಹದೇವಿ 12 ವರ್ಷವರೆಗೆ ಬೇಜಾರಿದೆ ಸದೇ ಅವರಿಗೆ ದಿನಾಂಕ 11/8/2000 ರಾಜವಂತಿ ಕಾರ್ಡ್ ಪಾವಗಡ ರಸ್ತೆಯಲ್ಲಿ ಜೀಪ್ ಅಪಘಾತವಾಗಿ ಕೆಳಕ್ಕೆ ಬಿದ್ದು ಜಲಪಾದಕ್ಕೆ ಜಜ್ಜಿ ಗಾಯವಾಗಿತ್ತು ಗಾಯಗಳು ಬೆಳಗ್ಗೆ 11:30 ಗಂಟೆಗೆ ಒಳರೋಗಿಯಾಗಿ ದಾಖಲಾಗಿ ಚಿಕಿತ್ಸೆ ಪಡೆದಿರುತ್ತಾರೆ ಸದರಿ ಅವರಿಗೆ ಅದೇ ದಿನ ಬಲಗಾಲಿಗೆ ಮಾಡಿದ್ದೇನೆ ಆತನ ಬಲಗಾಲಿನ ಪಾದ ಸಂಪೂರ್ಣ ಜಜ್ಜಿ ಹೋಗಿದ್ದು ಭಗವಾನ್ ಶಬ್ದ ಆಯ್ತು. ಡಾಕ್ಟರ್ ಕೇಳ ಅದೇ ಎವಿಡೆನ್ಸ್ ಹೇಳ್ತೀನಿ ಕೊಡ್ತಿದ್ರಲ್ರಿ.
Last examination, yeah. PW1.
ಹಾ ಕಡದೆ ವಕೀಲರಿಂದ ರಾಜಮತಿ ನನ್ನ ಸ್ವಂತ ಊರಾಗಿರುತ್ತದೆ. ಪಾವಗಡಕ್ಕೆ ಆ ದಿನ ನಾನು ನಡೆದುಕೊಂಡು ಬರುತ್ತಿದ್ದೆ. ಪಾವಗಡ 6 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇದ್ದಾಗ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ನನ್ನ ಹೆಂಡತಿ ಇದ್ದಳು. ಆ ದಿನ ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಪಾವಗಡ ಸಂತೆಗೆಂದು ಬರ್ತಿದ್ದೆವು. ನಿಶಾಂತ್ ಗಾಯಪಡೋದ್ರೆ ನಾನು ಜೀಪಿನಿಂದ ಬಿದ್ದಂತೆ ಬರೆಯಲಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಯಾವುದೇ ವಾಹನ ಅಪಘಾತ ಮಾಡಿರಲಿಲ್ಲ. ನಾನೇ ಜೀಪಿನಿಂದ ಇಳಿಯುವಾಗ ಬಿದ್ದು ಗಾಯಪಡಿಸಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತ ನಂತರ ನನ್ನನ್ನು ವಾಹನದಲ್ಲಿಯೇ ಪಾವಗಡ ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಲಾಗಿತ್ತು. ಅಪಘಾತದಲ್ಲಿ ಕೇವಲ ಸಾಧಕಗಳಾಯಿತು. ಒಪ್ಪಿಗೆ ಹುಡುಗರು ವೈದ್ಯರಲ್ಲಿ ಶಾಮೀಲಾಗಿ ಸುಳ್ಳು ಪ್ರಮಾಣ ಪತ್ರ ಬರೆಸುತ್ತೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತ ನನ್ನ ಹಾ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದಾರಲ್ಲ ಇಲ್ಲಿ ಜೀಪಿಂದ ಬಿದ್ರಿ ಅಂತ ಸಜೆಷನ್ ಕೂಡ ಮಾಡಿದ್ದಾರೆ. ಅಟ್ಲೀಸ್ಟ್ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಬರ್ದವ್ರೆ ಅಂದ್ರೆ ನೀವು ಆ ಎಂಟ್ರಿ ಮಾಡಿದಂತ ಡಾಕ್ಟರ್ ಯಾರಿದಾರೋ ಅವ್ರನ್ನಾರು ಕರ್ಸಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ.
ಜೀಪಿಂದ ಬಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ ಬರೆಯಲಾಗಿದೆ.
ಎಂದರೆ ಸರಿಯಲ್ಲ ಅಂತಾರೆ. Then you have to examine the doctor who wrote the history, who gave the history ಅಂತ. MSc registry extract ಹಾಕಿಲ್ಲ ನೀವು. ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ ಯಾರು ಕರ್ಕೊಂಡ್ ಬಂದ್ರು ಏನು ಅಂತ. ಬಟ್ ಇದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ ಸೆಲ್ಫ್ ಅಂತಿದೆ. ಹೆಂಡತಿ ಜೊತೆಗಿದ್ರೆ ಗಂಡನ್ ಡಿಕ್ಕಿ ಹೊಡೆದ್ರೆ ಹೆಂಡತಿ ಕರ್ಕೊಂಡು ಹೋಗಲ್ಲೇನ್ರಿ ಆಸ್ಪತ್ರೆಗೆ? ಮತ್ತೆ ಇಲ್ಲಿ ಸೆಲ್ಫ್ ಅಂತಿದೆ. Heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the judgment and award passed in MEC number 2 of 2009, dated 6th day of December 2013 on the file of Senior Civil Judge and MSCT 20 at Pavagada. The factual matters of case of claimant before the tribunal that on 11/8/2008 at 11 a.m., he himself and his wife were proceeding towards Pavagada Shandy. And when they were proceeding near Venkateshwara College and Tumkur Pavagada Road, one tempo tracks bearing registration number K26M600, being driven by its driver in a rash and negligent manner, came from Madakasira side and dashed against the petitioner and caused the accident. As a result, he fell down and the wheel of the vehicle ran over his right leg palm, causing crush injury. And other injuries all over his body. ಇನ್ನೇನ್ ಟೆಂಪೋ ಟ್ರ್ಯಾಕ್ಸ್ ಜೀಪ್ ಹಂಗೆ ಇರುತ್ತಲ್ರಿ ಇನ್ನೇನು ಸೇಮ್ ತಾನೆ. ಯಾವ ವೆಹಿಕಲ್ ನಂಬರ್ ಕೊಟ್ಟವ್ರವ್ರು? 0067 ಎಲ್ಲಿಂದ ಬಂತು ನಿಮ್ಗೆ FIR? ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲ, ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಇಲ್ಲೇನೋ ವೈಟ್ನರ್ ಹಾಕಿದ್ದಾರೆ. ಕೊಡಿ ತಗೊಂಡವರು ಎಲ್ಲಿ ಮಾಡಿದಾರೆ ಗೊತ್ತಿಲ್ಲ.
ನಮ್ಮ ಇದರಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ನಲ್ಲಿ ವೆಹಿಕಲ್ ನಂಬರ್ ಹೇಳಿಲ್ಲ.
ಇವರು ಹಾಸ್ಪಿಟಲ್ ತಗೊಂಡೋದಾರೆ, ಈ ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಪೊಲೀಸಿಂದ. ನೋಡಿ ಇದರಲ್ಲಿ ವೆಹಿಕಲ್ ನಂಬರ್ ಇದೆ K066007 ಇದೆ. ನೀವು ಕೋರ್ಟ್ ಹಾಕಿರ್ತಕ್ಕಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅದನ್ನ ವೈಟ್ನರ್ ಹಾಕ್ಬಿಟ್ಟು ಅಳಿಸಿದಿರಿ. ಹಾ, ನಿಮ್ಗೊಂದು ಕೊಟ್ಟವ್ರ ಕೊಡಿ. ಇದರಲ್ಲಿ ಇದು ನೀವು ಜೆರಾಕ್ಸ್ ತಗೊಂಡ್ರು ಹೌದಾ? ಅಲ್ಲಿ ವೈಟ್ನರ್ ಹಾಕಿರೋದ್ರಿಂದ ಅದು ಬರಲ್ಲ ಜೆರಾಕ್ಸ್ ಅಲ್ಲಿ. ನಮ್ಮ ಒರಿಜಿನಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇದೆ ಜೆರಾಕ್ಸ್ ಅಲ್ಲಿ. ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್ ಆಗಿದೆಯಾ? ಹಾ, ಇದು ಎಕ್ಸಿಬಿಟ್ P3. ನೀವು ಇದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಿ, ಇಲ್ಲಿ ವೈಟ್ನರ್ ಹಾಕಿರೋದು ಕಾಣಲ್ಲ. ನೀವು ಇದು ಅವ್ರಿಗೆ ತೋರಿಸ್ಬಿಟ್ರಿ ಒಂದ್ಸರಿ ಇದ್ರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ವೈಟ್ನರ್ ಹಾಕ್ಬಿಟ್ಟು ವೆಹಿಕಲ್ ನಂಬರೇ ಅಳಿಸ್ಬಿಟ್ಟಿದ್ದೀರಿ ಕೋರ್ಟ್ಗೆ ಹಾಕುವಾಗ. ಬಲಭಾಗದಲ್ಲಿ ಇದೆ ನೋಡಿ, ಅದು ವೆಹಿಕಲ್ ನಂಬರ್ ಹತ್ರ ಮೇಲ್ಗಡೆ ವೈಟ್ನರ್ ಹಾಕಿ ಫುಲ್ ಎರೇಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಜೀಪ್ ನಂಬರ್ ಅಲ್ಲಿ ನೋಡಿ, ಅಲ್ಲಿ ವೈಟ್ನರ್ ಹಾಕಿದೆ ಇಲ್ಲ? ಹಾಕಿದೆ ಅಲ್ಲ? ಹ ಅಷ್ಟೇ, ಹಾಕಿದೆಯೋ ಇಲ್ವೋ ಅನ್ನೋದು ಬೇಕು ನಂಗೆ ಅಷ್ಟೇ. ಹಾಕಿದೆ. ನಾವಿದೀವಿ ಅದಕ್ಕೆ. ಅಂತದ್ದೆಲ್ಲ ಇದೆ. ಫ್ರಾಡ್ ಇದ್ರೆ ನಾನು ಐ ವಿಲ್ ನಾಟ್. ಆಯ್ತು, ಫ್ರಾಡ್ ಅಂಡ್ ಜಸ್ಟಿಸ್ ಶುಡ್ ನಾಟ್ ವೆಲ್ ಟುಗೆದರ್. ಆಯ್ತಾ? ಇನ್ನೇನ್ ಕೇಸ್ ಇದ್ರೆ ಕೊಡೋಣ. ವೆಹಿಕಲ್ ನಂಬರೇ ಬೇರೆ ಇದೆ. ಆಮೇಲೆ ನೀವು ಟೆಂಪೋ ಟ್ರ್ಯಾಕ್ಸ್ ತಂದ್ರಿ. ಐ ಥಾಟ್ ದಟ್ ಈಗ ಏನಾಗುತ್ತೆ, ಹಳ್ಳಿ ರಸ್ಟಿಕ್ ಜನಗಳಿಗೆ ಗೊತ್ತಾಗಲ್ಲ ಟೆಂಪೋ ಟ್ರ್ಯಾಕ್ಸ್ ಯಾವುದು ಅಥವಾ ಜೀಪ್ ಯಾವುದು ಗೊತ್ತಾಗಲ್ಲ ಅಂತ. ಸ್ವಲ್ಪ ಡಿಫರೆನ್ಸ್ ಇರ್ಬೋದು, ಬಟ್ ಅದ್ರಲ್ಲಿ ನಿಮ್ಗೆ ಹಂಗಿಲ್ಲ. ವೆಹಿಕಲ್ ನಂಬರು ಇದೆ, ವೆಹಿಕಲ್ ನಂಬರ್ ಡಿಫರೆಂಟ್. ರಿಮೈಂಡ್ ಹಾಕಿ ಮಾಡ್ಬೇಕು. ನೀವೇ ಹಾಕುವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಇದು ಕೋರ್ಟಿಗೆ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕುವಾಗ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ನ ವೈಟ್ನರ್ ಹಾಕಿ ವೆಹಿಕಲ್ ನಂಬರ್ ರಿಮೂವ್ ಮಾಡಿ ಹಾಕಿದಿರಿ. ಹಾ, ರಿಮೈಂಡ್ ಅಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಕಾಸ್ಟ್ ಹಾಕಿ. ಹೌ ಯು ಕ್ಯಾನ್ ಟ್ಯಾಂಪರ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್? ನೋಡಿ ಏನಾಯ್ತು ಮೇಡಮ್? Other injury and he was shifted to the hospital and he was an inpatient for a period of 12 days. 12 days. The claimant, in order to substantiate his case, examined himself as PW1 and also examined the doctor as PW2. And got marked document exhibit P1 to 11. On the other hand, respondents have not laid down evidence, however, got marked the document of exhibit R1, insurance policy. The tribunal, after considering both oral and documentary evidence, allowed the claim petition granting compensation of ₹4,650,000 with 6% interest. Being agreed by the judgment and award, the insurance company has filed this appeal. The main contention urged in this appeal that the tribunal committed an error in not considering the exhibit P3 own certificate which discloses the history given in exhibit P3 had fallen from. ಯಾರ್ದು ಅಪೀಲ್ ಯಾರ್ದು ಇದು? ಇಂದಲ್ವ ಅಪೀಲ್ ಅವ್ರದ್ದು ಒಂದಿದೆಯಾ? ಕೊಡಿ. Fallen from a bike or the jeep and right foot being crushed under the tire of the same jeep, and the same has not been considered. The counsel also would submit that during the course of cross-examination, the same was suggested with regard to the history given by him, and he denies the same. The counsel also brought to notice of this court that in the own certificate, vehicle number is mentioned as K066007. But while filing the own certificate before the court, the same is harassed by using the whitener and committed fraud on the court. And the tribunal also, while considering the material and record, failed to take note of the history given at the time of the hospital in terms of exhibit P3, and instead of entertained the claim petition and granted compensation, and hence it requires interference. For contra, the counsel appearing for the respondent claimant in appeal filed in MFA 2663 of 2014 contained that quantum of compensation awarded is very meager, and it's the case of amputation of the right foot and disability taken, 30% is against the evidence of the doctor, 40% who deposed with regard to the whole body. And compensation awarded on pain and suffering and other heads are also very meager, and hence it requires an interference to enhance the compensation. Having heard the respective counsel and also on perusal of material, the point that would arise for the consideration of this court, whether the tribunal committed an error in allowing the claim petition, not considering the defense of the implication of the vehicle, and claim petition is filed with intention to make wrongful gain as contended in the appeal by the insurance company, whether the tribunal committed an error in not awarding just and reasonable compensation. Having heard the respective counsel and also on perusal of material, it is emerged in the course of evidence and also the leading evidence. It is the case of the claim that 18/11/2008 at about 11 a.m. near Venkateshwara College, the claimant along with his wife were proceeding as pedestrians. And tempo tracks came and dashed against the claimant. But the claimant themselves have relied upon the document of Exhibit P3, food certificate, wherein history is mentioned as injured is fallen from the jeep. And on perusal of Exhibit P3, the further mentioning of vehicle number is erased by using the whitener. And counsel appearing for the insurance company showed the copy of the wound certificate, wherein vehicle number is mentioned as K060607. And the same is not found in the Exhibit P3. Counsel appearing for the claimant also not dispute the fact that whitener was used to erase the vehicle number. And apart from that, it is the claim of the claimant that he was proceeding along with his wife and an accident was occurred. But on perusal of the wound certificate, he was not accompanied by wife, but he went alone and accompanied by, it is mentioned as self. And history was given within a span of half an hour of the accident, and accident was occurred at 11/8/2008 at 11 a.m. and injured was taken to the hospital at 11:30 a.m. to Pavagada Hospital, government hospital. And while giving the complaint in the evening on the same day, twisted the facts and given the history that tempo tracks came and dashed against them, and both of them are pedestrians. And if really the wife was accompanied with the injured at the and she was there along with the injured, the wife would have been rushed along with the injured to the hospital, and she was not accompanied with the injured at the time of admitting to hospital. And these are the evidence has not been considered by the tribunal. When the documentary evidence Exhibit P3 is clear that history was given that fallen from a jeep. And also not only it is mentioned as fallen from jeep, it is also given the history of the right foot being crushed under the tire of the same jeep. And this aspect is also not considered by the tribunal. During the course of cross-examination, PW1 specific suggestion was made to the witness that history in own certificate Exhibit P3, it is mentioned that he had fallen from the motorcycle, the jeep. But the witness denies the same. Even assuming that the said entry is made by wrong notion. The claimant ought to have examined the doctor who is the author of exhibit P3, and doctor who has been examined PW3 categorically admits that our duty doctor was given the first aid treatment for the petitioner, and he has a duty doctor only issued the wound certificate, and they said duty doctor has not been examined, and Dr. PW2 also in his evidence categorically says that the injured came to hospital in connection with road traffic accident involving the jeep in the accident, and he reiterates the history given. He reiterates the history mentioned in the exhibit P3, and in spite of it, the claimants have not examined the duty doctor and explained the history mentioned, and hence it is clear case of the vehicle different from the vehicle involved in the accident, and now the claim is made in respect of the vehicle bearing number M600, and the wound certificate discloses vehicle number of K066007, which has been removed in the original wound certificate, which was placed before the tribunal, and hence fraud and justice should not dwell together. And hence, it is a claim with an intention to make the wrongful gain, implicating of different vehicle and stating different story, and twisted the facts of the case, and made an attempt to get a compensation, and hence the claim petition filed by the claimant is liable to be dismissed. You have the discussions made up. I pass the following order. Copies put your wound certificate. Appeal filed by the insurance company is allowed. The judgment and award of the tribunal is set aside. Next, 20. Suresh M. Lathur. The amount in deposit is ordered to be refunded to the insurance company with proper identification.
My lord, I am the appellant in this case.
Or one quarter Thorsri. Kodi. Collect ಮಾಡ್ಕೊಳ್ಳಿ. 20 Suresh M. Lathur.
Yes, my lord. I am the appellant, my lord. In this case, I have filed the appeal challenging the judgment passed by the Honorable Tribunal, my lord. It was
other side idara O Maheshwar illi idalwa ilwa idara.
Both the cases have been dismissed, my lord.
Dismiss ಬರ್ಲಿ ಅವ್ರ ಹಾಗಾದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ಏನಾರು ರಿವರ್ಸ್ ಮಾಡದಾರ ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಬೇಕಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ನೋಡೋಣ, ಇವತ್ತು ಫುಲ್ ಡೇ ಇದೆ.
ಆಯ್ತು.
21 ವಿಜಯ MN. ಇದ್ರಲ್ಲೂ R2 HR ರೇಣುಕ ಇದಾರಲ್ಲ, ರೇಣುಕ ನಾಟ್ ಓ ಮಹೇಶ್ವರನ ಅವ್ರದಿಲ್ಲ. ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವ್ರದ್ದಿದೆ. ಕೃಷ್ಣಸ್ವಾಮಿ ಇದಾರ? ಅವರು ಇಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ ಅವ್ರು, ಭೂಷಣಿ ಕುಮಾರ್ ಪರ್ R1. ನಿಮ್ಗೆ ಹೇಳಿದ್ರ ಮೇಡಮ್? ರೇಣುಕಾ ಮೇಡಮ್ ನಿಮ್ಗೆ ಹೇಳಿದ್ರ?
ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಸುಮ್ಮನೆ ಹೇಳಿಲ್ಲ, ಪರವಾಗಿಲ್ಲ.
ಆಯ್ತು. R1 ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಅಂಡ್ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್. ಯಾರು ಏನಕ್ಕೆ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ?
ಅದು ಅದೇ ಅವನ್ ಬೇರೆ ಹೆಸರಲ್ಲಿ ಒಂದು ಬೈರಾ ಅನ್ನೋ ಹೆಸರಿನಲ್ಲಿ ಈಗ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗ್ತಾನೆ. ಆದ್ರೆ ರಂಗಸ್ವಾಮಿ ಅಂತ ಕೊಡ್ತಾನೆ ಎಲ್ಲಾ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ. And father's name is different in all the records, my lord. That's what your lordship heard on the last occasion, and ಅದಕ್ಕೆ LCR card.
ಯಾವತ್ ಬೇಕು ಮೇಡಮ್? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಲ್ಲ, ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ, ಬಿಫೋರ್ ವೆಕೇಶನ್.
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಆಗುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಹಾಕ್ಬಿಡಿ. ಒಂದು 15 12 ಬೆಳಗ್ಗೆಲ್ಲ ಇರುತ್ತೆ, ಬರ್ಬೇಕು.
ಆಯ್ತು.
23 A ವೆಂಕಟೇಶ್. A ವೆಂಕಟೇಶ್ ಅಂಡ್ ಹರೀಶ್ ಪೈ ಸರೋಡ್. ಚಂದ್ರಶೇಖರಯ್ಯ ನೀವಿದ್ದೀರಿ. ಅವ್ರದ್ದೇನು ಅಪೀಲ್ ಏನು? ವೆಂಕಟೇಶ್ ಇದಾರೇನ್ರಿ? ಯಾರೊಬ್ರು ಇರ್ತಾರಲ್ರಿ ಅವ್ರ ಕೊಲಿಗು? ನಿಮ್ದೊಂದು ಅಪೀಲ್ ಇದೆ, ಅವ್ರದ್ದೊಂದು ಇದೆ. ಏನ್ ಗ್ರೌಂಡ್ ಏನು ಅವ್ರಿಗೆ ಅಪೀಲ್ಗೆ? He died.
So ಏನು ಬರೋದಿಲ್ಲ.
ಕಾಸ್ ಆಫ್ ಡೆತ್ ಗುನು ಆಕ್ಸಿಡೆಂಟಲ್ ಇದಕ್ಕೂನು ನೋ ನೆಕ್ಸಸ್ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
ಇಂಜುರಿ ಕೇಸಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಇಂಜುರಿ ಬರೀ ಓನ್ಲಿ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟು ಎಲ್ಲ ಕೊಟ್ಟಿದಾರ.
ಚಾಲೆಂಜ್ ಮಾಡಿ.
ನೀವೀಗ ಡೆತ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಕೊಡಬೇಕು ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್. ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ ನೋಡೋಣ ಬಂದ್ರೆ. 24 ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ವಿಜಯ್ ಕುಮಾರ್ ಇವ್ರ ಈಗ ಶರ್ಟ್ ಹಾಕತ್ತಾರ, ಕೋಟ್ ಹಾಕತ್ತಾರ ನೋಡ್ರಿ ಅವರು.
ಒಂದು ಸೆಕೆಂಡ್ ಮೈಲ
ಪಾಸ್ ಓವರ್ ಮಾಡಿದೇನ್ ಬಿಡಿ. ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೇನೆ. ವಿಜಯ್ ಕುಮಾರ್ ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ಅವರು ಇಲ್ವಾ ಪಾಸ್ ಓವರ್? ಎಂ ಲಾತೂರ್ ಈಗಿದ್ರಲ್ಲ, ಎಲ್ಲ ಹೋದ್ರ ಅವರು? ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 25 ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್, ಬಿ ಆರ್ ರಾಮಕೃಷ್ಣ. ಹಾ 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 ಹ್ಮ್ 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 ಹಾ ಹಾ ಏನ್ ಕ್ವಾಂಟಮ್ ಇಲ್ಲ? ಹಾ ನಿಮ್ಮ ಅಪೀಲೇನು ಕ್ವಾಂಟಮ್ ಮೇಲೆ? ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್ ಅಲ್ಲಿ ಇಲ್ವಾ ಅವರು? ಅವ್ರದ್ದೇನು? ಅಲ್ಲ ಅವ್ರದ್ದೇನು ಅಂದೆ? ಅವ್ರದ್ದು ಕ್ವಾಂಟಮ್ ಇಲ್ಲ. ಅಲ್ಲ ಈ ಬೋತ್ ದಿ ಅಪೀಲ್ಸ್ ಆರ್ ಕ್ವಾಂಟಮ್ ಇಲ್ಲ. ಅಲ್ಲ ಅವರು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಕ್ವಾಂಟಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ? ಆಯ್ತು ನೋಡೋಣ, ಬರ್ತಾರಲ್ಲ. ನಾವೇ ಏನ್ ಮಾಡೋಣ ಬಿಡಿ. ಡೆತ್ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಅಲ್ಲ, ಓನ್ಲಿ ರಿವೈಸಿಂಗ್ ಆಫ್ ದಿ ಇನ್ಕಮ್. ಆಯ್ತು ಹೇಳಿ. ಹಾ ಹ್ಮ್ ಯಾರು? 57 years.
ಅಷ್ಟು ಬೇಗ 19 ಬಂದ್ಬಿಟ್ಟ.
ಮುಗ್ದೋಗ್ಬಿಡೋದು ನಿಮಿಷಕ್ಕೆ ಅಪೀಲ್ ಆಗೋ ಹೊತ್ತಿಗೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಯಾವ್ದು?
ನಾಳೆ
ಹ್ಮ್ 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 ಸರ್ಜರಿ. ಹಾ ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ? ಅಲ್ಲ ಇನ್ ಪೇಷಂಟ್ ಎಷ್ಟು ದಿವಸ ಇದ್ರು? 8 days. ಹಾ ಒಟ್ಟಿ ಟೋಟಲ್ ಇರೋದು 8 ದಿವಸ, 16 ದಿವಸ. ಟೋಟಲ್ ಇರೋದೇ 16 ದಿವಸ. ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದಿರ್ಲಿ, ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಹಾಸ್ಪಿಟಲೈಸೇಷನ್ ಎಷ್ಟು ದಿವಸ? ಆಮೇಲೆ ಒಟ್ಟಿಗೆ. ಬಟ್ ಈ ಪೀರಿಯಡ್ ಅಲ್ಲಿ 14 ಸರ್ಜರಿ ಮಾಡಿದಾರ. ಇಷ್ಟು ಟೈಮ್ ಅಲ್ಲಿ 14 ಸರ್ಜರಿ ಆಗಿದೆಯಾ ಅಂತ ಕೇಳಿದೆ. You said the 14 surgeries are conducted. 14 hours. Surgeries 14 hours. ಆಯ್ತು. ಹ್ಮ್ Hmm. Hmm. So, petitioner ನೋಡ್ತಾ ಇದ್ದೀನಿ. Was my former colleague. Injured is my former colleague. When I started my practice, he was my senior colleague, not before me. A.L. Tej Kumar. He was my former colleague. When I started my practice, he was in my senior office. But not before me. But I thought, madam, not before me. Hmm. Hmm. Let him be there. You argue. Production of additional documents. Earlier order sheet kodi madam. Every time comes and last time kuda ಇದು ಬಂದಂಗಿತ್ತು matter. ಅಲ್ವಾ? Every time you comes and seeks time. No, you argue. Learned counsel for the appellant seeks time and also undertakes to inform learned counsel for respond number 1, 2 and 3. I did that. Learned counsel for the appellant press time. This case next week. Every time comes and seeks time. At the request of the learned counsel for respond number 1 and 2, list this matter on 2 weeks.
One last occasion I believe.
Earlier also, 19/7/21. So, other side alva, BC Sitaram Rao for R3. Appellant counsel seeks time. R3 counsel is absent. This matter after winter vacation.
Right.
HN Keshav Prashant.
I appear for the appellant.
Mahesh R. Upin for R1. Quantum. ಹೇಳಿ. Quantum ಹೇಳ್ರಿ ಏನು? Keshav Prashant.
Negligence and quantum, I have questioned both the issues, my lord. Urdu, it was contended by the claimant, my lord, that he was traveling in a Tata Indica car in order to go to Manipal for the hospital, my lord. At that time, one lorry bearing number K343255 was parked due to there was some technical issues in the lorry. Accident occurred at around.
Now your appeal is only on quantum?
Negligence and quantum I have questioned both.
Negligence also.
Yes, sir. ರಾತ್ರಿ 1:20ಕ್ಕೆ ಲಾರಿ ರೋಡ್ ಸೈಡ್ ಅಲ್ಲಿ ಪಾರ್ಕ್ ಮಾಡಿದ್ರು. At that time, the driver of the insured car came from behind and dashed to the parked vehicle. So he suffered injuries. My contention is that lorry was parked the roadside without taking any precautionary measures. He is also responsible for the cause of accident. That is my first contention which I have raised. Charge sheet allagli, FIR allagli, ಅಥವಾ ಪಂಚನಾಮದಲ್ಲಾಗಲಿ ಎಲ್ಲೂ ಕೂಡ the driver of the lorry or the cleaner has taken necessary measures in order to show the wrong parking of the vehicle because of the technical issues. That was not considered by the MSCT while deciding the issue of negligence. FIR ಅಲ್ಲಿ ಲಾರಿ ಪಾರ್ಕ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಅಷ್ಟು ಬಿಟ್ಬಿಟ್ರೆ ವೆದರ್ ಡ್ರೈವರ್ ಆಫ್ ದಿ ಲಾರಿ ವಾಸ್ ಟೇಕನ್ ಆಲ್ ಪ್ರಿಕಾಷನರಿ ಮೆಜರ್ಸ್. ರಾತ್ರಿ 1:00ಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ.
crux of argument is that tribunal ought to have considered the negligence on the part of the
driver of the lorry also ಅಂತ ನಮ್ದು
lorry also. Same argument.
ಹೌದು.
ಹೌದಾ?
Also permitted to read my lord the FIR
ಕೊಡಿ.
marked as exhibit P1. ಫಿರ್ಯಾದುದಾರನ ಮಗನಾದ ಅನಿಲ್ ಕುಮಾರ್ ಎಂಬುವರಿಗೆ ಮೈಯಲ್ಲಿ ಹುಷಾರಿಲ್ಲದ್ದರಿಂದ ಅವರು ಚಿಕಿತ್ಸೆಗಾಗಿ ಮಣಿಪಾಲ್ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಐಗಳ ಬಂಕಾಪುರ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಮೇಲ್ಕಂಡ ಆರೋಪಿತನ KA53-551 ನಂಬರಿನ ಟಾಟಾ ಇಂಡಿಕಾ ಕಾರನ್ನು ಬಾಡಿಗೆ ಮಾಡಿಕೊಂಡು ಮಧ್ಯರಾತ್ರಿ ಮನೆಯಿಂದ ನಾನು ಮತ್ತು ನನ್ನ ಮಗ ಅನಿಲ್ ಕುಮಾರ್ ಹಾಗೂ ಚಾಲಕ ಶಿವಕುಮಾರ್ ಇವರ ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದ ಶಿವಯ್ಯ, ತಂದೆ ವೀರಯ್ಯ, ನಾವು 4 ಜನ ಹೊರಟು ಮಧ್ಯರಾತ್ರಿ ಸುಮಾರು 1:20 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹರಪ್ಪನಹಳ್ಳಿ ಅನಂತನಹಳ್ಳಿ ಗ್ರಾಮದ ಮಧ್ಯದಲ್ಲಿರುವ ನೀರಿನ ಟ್ಯಾಂಕ್ ಮುಂಭಾಗದ ಹರಪ್ಪನಹಳ್ಳಿ ಹರಿಹರ ರಸ್ತೆಯ ಮುಖಾಂತರವಾಗಿ ಪ್ರಯಾಣ ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿರುವಾಗ ಕಾರಿನ ಚಾಲಕ ಶಿವಕುಮಾರ್ ಅವರು ಏಕಾಏಕಿ ತನ್ನ ಕಾರನ್ನು ಅತಿ ವೇಗ ಮತ್ತು ಅಜಾಗರೂಕತೆಯನ್ನು ಚಾರ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ರಸ್ತೆಯಲ್ಲಿ ಕೆಟ್ಟು ನಿಂತಿದ್ದ K343255 ನಂಬರ್ ಲಾರಿ ಹಿಂಭಾಗಕ್ಕೆ ಡಿಕ್ಕಿಪಡಿಸಿದ್ದರಿಂದ ಆಕ್ಸಿಡೆಂಟ್ occurred. This is what the FIR, the gist of FIR. But nowhere, even in the statement,
the word is used ಕೆಟ್ಟು ನಿಂತಿದ್ದ ಅಂತ.
ಹೌದು, ಗಾಡಿ ಕೆಟ್ಟು ನಿಂತಿದೆ, ಲಾರಿ ರೋಡ್ ಸೈಡ್ ಅಲ್ಲಿ ನಿಲ್ಲಿಸಿದ್ರು. Nowhere, my lord, it was stated, even in the statement or in the FIR, my lord, nowhere it was stated that the driver of the lorry has taken precautionary measures. That too during the midnight, my lord. My driver, my lord, came from the back side and dashed to the hill portion of the lorry, which was, my lord, marked. Panchanamadallu kuda my Panchanama is marked as not exhibit P4. ಅದರಲ್ಲೂ ಕೂಡ ಎಲ್ಲೂ ಲಾರಿ ಫುಟ್ಪಾತ್ ಮೇಲೆ ನಿಂತಿತ್ತು ಅಂತಾನು ಹೇಳ್ತಿಲ್ಲ, ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಇತ್ತ. This is what the facts of the case. Panchanama is marked as exhibit P4, my lord. May I read, my lord? Exhibit P4. ಇದರಲ್ಲೂ ಕೂಡ ಫುಟ್ಪಾತ್ ಮೇಲೆ ಇತ್ತು ಅಥವಾ ಇದರಲ್ಲಿತ್ತು ಪ್ರಿಕಾಷನರಿ ಮೆಜರ್ಸ್ ತಗೊಂಡಿದ್ರು ಅಂತ ಎಲ್ಲೂ ಕೂಡ ದೇರ್ ವಾಸ್ ನೋ clinching evidence with regard to the negligence aspect. So that's why, my lord, there was a negligence on the part of the driver of the lorry also, my lord, in parking the vehicle during midnight. He should have, my lord, taken all precautionary measures in order to show them, my lord, the other vehicles that vehicle was parked due to the mechanical defect. That was not, my lord, considered by MSCT. That is my major issue, my lord.
Regard to the negligence is concerned.
That is the aspect of negligence. Sketch is not produced to, my lord, to show that what is the even Panchanamadallu kuda width of the road ಏನಿದೆ,
width of the road mention ಮಾಡಿದಾರಾ?
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲೂ ಮಾಡಿಲ್ಲ. Nowhere it was mentioned. ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ನಿಲ್ಲಿಸಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಇದು ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ, ಚೆಕ್ ಬಂದಿ ಕೊಡ್ತಾರೆ, ಬಟ್ ಎಲ್ಲಿದೆ ಏನು ಯಾವುದು ಇದು ಅಂತ ಎಲ್ಲೂ ಕೂಡ ತೋರಿಸ್ತಾರೆ. ಹರಪ್ಪನಹಳ್ಳಿ ಹರಿಹರ ಮೈನ್ ರೋಡ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಷ್ಟು ಬಿಟ್ರೆ ವಿಡ್ತ್ ಆಫ್ ದಿ ರೋಡ್ ಅನ್ನ ಎಲ್ಲೂ ಕೂಡ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ.
Next.
That is the one thing. The second aspect, my lord, as far as the quantum is concerned, but he was working as an engineer, my lord, in private limited company. Loss of future earnings is calculated at 8,44,800 is granted by the MSCT. My country,
future loss of income. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಇನ್ಕಮ್ ಏನು ತಗೊಂಡ್ರು ಅಂದೆ? 22,000 as his income.
52,000 income ತಗೊಂಡಿದ್ದಾರೆ. 20% disability consider ಮಾಡಿ 8,44,000 my lord is awarded by the MSCT on the head of loss of future income. My country
Whether he continued the job or not.
Milord, that is the main issue, Milord. He was not terminated. He was terminated by the company.
He was terminated by the company.
Yes, Milord. But not on account of the injuries suffered. Milord, he was unauthorizedly absent to the work. And subsequently, Milord, there was some document, Milord, which reflecting that subsequent to the action, Milord, he has requested the employer to give a white collar job. He may not be able to do the field work. However, Milord, that was also rejected by the company, not because of the injuries suffered. There was no document Milord, to show that he was terminated because of the injuries suffered in the alleged accident. Milord, exhibit PW5, Milord, is the employer, is examined before the tribunal. PW5 ಒಂದು ಎವಿಡೆನ್ಸ್ ಅನ್ನು ಓದ್ತೀನಿ ಸುಮ್ಮನೆ. PW5 ಪ್ರಭಾಕರ್ ಅಂತ ಒಬ್ಬನ ಕಂಪನಿ HR ಒಬ್ಬನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ ಅವರು. PW5 ಪ್ರಭಾಕರ್. ನಾನು ಚಿತ್ರದುರ್ಗದಲ್ಲಿ ಎನಿಕ್ರಾನ್ ಇಂಡಿಯಾ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಯಲ್ಲಿ HRO ಎಂದು ಸೇವೆ ಸಲ್ಲಿಸುತ್ತೇನೆ. ನಮ್ಮ ಕಂಪನಿಯಲ್ಲಿ ಅನಿಲ್ ಕುಮಾರ್ ಬಿನ್ ವೀರಣ್ಣ ಎನ್ನುವರು ಹಿರಿಯ ಇಂಜಿನಿಯರ್ ಎಂದು ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದರು. ಅವರು 2004ರಿಂದ ನಮ್ಮ ಕಂಪನಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಸದರಿ ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ಸೆಪ್ಟೆಂಬರ್ 2009ರಿಂದ ರಜೆಯ ಮೇಲೆ ಇರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಮಿಲಾಡ್ ದಿ ಫಸ್ಟ್ ಆಸ್ಪೆಕ್ಟ್. ಆಕ್ಸಿಡೆಂಟ್ ಅಕರ್ಡ್ ಮಿಲಾಡ್ ಆನ್ 1/4/2010 ಇರುತ್ತಾರೆ. ಅವರ ಈಗಿನ ವೇತನ ಪ್ರತಿ ತಿಂಗಳು 30,000 ಇರ್ತದೆ. ಅವರು ಪ್ರಾಜೆಕ್ಟ್ ಇನ್ಸ್ಟಾಲೇಷನ್ ವಿಭಾಗದಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಅವರ ಎಲ್ಲಾ ಕೆಲಸ ಬೇರೆ ಬೇರೆ ಸ್ಥಳಗಳಲ್ಲಿ ಹೋಗಿ ನಿರ್ವಹಿಸುತ್ತಿತ್ತು. ಕಚೇರಿ ಕೆಲಸ ಇರಲಿಲ್ಲ. ನಮ್ಮ ಕಂಪನಿಯ ಶಾಖೆಗಳು ಸಂಪೂರ್ಣ ಭಾರತದಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆ ಇರುತ್ತದೆ. ಸಾಕ್ಷಿ ತಮ್ಮ ಕಂಪನಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳು ನೋಡಿ ಗುರುತಿರ್ತಾರೆ. ಪಾಟೀಲ್ ಸವಾಲು JNU ವಕೀಲರಿಂದ. ಈ ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ಹಾಜರಾತಿ ಪುಸ್ತಕವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ಅವರು ಯಾವ ತಾರೀಕಿನಿಂದ ರಜೆ ಮೇಲೆ ಇರುತ್ತಾರೆ ಎಂದು ಸಾಕ್ಷ್ಯ ನುಡಿಯುತ್ತಿದ್ದೇನೆ. ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ನೀಡಿದ ವೈಯಕ್ತಿಕ ರಜೆ ಫೆಬ್ರವರಿ 28ಕ್ಕೆ ಕೊನೆಗೊಂಡಿದ್ದವು. ನಂತರ ಅವರ ಖಾತೆಯಲ್ಲಿ ರಜೆ ಇಲ್ಲದ ಕಾರಣ ಅವರ ರಜೆ ಕೇಳಿದ್ದರಿಂದ ವೇತನ ರಹಿತ ರಜೆಯನ್ನು ನವೆಂಬರ್ 2010ರವರೆಗೆ ನೀಡಲಾಗಿತ್ತು. Much earlier to the action, Milord, he was on leave. And that Milord leave was ended on February 28. Subsequently, Milord, again he was requested, since there was no Milord, the medical ground, they have extended the leave till 2010, November 2010. ವೈಯಕ್ತಿಕ ರಜೆ ಮೇಲೆ ಇದ್ದಂತಹ ದಿನಗಳ ವೇತನಗಳನ್ನು ಅನಿಲ್ ಕುಮಾರ್ ನೀಡಿರುತ್ತೇವೆ. ನಂತರ ಫೆಬ್ರವರಿ 20, 2011ರವರೆಗೆ ಅವರಿಗೆ ವೇತನ ರಹಿತ ರಜೆ ನೀಡಲಾಗಿತ್ತು. ಅದಾದ ನಂತರ ಕೂಡ ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ಕೆಲಸಕ್ಕೆ ಹಾಜರಾಗಲಿದ್ದುದರಿಂದ ನಮ್ಮ ಚಿತ್ರದುರ್ಗ ಶಾಖೆಯಿಂದ ನೋಟಿಸ್ ನೀಡಿರುವುದಿಲ್ಲ. ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಾರೆ, ಕೇಂದ್ರ ಶಾಖೆಯಿಂದ ನೋಟಿಸ್ ನೀಡಬಹುದು. ಅವರು ಅನಧಿಕೃತವಾಗಿ ಗೈರು ಹಾಜರಾಗಿದ್ದರಿಂದ ನಮ್ಮ ಶಾಖೆಯಿಂದಾಗಲಿ ಕಂಪನಿಯಿಂದಾಗಲಿ ಯಾವುದೇ ವಿಚಾರಣೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅನಿಲ್ ಕುಮಾರ್ ಹಾಜರುಪಡಿಸುವ ನಮ್ಮ ಕಂಪನಿಯ ದಾಖಲಾತಿಗಳನ್ನು ನೀಡಿದಂತಹ ಅಧಿಕಾರಿಗಳು ಇನ್ನು ಕರ್ತವ್ಯದಲ್ಲಿರುತ್ತಾರೆ. This is what the evidence of PW5. He was unauthorizedly absent. Much earlier to the action, Milord, he was on leave. That's why, Milord, he was terminated by the employer.
Yes.
And not because of the injuries suffered in the accident. That's why, Milord, I have contended that.
What are the injuries he had sustained?
Milord, he has suffered, Milord, the dislocation of hip joint. Dr. Milord is examined as Milord PW3 is the doctor.
Only dislocation of hip joint or?
Houdu, dislocation of hip joint. But the PW3 Dr. Milord is examined, the orthopedic surgeon. Maybe Milord permitted to read the cross-examination of PW3. Dr. Anil S. Relvagi ಅಂತ ಹೇಳಿ ಆರ್ಥೋಪೆಡಿಕ್ ಸರ್ಜನ್ ದಾವಣಗೆರೆ ಆಸ್ಪತ್ರೆ. PW3 ಮೇಲೆ ಕನ್ನಡದಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ. ಪಾಟಿ ಸವಾಲು ಒಂದನೇ ಪದರ ಎರಡನೇ ಪದರ ವಕೀಲ. ಸದರಿ ಅರ್ಜಿದಾರರಿಗೆ ಚಿಪ್ಪೆಯ ಮೂಳೆ ಮುರಿತವನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಮೂಳೆ ಮುರಿತವಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ P5ರಲ್ಲಿ ಕಾಣಿಸಿದ ಗಾಯಗಳು ಕೇವಲ PW3 ಮೇಲೆ
ಯಾರ ಬೇರೆ ಇದೆಯಲ್ಲ, ಯಾರು ಅನಿಲ್ ಕುಮಾರ್
ಅಲ್ಲ, ಅನಿಲ್ ಕುಮಾರ್ ಮೇಲೆ ಇಸ್ ದಿ ಕ್ಲೈಮೇಟ್. ಅನಿಲ್ ಎಸ್ ನೆಲವಗಿ ಅಂತೇಳಿ ಡಾಕ್ಟರ್.
ಅನಿಲ್ ಕುಮಾರ್ ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್. PW2 A
Veeranna Milord is the another claimant. There are two claim petitions arising out of the same accident.
Anil S. Nelavigi.
Party ಸವಾಲು ಉಂಟು. ಸದರಿ ಅರ್ಜಿದಾರರಿಗೆ ಚಿಪ್ಪೆ ಮೂಳೆ ಮುರಿತವನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಮೂಳೆ ಮುರಿತ ಆಗಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ PI ಕಾಣಿಸಿದ ಗಾಯಗಳು ಕೇವಲ ಗಾಯಗಳಾಗಿರುತ್ತವೆ ಎಂದರೆ ಸರಿ. ಅರ್ಜಿದಾರರ ಚಿಪ್ಪೆ ಮೂಳೆ ಮುರಿತ ಈಗ ಕೂಡಿಕೊಂಡಿದೆ ಎಂದರೆ ಸರಿ. ಅರ್ಜಿದಾರನ ಕೊನೆಯ ಬಾರಿ ದಿನಾಂಕ 27/5/2011 ಬಂದಿದ್ದರು. ನಂತರವೂ ಸಹ ಅನುಸರಣಾ ಚಿಕಿತ್ಸೆಗೆ ನನ್ನ ಬಳಿ ಈಗಲೂ ಸಹ ಬಂದಿರುತ್ತಾರೆ. ನಾನು ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುವ 20% ಅಂಗನ್ಯೂನತೆ ಅರ್ಜಿದಾರನ ಚಿಪ್ಪೆಗೆ ಮಾತ್ರ ಸಂಬಂಧಪಟ್ಟಿರುತ್ತದೆ. ಸದರಿ ಅಂಗನ್ಯೂನತೆಯನ್ನು ಇಡೀ ದೇಹಕ್ಕೆ ಹೋಲಿಸಿದರೆ ಕಡಿಮೆ ಆಗುವ ಸಾಧ್ಯತೆ ಕಂಡು ಬರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿ. He has assessed the disability particularly. Tribunal has considered 20% disability as a whole body disability. And this Dr. has not given any calculation how he has arrived to that figure. So the disability considered at 20% to the whole body is erroneous. When doctor said that ನಾನು ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುವ 20% ಅಂಗನ್ಯೂನತೆ ಅರ್ಜಿದಾರನ ಚಿಪ್ಪೆಗೆ ಮಾತ್ರ ಸಂಬಂಧಪಟ್ಟಿರುತ್ತದೆ ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ತಾರೆ. So this is the other aspect where the compensation granted and future of earnings is highly excessive. And he was not terminated from the job because of the injury suffered. Subsequent to this, all this evidence and all, he has requested the employer to give a white collar job also. Because of
where is the document to that effect?
They have produced it. This is the second round of litigation. Subsequently, exhibit P205 in the produce master. Exhibit 206 206. ಹೌದು 206. ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬಂದು ಮತ್ತೆ ರಿಮ್ಯಾಂಡ್ ಆಗ್ಬಿಟ್ಟು ಸೆಕೆಂಡ್ ರೌಂಡ್ ಆಫ್ ಲಿಟಿಗೇಷನ್. Subsequently, this document produced.
206. Clarification required for amount credited to the account as full and final settlement antane exhibit P6.
ಅದರಲ್ಲಿ
several times in the past to give me an opportunity to serve in the company in office, sir, but you have not considered my request.
So these are the request letters and other documents which is produced. Voluntary abandonment from service ಇದು ಎಲ್ಲವನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. That indicates that he was capable to continue the work. As on today, I don't know whether he's joined some other company or not. There is no document for that. But this is the document issued on 2011 and 12. 2011 ಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತಾರೆ, 26/1/2012 ಒಂದು ಕೊಡ್ತಾರೆ, 23/2/2012 ಒಂದು ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. And after there one more this thing, they have produced the bank statement as well as the salary slips produced by the claimant. The bank statement is only till 9/6/2011. 9/6/2011. Subsequent to that, there is no document to show that whether he was has received the salary, whether he was continuing in the service, or whether the employer has taken him back for the document illa. After 2012, because 2012 he has requested the employer for the white collar job. So 9/6/2011, the bank statement is produced and marked as exhibit P69. 9/6/2011 is the last transaction. Exhibit P69 prakara. So even there is no pay slip, there is no bank, there is no transaction in the bank statement. There was a variations in the pay slips. 13,198 ಒಂದ್ ಕಡೆ ತೋರಿಸ್ತಾರೆ, ಒಂದ್ ಕಡೆ 20,687 ಅಂತ ತೋರಿಸ್ತಾರೆ, ಇನ್ನೊಂದ್ ಕಡೆ 20,857 ಅಂತ ತೋರಿಸ್ತಾರೆ. On 3/4/2010, which was the last drawn salary as per the bank statement. 3/4/2010 15,035 was credited to his account as a salary.
Salary slip ಹಾಕಿಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಇಲ್ಲಿ ತನಕ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ. ಅಂದ್ರೆ 2000 last pay slip which is produced is
previous month. What is his salary?
2000 September 2009 was the last pay slip.
ಅದೇ ಎಷ್ಟಿದೆ ಅವಾಗ salary?
ಅವತ್ತಿನ ದಿವಸ ಗ್ರಾಸ್ ಸ್ಯಾಲರಿ ಮೇಲೆ is 24,348 and net salary was 22,698 and professional tax and income tax is also deducted.
22,368.
So this is the September 2009 payslip. Subsequent to that, till 1/4/2010, there was no payslip. This is the last payslip produced. As per the bank statement, on 1/4/3/4/2010, that is the date of month of accident, he has received 15,035 as a salary. Exhibit P69.
3/4/2009 is the bank statement.
Bank statement. ಅದರ ಪ್ರಕಾರ 1/4/2010ಕ್ಕೆ ಈಗ ಸ್ಯಾಲರಿ ಕ್ರೆಡಿಟ್ ಆಗುತ್ತೆ ಎನ್ಆರ್ಆನ್ ಇಂಡಿಯಾ ಲಿಮಿಟೆಡ್ ಇಂದ. ದಟ್ ಈಸ್ 15,035 was the salary.
Yes. Yes, counsel.
As negligence is concerned, this is second round of appeal. The before the tribunal, insurance company or the owner not take any evidence disputing the negligence. Police investigation filed charge sheet that was not valid and it has become final. And having not laid any evidence before the tribunal questioning the negligence, they are not entitled to argue this matter for the first time before the court. So far, in the first round of appeal, which was before this honorable court, this question of negligence was not raised at all. You will ask me.
First appeal illa.
First appeal illa.
Why it was remanded?
But it was remanded that in quantum.
Only quantum.
Yeah, quantum.
Where is that order, earlier order?
Yes, but
Copy idre kodi. ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ?
Case number is 6755 of 2012.
ಏನಾರ ಇದೆಯಾ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ? ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಹೋಗಿರುತ್ತಲ್ಲ ಕಾಪಿ.
ಅಲ್ಲ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸುಮ್ಮನೆ.
ಹೈಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಇದರಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ. ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ರಿಮೈಂಡ್ ಮಾಡುವಾಗ ವಾಟ್ ಇಸ್ ದಿ ಅಬ್ಸರ್ವೇಷನ್?
This is what
earlier quantum who asked question?
Ibru question. Both have
both claimant as well as insurance company.
Yes.
This is what para 6 of the order.
ಹೇಳಿ ಏನು ರೀಸನ್ ಇದೆಯಾ ಓದು.
Whereas it is the case of the insurer that much prior to the occurrence of accident, claimant was suffering from spinal cord problem and that while on his way to go to hospital to take treatment for that problem, he met with an accident and sustained injuries. That this aspect of the matter is seriously disputed by the learned counsel appearing for the claimant. Therefore, learned counsel appearing for both parties after going through the original records available on file and after rival arguments submitted that the matter requires reconsideration afresh by the tribunal, having regard to this is important: the age, avocation, nature of injury sustained, nature of duration of treatment undergone, and also the fact as to whether the claimant has lost job on account of spinal cord problem or on account of injury sustained by him in the road traffic accident. The said aspect has to be decided by the tribunal only after proper appreciation of additional oral and documented evidence to be adduced by both parties. Therefore, learned counsel appearing for both parties submitted that appeals filed by both the parties be allowed and the impugned judgment and award passed by tribunal be set aside and the matter be remanded back to the tribunal for reconsideration of trial after appreciating additional oral and documented evidence be adduced by both parties. All the counts.
ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಏನಾರ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದಿರಾ?
Lord, after remand, Lord, so far as the quantum is concerned, Lord, I have read additional evidence, not oral evidence. That is not. Was recorded on 13/11/2015.
ಯಾರು ನಿಮ್ದೇನಾ?
Namaste evidence.
ಅದೇ ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್.
I state that after the accident, because of traverse fracture to posterior acetabular pillar resulting posterior dislocation of my right hip joint, I requested my employer to provide white collar office job at the head office. Stop here. The company in which I was working, Lord, is Enercon company not which is carrying on business of this wind energy. I was a mechanical engineer not who was required to not climb the hills and install or repair not the wind fans not installed at the top of the hills. For this not because of this injury not I am not able to climb the hills not and go up to the top of the wind fan not to repair the wind fans. This is the difficulty I was facing. Therefore, I requested my employer provide me at least alternative job. I continue. Enercon India Limited office, Mumbai, or in the original office, regional office, Ganesha Towers near Ishwarya Fort on 27/4/2011, 4/4/2011, 26/1/2012, 23/2/2012. To a written request letter by registered court with acknowledgement. The head office Mumbai and regional office Chitradurga had acknowledged the application letters from me. So also I had sent electronic mails on 6/6/2011 and on 22/9/2011. Requested my employer to provide office work. The HRD head office Mumbai on 22/9/2011 replied the said electronic mail by saying that
He was terminated only in 2013. Thereafter, I came to know that I was terminated from the company on 16/4/2013. 16/5/2013, I once again wrote a requisition letter to the company by questioning the action taken by the so-and-so. Yes.
It is my space. Therefore, it is the nature of work which I was carrying, climbing the hills and repair the wind fans. Now, because of this injury, I am not, though the doctor's assessment of disability is only 20%, but I am not able to discharge my duties as a mechanical engineer, not in which I was working at the time of the accident. Therefore, Malati lay upon one thing.
Justice Ravindran Aurdu. Justice Ravindran Aurdu with regard to the injury cases.
Yes, Malati.
I read that judgment. All right. Next. That is the only main judgment. Regard to the
has to be assessed.
injury is concerned.
Yes, Malati. Disability has to be assessed having regard to the nature of work which I was doing. In this case, tribunal has not assessed only 20% disability as per the doctor's evidence, not with relation to the nature of work which I was doing. Though the tribunal has taken the fact that I was terminated from service, tribunal observes that it is for me to question it before some other court. Not that is not the
after remand, except further examination of your client.
Yes.
Any other evidence is produced?
Not
after the remand.
No, Malad, there is no other evidence on that.
Other evidence except this evidence.
PW one ಮಾತ್ರ ಇದು ಮಾಡಿ ಲೆಟರ್ಸ್ ಇದನ್ನೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ನೀವೇನಾರು ಮಾಡಿದ್ದೀರಾ?
We have not read any evidence.
Not read any evidence.
We have not read any evidence. Right. But only one thing, Malad, if my learned senior counsel Malad has completed, then
ಆಯ್ತಲ್ಲ ನಿಮ್ದು ಆಗಿದೆಯಾ?
My submission is that Malad, having regard to the nature of what he was doing, disability has to be assessed, but not on the basis of the evidence of the doctor. Since I was terminated.
Like in disability, ನಿಮ್ ಪ್ರಕಾರ ಇನ್ನು ಜಾಸ್ತಿ ತಗೋಬೇಕು. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್.
20% ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಷ್ಟೇ ಹೇಳಿದ್ರೆ
ಅವ್ರು ಓನ್ಲಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಲಿಂಬಿಗೆ ಹೇಳಿದ್ದಾರೆ. This is only a dislocation of hip joint, that's all.
He cannot, his disability, he cannot climb the hills. And even doctor was
cross-examined. Refer the matter to the ಬಾಡಿಗೆ.
Doctor was in fact cross-examined regarding this. He said there cannot be any improvement. This
medical board concern. Medical board no rest assess ಮಾಡ್ತಾರೆ ಅದರ ಮೇಲೆ ಕೊಡಲ್ಲ compensation. Because both are claiming enhanced according to them it is on higher side.
Yes.
According to you it is lower side. We'll refer the matter to the medical board and we'll get the assessment whether is capable or not.
But having regard to now
ಯಾಕೆಂದ್ರೆ ನಮ್ಮ ಮುಂದೆ ಏನಿಲ್ಲ ಈಗ after this accident whether he is working or not.
ಇಲ್ಲ, he is not working. He is terminated from service.
ಆಯ್ತು, ಆಮೇಲೆ ಬೇರೆ ಕಡೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ.
ಬೇರೆ ಕಡೆ ಎಲ್ಲೂ ಇಲ್ಲ.
ಇಲ್ವಾ?
ಇಲ್ಲ.
ಏನು
I leave it to the court. So press, accident is 2010, not, maybe your lordship may kindly take it reasonable disability. So press salary is concerned, not 22,000 is taken, not little higher. Little higher.
As on the date of the accident, he was getting salary of rupees 24,000.
Difference ಇದೆ. ಒಂದೊಂದು salary slip ಅಲ್ಲಿ ಒಂದೊಂದು ಇದೆ. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಎಂಪ್ಲಾಯರ್
It depends upon field work ಇದ್ರೆ ಜಾಸ್ತಿ ಕೊಡ್ತಾರೆ ಬೇಸಿಕ್ ಏನು ಒಂದು ಸ್ಯಾಲರಿ ನಲ್ಲಿ ಅರ್ಲಿಯರ್ ಬೇಸಿಕ್ ಏನು ಫೀಲ್ಡ್ ವರ್ಕ್ ಏನಾಗ್ತದೆ ಜಾಸ್ತಿ ಫೀಲ್ಡ್ ವರ್ಕ್ ಹೋದ್ರೆ ಅವಾಗ ಇಟ್ ಡಿಪೆಂಡ್ಸ್ ಅಪಾನ್ ಕನ್ವೆನ್ಸ್ 22,368 ತಗೊಂಡಿದ್ದಾರೆ ಇಲ್ವಾ ಹೇಳ್ರಿ ರಿಪ್ಲೈ
ಏನಿಲ್ಲ ಒಂದೇ ಒಂದು
ತುಂಬಾ ಕಡಿಮೆ ಇದೆ.
ಬೇರೆ ಹೆಸರು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ
$30,000 is granted on parents.
lip abrasion wound or left, tenderness or left free. 30,000 pain and suffering. ಎಷ್ಟು ಸೇರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ 15 days sir.
ಅಲ್ಲ 15 days.
Loss of amenities and discomfort in life 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Medical expenses 1,87,000. Attendance charges and other incident charges 20,000. Laid up period income ಕೊಡ್ಲೇ ಅಲ್ವಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಹೇಳಿ ರಿಪ್ಲೈ ಅಂದ್ರೆ ಹೇಳಿ.
Reply ಇನ್ನೇನಿಲ್ಲ. Even on the first round of litigation, my lord, I have raised the issue of negligence in my appeal memo. But while remanding the matter, my lord, all the defenses are open ಅಂತ ಹೇಳಿ ರಿಮೈಂಡ್ ಮಾಡಿದ್ದಾರೆ. So that cannot be taken as a, my lord, the yardstick, because even first round of litigation, my lord, my main issue was that
with regard to the negligence
aspect.
Copy of the appeal memo ಇದೆಯಾ?
ಈ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇರಬಹುದು ಸ್ವಾಮಿ, ಬಟ್ ಅದರ್ವೈಸ್
earlier order ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಬರ್ದಿಲ್ಲ.
ಅಲ್ಲ ಬರ್ದಿಲ್ಲ, ಬಟ್ ಅದನ್ನ ತಗೋಬಾರ್ದು ಇವಾಗ ಅಂತ ನಮ್ಮನ್ನ ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲೂ ನಾನು ದಟ್ ಇಸ್ ಎ ಮೇನ್ ಇಂಟೆನ್ಷನ್. ದೆನ್
ಫಸ್ಟ್ ಟೈಮ್ ಅಪೀಲ್ ಕಾಪಿ ಅಪೀಲ್ ಮೆಮೊ ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ ನನ್ನ ಹತ್ರ
ಕೊಡಿ.
I have that. I will furnish.
ಅದನ್ನ ಕೊಡಿ. We will start at dictation at 2:30. ನೀವು ಒಂದು ಕಾಪಿ ಕೊಡಿ. 2:30 ಕೊಡಿ. ಕಾಪಿ ಕೊಡ್ರಿ ಸಾಕು, ಇನ್ನೇನ್ ಬೇಡ. ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆಯಲ್ಲ?
ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
I will dictate the order.
Please.
ಅವ್ರ ಪ್ರಕಾರ ಆ ಗ್ರೌಂಡ್ ಅರ್ಜ್ ಮಾಡಿಲ್ಲ ಅಂತ, ನಿಮ್ ಪ್ರಕಾರ ಆ ಗ್ರೌಂಡ್ ಅರ್ಜ್ ಮಾಡಿದ್ದೀವಿ. We want to see the appeal memo of first appeal. Our okay, no order in the division bench while remanding.
I will furnish it, my lord.
Remanding ಕೊಡಿ, ಮಧ್ಯಾಹ್ನ ಕೊಡಿ.
Even not if he raises it, not argues, not it about not pressing that ground.
ಅಲ್ಲ, the ground ನೀವೇನ್ ಹೇಳಿದ್ರಿ, ಅವ್ರ ಏನೋ ಆ ಗ್ರೌಂಡೇ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಈಗ ಹೇಳಿದ್ರಿ. ಅವ್ರನ್ನ ನಾನು ಅರ್ಜ್ ಮಾಡಿದ್ದೀನಿ.
At the time of argument, that ground was not raised.
That is a different thing. That is a totally different.
ಆಯ್ತು ನೋಡೋಣ. ಅವ್ರಿಗೆ ಬೇರೆ ಇತ್ತು ಅಂತ, ಸ್ಪಾಂಡಲೈಸಿಸ್ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು ಅಂತ, ಅದಕ್ಕೆ ಅವ್ರೇನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ನಾನು ಅದಕ್ಕೆ ಕೇಳಿದ್ದು, ಆಫ್ಟರ್ ರಿಮೈಂಡ್ ಏನಾದ್ರು ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರ? ಇಲ್ಲ.
Appeal memo. At the time of argument, not process that blood, it amounts to not even go by.
ಆಯ್ತು, ಕನ್ಸಿಡರ್ ಮಾಡಿ. ನಿಮ್ಮ ಹತ್ರ ಅಪೀಲ್ ಕಾಪಿ ಇದ್ರೆ ಅಪೀಲ್ ಕಾಪಿ ಕೊಡಿ.
ಈ ಅಪೀಲ್ ನಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 7, 8, 9, 10 ಏನ್ ಈ ಅಪೀಲ್ ನಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 7, 8, 9, 10 ಏನ್ ತಗೊಂಡಿದ್ರು ಸೇಮ್ ಮಲಾಡ್ ಅರ್ಜಿಡ್ ಇನ್ ದ ಫಸ್ಟ್ ಅಪೀಲ್ ಮೆಮೊ ಆಲ್ಸೋ.
ಅದೇ ಗ್ರೌಂಡ್,
ಅದೇ ಸೇಮ್ ಗ್ರೌಂಡ್ಸ್. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಚೇಂಜ್ ಮಾಡಿಲ್ಲ ನಾನು ಆಕ್ಚುಲಿ. ಅದು
ಡಿಕ್ಟೇಟೆಡ್ 2:30.
ಪ್ಲೀಸ್.
ಕೈಂಡ್ಸ್ ಪರ್ಮಿಷನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಮಿಲಿಯನ್
40 ಹೇಳಿ ಮೇಡಮ್.
ಅದ್ರಲ್ಲಿ ಅವರು ಕಾಪಿ ಕೊಡ್ಬೇಕಿತ್ತು ನಂಗೆ.
ಚಂದ್ರಶೇಖರ್ ಎಲ್ ಇದಾರೇನ್ರಿ? ಚಂದ್ರಶೇಖರ್ ಎಲ್
ಮಧ್ಯಾಹ್ನ ನಂಗೆ ಸ್ವಲ್ಪ ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ.
ಇಲ್ವಲ್ಲ ಅವ್ರೀಗ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಹ್ಯಾವಿಂಗ್ ನಾಟ್ ಫರ್ನಿಶ್ಡ್ ಅಂತ ಇದೆ, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್. ಆಯ್ತು, ನಿಮ್ಗೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಬಟ್ ಅವ್ರು ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ ನೋಡ್.
ಆಯ್ತು.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ 70 ಹೇಳಿ. ಅವೈಟಿಂಗ್ TCR ಅಂತ ಇದೆ. ಕೈಲಾಶ್ ಶಂಕರ್ ಯಾರು ಇದಾರಾ? ಅವ್ರು ಇದಾರಾ? ಅವೈಟಿಂಗ್ TCR ಅಂತ ಇದೆಯಲ್ಲ, ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಮೇಡಮ್. ನೋಡಿ ಆಯ್ತು, ಮತ್ತೆ ನೋಡೋಣ. ಇಲ್ಲ ಅಂದ್ರೆ ವೆರಿಫೈ ಮಾಡಿ, ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. ಆಫ್ಟರ್ ಮಧ್ಯಾಹ್ನ ನೀವು ಇಲ್ಲ ಮೇಡಮ್, ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಅದೇ ಹೇಳಿದ್ ನಾನು. ಹೇಳಿ. ಅದ್ರಲ್ಲ PF ಕೊಡ್ಬೇಕು. ಯಾರು? ಮೇಡಮ್ ನೀವೇ PF ಕೊಡ್ಬೇಕಲ್ರಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು R3 ಫಾರ್ 3rd ಟೈಮ್ ಅಂತ ಇದೆ. ಅದ್ ಮೆಮೊ ಹಾಕ್ಬೇಕು ನೀವು. ಆಗ ಹಾಕ್ಬಿಡಿ, ಮೆಮೊ ಹಾಕ್ಬಿಡಿ. ಮೆಮೊ ಹಾಕಿ, ಮೆಮೊ ಹಾಕಿ. 30 ಏನಾಗ್ಬೇಕು? ಶಂಕರ್ ರೆಡ್ಡಿ ಅಂಡ್ ವಿಷ್ಣುಮೂರ್ತಿ ಮಯ್ಯ ಅದರ್ ಸೈಡ್ ಇದಾರಾ? ಮತ್ತೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? ಬರ್ತಾ ಇಲ್ವಾ? ಇಲ್ಲೇನಿದೆ ಸರ್ವ್ಡ್ ಅಷ್ಟೇನಾ? ಆಯ್ತು. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಆಗೋಯ್ತಲ್ಲ ಬೆಳಗ್ಗೆ ಎಲ್ಲ. DNP ಆಗೋಗಿದೆ. ಅಲ್ಲ ರೀ, ನೀವು ಲಾಯರ್ ಬರೋದಿಲ್ಲ, ಪಾರ್ಟಿ ಕೊಟ್ರೆ ನೋಟಿಸ್ ಪಾರ್ಟಿನೂ ಬರೋದಿಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಇಟ್ ವಾಸ್ ಸರ್ವ್ಡ್ ಇನ್ ದ ಮಂತ್ ಆಫ್ April 22. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ, ನೋಡು ವಿಕಾಲ್ ಮಾಡಿ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ. ಯಾಕೆ? ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಟು ದಿ ಅಪಲೆಂಟ್ ಅಂಡ್ ಸರಾ ರಿಟರ್ನ್ಡ್. ಅವನಿಗೆ ಸಫಿಶಿಯಂಟ್ ಆಗಿ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಅವನ ಸಿಗ್ನೇಚರ್ ಇದೆ, ನೋಡಿದೆ ನಾನು. ಸಿಗ್ನೇಚರ್ ನೋಡಿದ್ಮೇಲೆ ವಿ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ದಿ ರಿಪೋರ್ಟ್ ಫ್ರಮ್ ದಿ ಇದೇನು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಸರ್ವ್ಡ್ ಅಂತ. ಆಯ್ತ್ರಿ, ನೀವು ಶ್ರೀನಿವಾಸ್ ಬಾಬು ಅಂತ ಹೆಸರೇನೆ ಇದೆಯಲ್ಲ, ಬರ್ಬೇಕಲ್ಲ. ಮತ್ ನಾವೇನ್ ಮಾಡಕ್ಕ? ಅಡ್ವೊಕೇಟ್ ಹೂ ಇಸ್ ಆನ್ ರೆಕಾರ್ಡ್. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ವಿ ನೀಡ್ ನಾಟ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದಿ ಅಪಲೆಂಟ್. ಎಲ್ಲ ಕೇಸಲ್ಲೂ ನಾವು ನೋಟಿಸ್ ಮಾಡ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ ಕೆಲಸ ಇಲ್ವಾ? ಮಾಡಿರೋದೇ ತಪ್ಪು ನನ್ನ ಪ್ರಕಾರ. MFA ಬರ್ಲಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಮಾಡು ಅಷ್ಟೇ. ಮತ್ತೆ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಇದ್ಮೇಲೆ ಮತ್ತೆ ಅಪಲೆಂಟ್ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ಮತ್ತೆ ನೀವು ನೋಟಿಸ್ ಕೊಟ್ರೂ ಬರಲ್ಲ. ನಿಮ್ ಕ್ಲೈಂಟ್ ಟೇಕನ್ ದಿ ನೋಟಿಸ್ ಇನ್ ದ ಮಂತ್ ಆಫ್ April ಇಟ್ ಸೆಲ್ಫ್. ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ಎಲ್ಲಿದೆ ನೋಡಿ ನಾಡು ಶೀಟ್. ಅಪಿಯರ್ ಆಗಿದ್ರೆ ನಾನು ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ? ನಾನು ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಬರ್ತಿದ್ದೀನಿ. ನೋಡೋಣ ಫಸ್ಟ್. ನೋಡ್ರಿ ಮೇಡಮ್, ರೆಕಾರ್ಡ್ ತರಿಸಿ ಅದು ನೋಡಿ ಫಸ್ಟ್. ಯು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್, ದೆನ್ ವಿಲ್ ಸಿ. ಅಷ್ಟೇನಾ? ಇದರಲ್ಲಿ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಮೋಸ್ಟ್ಲಿ ರರ್ಜ್ ಮಾಡಿರ್ತಾರೆ. ಏನ್ರಿ, 2 ಕ್ಲೈಮ್ ಮೇಲೆ ಇನ್ನೊಂದು ಕ್ಲೈಮ್ ಮೇಲೆ ನೆಗ್ಲಿಜೆನ್ಸ್ಗೆ ನೀವು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಪೇಮೆಂಟ್ ಮಾಡಿದಿರಂತ ಕೇಶವ ಪ್ರಸಾದ್. Now how you can raise the ground of
yes my lord, I have forgotten it. Correct.
Now how you can raise the ground of negligence? Alwa?
I am sorry my lord, I am sorry.
You cannot blow hot and cold.
True my lord, I agree with that.
Once you have admitted the liability and made the payment.
ಇಲ್ಲ ಸ್ವಲ್ಪ ಮರ್ತೋಗ್ಬಿಡ್ತು. Otherwise I would have not urged my lord. I am sorry my lord.
Other side ನೆನ್ಸಿದ್ದಾರೆ ಈಗ.
I am sorry my lord, I am sorry.
Serial number 32 ಏನು ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ.
What up, sir? What up, sir? What up, sir?
ಹೇಳಿ ಸರ್.
What up, sir?
ಹೇಳಿ.
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಮೇಡಮ್?
ಅದೇ ಇವತ್ತು
ಇದೆಯಾ?
ಇದೆ.
ಹಾ, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ನಂಬರ್ 32 ಏನ್ ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಆಗ್ಲ.
ಆಶ್ಚರ್ಯ, ಒಂದ್ ಮಾತು ಆಗ್ಲಿಲ್ಲ ಇಬ್ರು ಇನ್ ಕೇಸ್
ಏನಾಯ್ತ್ರಿ ಕಾಂಪ್ರಮೈಸ್ ಎಲ್ಲ ಬರ್ಕೊಟ್ರೇನ್ರಿ? ಏನೋ ಬರ್ಕೊಡ್ತೀವಿ ಆಸ್ತಿ ಎಲ್ಲ ಹೊಡೆದಿದ್ದೆಲ್ಲ ವಾಪಸ್ ಅಂದ್ರಲ್ಲ, ಏನಾಯ್ತು ಬರ್ಕೊಟ್ರ ಅಂದೆ? ಹಾ ಸಿಕ್ಕಿಲ್ವಾ? ನೋಡಿ, ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಅಬ್ಸೆಂಟ್. ಆಯ್ತು, ನಿಧಾನ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊ ಬರ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೊಂಡು. ಆಯ್ತು, ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ 72 ಅರ್ಜೆಂಟ್. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದಾಗ ತಗೊಳ್ಳೋದು ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲ ಪದ್ಧತಿ. ಈಗಿದ್ರೆ ಕೇಳ್ತೀನಿ, ಕ್ಲಿಯರ್ ಮಾಡ್ತೀನಿ. ಇವತ್ತಿಲ್ಲ, ನನಗೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ನಿಮ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದ್ ಟೈಮಲ್ಲಿ ತಗೊಳ್ಳೋ ಪದ್ಧತಿ ನನ್ನ ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲ. ಆಯ್ತಾ? ಈ ಮೇ ಬಿ ಎ ಸೀನಿಯರ್ ಟು ಯು, ನಾಟ್ ಟು ದಿ ಕೋರ್ಟ್. ಯಾವತ್ ಬೇಕು ಹೇಳಿ? 3:30 ನಾನು ಕೊಡೋದಿಲ್ರಿ ಟೈಮು. ಆಮೇಲೆ ರೀಚ್ ಆಗ್ದವ್ರು ಏನ್ ಮಾಡ್ತೀರಿ? ಮತ್ತೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ರು. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮಸ್ಟ್ ಬಿ ದೇರ್ ಇನ್ ದಿ ಕೋರ್ಟ್. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗೆ ಏನ್ ಸಪರೇಟ್ ಕೋಡ್ ಇರಲ್ಲ. ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾರಿಗೂ ಕೋಡ್ ಇರಲ್ಲ. ಆಯ್ತಾ? ನೋ ಕೌನ್ಸಿಲ್. ಯಾವತ್ ಬೇಕು ಹೇಳಿ? ನಿಮ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗೆ ಟೈಮ್ ಆದಾಗ ಯಾವತ್ ಬೇಕು ಕೊಡೋಣ, ಡೇಟ್ ಹೇಳಿ. ಯಾವತ್ ಬೇಕು ಹೇಳಿ? ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ? ನಾಳೆ ಆಗೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನೋಡೋಣ. ಯಾವತ್ ಬೇಕು ಹೇಳಿ? ಹ್ಮ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ನೋಡಿ. ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನೆಕ್ಸ್ಟ್ ಅರುಣ್ ಕುಮಾರ್ YH. ಇವಾಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ದಂಧೆ ಮಾಡಕ್ ಹೊರಟಾರಲ್ಲ. ಮತ್ತೆ ಯಾರು ಇಲ್ವಾ? Petitioner counsel is absent. List this matter after winter vacation.
Serial number, my lord?
74.
75.
75 now. Vishnumurthy. ಹೇಳ್ರಿ ವಿಷ್ಣುಮೂರ್ತಿ ಅವ್ರು ಏನ್ ಹೇಳಿ.
Petition successive bail application, Your Lordship. The petition is the effective number 2.
A2 na?
A2, sir. Earlier, Your Lordship rejected the bail application on May 2022.
ಇದೆ ನನ್ನ ಹತ್ರ. I am having copy. Based on merits ಏನು?
Merits, Your Lordship, that on the date of the incident, he was pushed in the incident to face in their house, Your Lordship. The deceased, along with his friends, that's 2 and 3 eyewitness and other persons, 5 persons, came to the house of the accused number 1 to recovery of the money of 18 lakhs, which was transacted with the accused number 1 and Jivan Prakash, 07 years old.
Facts ಬೇಡ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಿದ್ವಾ ಇಲ್ಲ ಅರ್ಲಿಯರ್? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಿದ್ವಾ ಇಲ್ಲ ಅರ್ಲಿಯರ್? ಮಾಡಿದೀವಿ. ವಾಟ್ ಇಸ್ ದಿ ಚೇಂಜ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್?
And the accused number 3 is already enlarged on bail by the trial court, Your Lordship.
A1 and 3 are enlarged on bail.
One assaulted, one allegation against accused number 1 who is stabbed the injury, one injury, Your Lordship. Yet petition was the allegation, Your Lordship, that he was pushed and the court did it, Your Lordship. Except there is no allegation.
Pushed and handled, that means he felicitated the other accused to inflict the injury.
Accused number 1. Now the accused number 1 is Your Lordship. Since 1 year he is custody, Your Lordship. Charge sheet is already filed, Your Lordship.
302 na?
302.
302 1 year jail ಇರೋದು not a ground. Accused number 1 ಏನ್ ರೀಸನ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? Page 117. This is went along with the Prakash to the house of petitioner to collect the money from the petitioner on 27/11/2021 at 6 p.m. During the discussion, quarrel took place between the accused and deceased parties, and they scuffled with each other. And at that time, the accused number 1 stabbed the deceased with knife on the chest of the deceased with one single injury, which resulted in death of deceased. Postmortem report reveals that death was due to stab injury. The learned counsel for the petitioner submits that there is no premeditation or intention to commit the murder of the deceased. The deceased and others came to the house of the petitioner and picked up quarrel, and during the quarrel, the petitioner, due to anger and sudden provocation, took the knife and stabbed the deceased, which resulted in death. The incident took place at the time of spur of moment. The contention of the learned counsel for the petitioner is acceptable as the deceased and others went to the house of the accused, where the quarrel took place, and there is only one stab injury which resulted in death of the deceased. Accused number 3 is already released on bail. At this stage, it cannot be said that the petitioner within intention and motive had prepared to commit the murder, which caused to the death, and it happened to the spur of the moment and provoked by deceased, who is said to be a rowdy shooter. Alari, ಒಬ್ಬನ್ ಬೇರೆಯವನ್ ಮನೆಗೆ ಹೋಗಿ along with weapon. ಅದೇ ದುಡ್ಡು ಕಲೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ಅಂತ ಹೋಗಿರ್ತಾರ. ವೆಂಟ್ ವಿತ್ ವೆಪನ್ ಹೌದಲ್ಲ? ವೆಂಟ್ ವಿತ್ ವೆಪನ್ ಹೌದಲ್ಲ?
ಅಲ್ಲ, ಡಿಸೀಸ್ ನಮ್ಮ ಮನೆಗೆ ಬಂದ್ಬಿಟ್ಟು ದುಡ್ಡು ರಿಕವರಿಗೋಸ್ಕರ
ದುಡ್ಡು ವಸೂಲಿ ಮಾಡಕ್ ಬಂದ. ಆಗ ವೆಪನ್ ತಗೊಂಡ್ ಹೊಡೆದ್ರು. ವೆಪನ್ ಎಲ್ಲಿ ತಲೆ ತಗೊಂಡ್ ಹೊಡೆದ್ರ ಅಥವಾ ಹೆಂಗೆ?
ಅಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಇದ್ದದ್ದೇ ಹೊಡೆದ್ರು.
ಮನೆಯಲ್ಲಿ
ಬಂದು ಅಟ್ಯಾಕ್ ಮಾಡಿದ್ರು.
ಜಾಗದಲ್ಲಿ ಇತ್ತೇನ್ರಿ ಸ್ಪಾಟ್ ಅಲ್ಲಿ? ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಲೈಫ್ ಇತ್ತ?
ಮನೆ ಒಳಗಡೆ ಇದ್ದದಂತ ಹೇಳ್ತಾರೆ.
ಮನೆ ಒಳಗೆ ಹೋಗಿ ಇದ್ದದ್ದು ಹೋಗಿ ತಗೊಂಡ್ ಬಂದು ಹೊಡೆದಿರೋ ಹಾಕಿರುತ್ತಾನೆ ಅದು. How it will be a spur of the moment? Premeditation?
Your Lordship, the 5% are attracted to the accused number 1, Your Lordship. Our money is started over there. He is not went to the that model is a premeditation, Your Lordship. Preparation for committing a murder. When
ಈಗೇನ ನಮ್ ಜೊತೆಗೆ ನೀವು ಗಲಾಟೆ ಮಾಡ್ಬಿಡ್ತೀರಪ್ಪ, ಇಲ್ಲೇನೋ ಒಂದು ಇದಿರುತ್ತೆ, ಅದನ್ನ ತಗೊಂಡು ಓಡಿದ್ರೆ ಅದು ಸ್ಪರ್ ಆಫ್ ದಿ ಮೂಮೆಂಟ್ ಆಗ್ತದೆ ಅಲ್ವಾ? ಹೇಗಾಗಿರೋದು? ನೈಫ್ ಎಲ್ಲಿತ್ತು? ಮನೆಯಲ್ಲಿ ಇಟ್ಟಿದ್ದು, ಆ ಜಾಗದಲ್ಲಿ ಇತ್ತ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಸ್ಪಾಟ್ ನೈಫು ಸ್ಪಾಟ್ ಅಲ್ಲಿ ನೈಫ್ ಇತ್ತಾ?
ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ, ನೋ ಸ್ಪೆಸಿಫಿಕ್ ಅಂತ
ಇನ್ನೇನೋ ಇತ್ತು ತಗೊಂಡು ಚುಚ್ಚದ ಅಂತಂದ್ರೆ ದಟ್ ಬಿಕಮ್ಸ್ ಎ ಸ್ಪರ್ ಆಫ್ ದಿ ಮೂಮೆಂಟ್, ನೋ ಇಂಟೆನ್ಷನ್. ಹೌದಲ್ಲ? ಮನೆ ಒಳಗೆ ಆಗೋದ್ರಿ ಇನ್ಸಿಡೆಂಟ್, ಬೇರೆ ಕಡೆ ಎಲ್ಲ ಆಗಲ್ಲ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇಸ್ ದಟ್ ಒನ್ ವರೀಸ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್.
ಒಂದು ವರ್ಷದ ಕಸ್ಟಡಿ
ದಟ್ ಇಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಅನ್
ಬೈಂಡಿಂಗ್ ಅಲ್ಲ, only with the bail in court, but this petition was a one not authoritative.
ಬೇಡ್ರಿ, ಅಸಾಲ್ಟ್ ಮಾಡಕ್ಕೆ ಇವನೇ ಫೆಲಿಸಿಟೇಟ್ ಮಾಡಿದಾನೆ, ಹಿಡ್ಕೊಂಡಿದ್ದಾನೆ ಅವನ್ನ. ಹಿಡ್ಕೊಂಡಾಗ ಅವನ್ ಚುಚ್ಚವನ. ಇದು ಬರೀ ಒಂದೇ ಸ್ಟಾಫ್ ಇಂಜುರಿ ಬರೀತಾರ. ಆ ಜಜ್ಮೆಂಟ್ ಹಿಡ್ಕೊಂಡು ನಮ್ಮ ಹತ್ರ ಬಂದಿಲ್ಲಿ ನೀವು ಬೇಲ್ ಕೊಡಿ, ಬೇರೆಯವ್ರು ಕೊಟ್ಟಾರೆ ಅಂತ ಬರ್ತೀರಿ ನೀವು. ಮೆಟೀರಿಯಲ್ ಇರೋದೇ ಒಂದು, ಆರ್ಡರ್ ಇರೋದೇ ಒಂದು. ನೋಡ್ರಿ ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರೀಸ್.
Injury only
ಸ್ಟಾಪ್ ಆಗಲ್ಲ ನೋಡಿ. ಅಬ್ರೇಷನ್ 1 x 1 cm ಪ್ರೆಸೆಂಟ್ ಓವರ್ ರೈಟ್ ಟೆಂಪೋರಲ್ ರೀಜನ್ ಆಫ್ ಸ್ಕಾಲ್ಪ್, ತಲೆ ಕೊಟ್ಟು ಅಟ್ಯಾಕ್ ಮಾಡೋನೆ. ಅಬ್ರೇಷನ್ 2 x 0.5 ಪ್ರೆಸೆಂಟ್ ಓವರ್ ದಿ ಲೆಫ್ಟ್ ಸೈಡ್ ಆಫ್ ಫೋರ್ಹೆಡ್. ಎಲ್ಲ ಹೆಡ್ ಮೇಲೆ. ಅಬ್ರೇಷನ್ ಪ್ರೆಸೆಂಟ್ ಓವರ್ ದಿ ಲೆಫ್ಟ್ ಚೀಕ್, ಸಿಚುಯೇಟೆಡ್ 2 cm ಬಿಲೋ ಔಟರ್ ಆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಲೆಫ್ಟ್ ಐ. ನೆಕ್ಸ್ಟ್ 4ನೇದು, ಅಬ್ಲಿಕಲಿ ಪ್ಲೇಸ್ ಇನ್ಸೈಸ್ wound measuring 2 cm deep noted over middle part of the chin, situated at 8 cm from right angle of mandible. 5ನೇದು, obliquely placed stab injury measuring deep noted over left side front of chest, situated 5 cm from middle line and 2 cm from below the lower border of left clavicle. Abrasion over the right. ಒಟ್ಟು 7 ಇಂಜುರೀಸ್ ಇದೆ. ಸಿಂಗಲ್ ಸ್ಟಾಬ್ ಇಂಜುರೀಸ್ ಅಂತ ಬರ್ದ್ ಬೇಲ್
ಇಬ್ಬರಿಗೂ ಫ್ರೀ ಫೈಟ್ ಆಗ್ತದೆ. ಅದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಇಬ್ಬರಿಗೂ ಫ್ರೀ ಫೈಟ್ ಆಗ್ಬಿಟ್ಟು ಬಾಗಿಲವರಿಗೆ ತಳ್ಕೊಂಡು ಹೊಡೆದಾಕೊಂಡು ಬರ್ತಾರೆ, ಬಾಗಿಲವರಿಗೆ ತಳ್ಕೊಂಡು ಹೊಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ಆಮೇಲೆ
it is spur of moment or all at the time of trial, not at the stage of considering the bail petition. ಅಷ್ಟೇನಾ? ಯಾವ ಕಂಡೀಷನ್ ಇಲ್ಲ. ಜೀವ ತೆಗೆಯೋದು, ಮನುಷ್ಯನ್ ಜೀವ ತೆಗೆಯೋದು. Heard the petitioner counsel and also the counsel appearing for the state. This petitioner, who has been arraigned as accused number 2, earlier approached this court. ಆಯ್ತು, ಏನಾಯ್ತು ಹೇಳಿ? When this court about to dictate the orders at this juncture, the counsel seeks permission to withdraw the petition and permitted to withdraw. ಅಂತ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಇಟ್ಕೊಂಡು ಬಂದು ನಮ್ಮ ಹತ್ರ ಪ್ಯಾರಿಟಿಗೆ ಅವ್ರಿಗೆ ಬರಕ್ ಹೋಗ್ಬೇಡಿ. ಕಣ್ಣಿಗೆ ಕಂಡಂಗೆ 7 ಇಂಜುರಿ ಇದಾವೆ, ಒಂದೇ ಇಂಜುರಿ ಅಂತ ಹೇಳಿ ಬೇಲ್ ಕೊಟ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ ಹೇಳಿ? ಹೇಳ್ರಿ. ಪೋಕ್ಸೋ ಆಕ್ಟ್. The petitioner is at liberty to approach this court after examination of the victim girl and the doctor. ಆಯ್ತಾ? ಇಬ್ರು ವಿಚಾರಣೆ ಆಯ್ತಾ? ಕೊಟ್ಟಿದಾರಾ? ಎವಿಡೆನ್ಸ್ ಕಾಪಿ ಹಾಕಿದೀರಾ? ಎಲ್ಲಿ ಹೇಳಿ? ಪಾರ್ಟಿ ಸವಾಲು ಏನಿದೆ ಅಲ್ಲಿ ಸಪೋರ್ಟ್ ಮಾಡಲಿಲ್ಲ. ಪಾರ್ಟಿ ಸವಾಲಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಇದು ವಿಕ್ಟಿಮ್ ಅಲ್ವಾ, ಮದರ್ ಇರ್ಬೇಕು.
ಹೀರೋ ಇರ್ತಾಳೆ, ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಹತ್ರ ಬೆಳಿತಾರೆ ಶಿವಮ್ಮ. ವಿಕ್ಟಿಮ್ದು ಇದೆ ನೋಡಿ, ಫೇಸ್ 30.
ಅಲ್ಲಿ ವೈದ್ಯರು ನನ್ನ ಮತ್ತು ಚಾಚಾ ಇವಳು ಸಮ್ಮತಿಯನ್ನು ಪಡೆದು ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷೆ ನೋಡಲಾಗಿ ಗರ್ಭಿಣಿಯಾಗಿರ್ತಾರೆ ತಿಳಿಸಿ ವೈದ್ಯ ಪ್ರಮಾಣ ನೀಡುತ್ತಾರೆ ಸರಿಯಲ್ಲ. ಅಲ್ಲ ರೀ, ನಿಮ್ ಪಾರ್ಟಿ ಸಾವಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಬೇಡೇನ್ರಿ, ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ಕೆ ಸಿಗ್ನೇಚರ್ ಇದ್ದಿದ್ಕೆ ಬರೀ ಸಜೆಷನ್ ಮಾಡ್ಬಿಡ್ತೀರಿ ನೀವು. ನಿಮ್ಮ ಇವರು ಹಂಗೆ ಇದ್ದಾರೆ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್, ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿರ್ತಾರೆ ಸರ್ ಕನ್ಸೆಂಟ್ಗೆ. ಆ ಸಿಗ್ನೇಚರ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದಾರೆ ವಿಟ್ನೆಸ್ಗೆ? ಎಲ್ಲಿದೆ? ಹಾ, ಟ್ವೆಂಟಿ 5 ಯಾರ್ದು ನೀವು ಕೇಳ್ತಾ ಇರೋದು? ಬೇರೆಯವ್ರದ್ದು? ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಮದರ್ದು. ಮದರ್ ವಾಸ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್ ವೈಲ್ ಗಿವಿಂಗ್ ಕನ್ಸೆಂಟ್ ಫಾರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್ ಬಿಕಾಸ್ ಹಿ ಇಸ್ ಮೈನರ್ ಅಲ್ವಾ? ಎಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದೀರಿ? ಹಾ 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 DNA ಏನು ಬಂದಿಲ್ವಾ? ಹಾ, ಸಂತರಸ್ತೆ. ಸರಿ ಹೊಸನ ನೋಡಿ ಗುರುಸಿದ್ದದನ್ನು ಈಗ ನಿಶಾನೆ P3 ಎಂದು ಮತ್ತು ಅದರ ಮೇಲೆ ನನ್ನ ಸಹಿಯನ್ನು ನಿಶಾನೆ P ಎಂದು ಗುರುಸಲಾಯಿತು. ಎಕ್ಸಿಬಿಟ್ P3 ಅನ್ನು 164 ಸ್ಟೇಟ್ಮೆಂಟ್. ಹಾ, ಜಡ್ಜ್ ಮುಂದೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾಳೆ. ಏನಂತ ಇದು 164 ಅಲ್ಲಿ? ಹಾ, ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನೀವು ಸಿಗ್ನೇಚರ್ ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರಿ, ಇದ್ ನಿಂದ ಸಿಗ್ನೇಚರ್ ಅಂತ ಎಲ್ಲಿ ಕೇಳಿದಾರ್ರಿ? ಅದ್ ಜನರಲ್ ಸಜೆಷನ್ ಆಯ್ತು. ಸಿಗ್ನೇಚರ್ ತೋರಿಸ್ಬಿಟ್ಟು ಈ ಸಿಗ್ನೇಚರ್ ನಿಂದ ಹೌದಾ ಅಲ್ಲ ಅಂತ. 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಶಿ ಅಡ್ಮಿಟ್ ಸರ್. ಎಕ್ಸಿಬಿಟ್ P3 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು. ಎಕ್ಸಿಬಿಟ್ P3 ಏನ್ ನೋಡಿ. What is the evidence of the doctor? ಡಾಕ್ಟರ್ ಆಗಿಲ್ಲೇನ್ರಿ? ಎಲ್ಲಿದೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್? ಇಲ್ಲೆಲ್ಲ ಹಾಕಿದಿರಿ ನೀವು? ಯಾಕೆ ಹಾಕಿ ಮತ್ತೆ ಅದನ್ನ ಹಾಕ್ಬೇಕಲ್ಲ. ಮತ್ತೆ ವೈ ಯು ಆರ್ ವೇಸ್ಟಿಂಗ್ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್? ವಿಕ್ಟಿಮ್ ಗರ್ಲ್ ಅಂಡ್ ದಿ ಡಾಕ್ಟರ್ ಅಂತಿದ್ದೀರಿ, ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿ? ಯಾಕೆ ನಿಮಗೆ ಕನ್ವೀನಿಯಂಟ್ ಆಗಿರೋದು ಮಾತ್ರ ತಂದು ಹಾಕಿದ್ದೀರಾ? ಬಟ್ ಅರ್ಲಿಯರ್ ಪಿಟಿಷನ್ ರಿಜೆಕ್ಟೆಡ್ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ದಟ್ ಅರ್ಲಿಯರ್ ಆಫ್ಟರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್ ಅಂಡ್ ಡಾಕ್ಟರ್ ಅಪ್ರೋಚ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಮಾಡಿದ್ದೀವಿ. ವೈ ಯು ಆರ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್? ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಲ್ವಾ? ತಾಯಿದು ಮಗಳದು ತಗೊಂಡು ಬಂದು ನೀವು ಕೋರ್ಟ್ ಹಾಕಿದ್ದೀರಿ ಅಷ್ಟೇನೆ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್. ದಿಸ್ ಕೋರ್ಟ್ earlier rejected the bail petition and given liberty to approach the court after the examination of the victim and also the doctor. Now only victim evidence is placed and doctor evidence is not placed, and hence petitioner counsel is directed to place the deposition of doctor. ಯಾವಾಗ ಬೇಕು ಯಾವತ್ತು ಆಗ್ತದೆ? ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ, ನಿಮ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂದ್ರೆ ಇಲ್ಲ, 16 ಯಾವತ್ತು ಬೇಕು? ಆಯ್ತು 15.
After filing of the charge sheet. But the after filing of the charge sheet, under the session court was pleased to allow bail petition from accused number 3 to 8.
3 to 8.
Please.
Huh.
But Have rejected.
Hmm.
Now, let the reason the petitioners of the project.
Offense is 307. Offense 307. Not 2 ಆಗಿದೆ ಈಗ. ಆಗಿಲ್ವಲ್ಲ 307. ಅವಾಗ 143, 147, 447, 323, 307, 504, 506 ರೆಡ್ ವಿತ್ ಸೆಕ್ಷನ್ 149 ಅಂತಿದೆ. ಆಗಿರ್ಲಿಲ್ಲ.
They have sought permission to the honorable magistrate to invoke 302. Because Lord, from the date of incident, Lord, after 5 days, Lord, he expired. 302 was invoked that time itself. But the now, Lordship, my Lord, kindly see.
Where is the order of the trial court now?
Lord, Lordship.
While rejecting bail petition in respect of these two petitioners, what is the observation?
Observation. Sure.
Page 23, reasons. Lakshmana Gangadhara. Para 7, point number 1. Petitioners have filed a private complaint against the present case complainant. And moreover, nothing recovered from these petitioners, section number 1 and 2, in connection with the allegations, and as already investigation is over and petitioners are ready to cooperate with the trial counsel on their grounds. As in support of his contention, so relied upon the judgment also, then in the case therein, bail granted for the offense and section 302 of ICC, and the deceased mother-in-law had intervened in the altercation between the accused and his wife, and resulting the said mother-in-law sustained stabbed injuries, and hence not a case for commission. Well, judgments. On the other hand, the learned counsel contended that due to land dispute, murder committed by the petitioners, and further charge sheet filed prima facie against the petitioner. At this stage, the charge sheet based on the complaint and the statements of the witnesses, and also for the dying declaration of the deceased Hanuman-Tappa, it emerges that petition number 2 and 1 being the accused number 2 and 1 have, in spite of land dispute, came to the land Karaga village through the patrol against the said Hanuman-Tappa, and by use of fire stick set fire to the said Hanuman-Tappa respectively. And due to such act, the said Hanuman-Tappa has suffered severe burn injuries on his hands, legs, chest, back, and face. And he was shifted to Srirampura Government Hospital and thereafter shifted to Victoria Hospital, Bangalore, where he died due to burn injuries. At this stage, aforesaid the prima facie shows a serious case against the petitioner herein, and on the other hand, the arguments urged by the petitioner that charge sheet has been filed, and thereby the petitioner's entitled for regular bail is not acceptable. ಒಂದೇ ನಿಮಿಷ earlier order ಓದ್ಬಿಡ್ತೀನಿ. Having heard the respective counsel and also on perusal of material available on record, taking note of the factual matters of the case, there was a civil dispute between the parties, and there was a fight between the petitioner and the victim. The material also disclosed that complaint was also very much present along with the victim. The fact that the injured also sustained to the burn injuries is not in dispute. Having taken note of the cause of death, the victim had sustained burn injuries all over the body. When such being the case, when specific allegation is made that these petitioners poured petrol and set fire, and as a result of said incident, the victim had suffered burn injuries, and the cause of death is also on account of burn injuries sustained. It is not a fit case to enlarge the petitioner bail at this stage of time, since victim also made statement before the police, and the same was certified by the doctor that he was fit to make statement. Healing.
Bottom line, 6th line.
ಸ್ಥಳವಾಗಿರುತ್ತೆ. ಸ್ಥಳದಲ್ಲಿ ಬರೀ ಜಮೀನು ಜಮೀನಾಗಿದ್ದು ಬದಲಿ ಜಮೀನಿನಲ್ಲಿ ಹುಲ್ಲು ಹಾಗೂ ಗಿಡಗಂಟೆಗಳು ಬೆಳೆದಿತ್ತು. No, in the fact that there was no crop with that time. That was crazy. Sir, the land of private as well suddenly how can fasting created by them? That was in favor of us for two products. Yeah. Protected.
Let the appeal be their counsel with regard to the bail you argue. The allegation against you that you went with petrol and poured the petrol and set the fire. What is your argument on this point? Is there any report that on account of burn injuries by pouring the petrol, he has sustained injuries? What is the report? Cause of death, burn injuries ಇದೆಯಲ್ರಿ, ಪೆಟ್ರೋಲ್ ಹಾಕಿ ಸುಟ್ಟಿರೋದ್ರಿಂದಲೇ ಸತ್ತಿರೋದು ಅನ್ನೋದಕ್ಕೆ ಡಾಕ್ಟರ್ ಇದೆಯಾ ಎವಿಡೆನ್ಸ್? PM report ಏನಿದೆ? cause of, that's what this court has observed in the earlier also. What is the change circumstances after filing of the charge sheet?
Stated that you remove the wheel with 16 what father of finger. There, we can put against the password. We appreciate all this. The serious work against or the litigation prosecution itself is wrong on the premise case.
Sir? Incident at what time? Alone. to the spot. That this disease was in the said land and started quarrel with him, and they went with petrol and poured the same on him and set fire, and he had sustained burn injuries. He was taken to the hospital, and his statement taken to Srirampura Government Hospital, and thereafter he was taken to Bangalore Hospital. His statement was also recorded. W? Third complaint the complaint given by whom? Accused number 8 wife. Accused number 8 wife. ಆಯ್ತು ನೋಡೋಣ CW 2 and 3 ಎವಿಡೆನ್ಸ್ ಆಗುತ್ತಲ್ಲ ಅವಾಗ ನೋಡೋಣ ಇಂಪ್ಲಿಕೇಶನ್ ಅಥವಾ ಏನು. ಆಯ್ತ್ರಿ, earlier we have considered the matter and merits ಅಲ್ವಾ. ನಾವು only change ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ಈಗ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಇಟ್ಕೊಂಡು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಬಿಲ್ ಕೊಡಕ್ ಆಗುತ್ತಾ? ರಿಟರ್ನ್ ಮಾಡಿದ್ ಯಾವತ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ ನೀವು? ಥ್ರೆಟ್ ಕಂಪ್ಲೇಂಟ್ ಯಾವತ್ ಕೊಟ್ರಿ? ಮರ್ಡರ್. That also helps the prosecution that you are having motive to eliminate him ಅಂತ. ಮತ್ತೆ because of grudge only you certify by pouring petrol. At counsel, it is a matter of trial, counsel. A matter of trial. ನಾವೀಗ ಉಳಿದಿರೋದು ಇಬ್ರೆ. ಯಾರು ಪೆಟ್ರೋಲ್ ಸುರಿದ್ರು, ಯಾರು ಬೆಂಕಿ ಹಚ್ಚಿದ್ರು, ಅವ್ರು ಮಾತ್ರ ಉಳಿದವ್ರು ಅಷ್ಟೇ. ಬಾಕಿಯವ್ರಿಗೆಲ್ಲ ಬೇಲ್ ಆಗಿದೆ ಈಗ. ಹೌದಾ? ಆಯ್ತು. ಎಲ್ಲಾರು ಬ್ರೆಡ್ ಆರ್ನರ್ಸ್. ಆಯ್ತು ನೋಡಿ. Heard the petitioner counsel and also the counsel, allow me to dictate the order. I heard enough you. ಆಯ್ತ್ರಿ, ನೀವು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನರೇಟ್ ಮಾಡ್ರೆ ನಾನು ಇಲ್ಲೇನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ? That is only an allegation in the complaint, that's all. This court has to see only the material collected by the IO, not the contents of the private complaint filed by accused number 8 wife. I don't know why you are not understanding. ಮತ್ತೆ ಹೌದ್ರಿ, 23ಕ್ಕೆ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಿ ನಮ್ಗೆ ಒಂದು ಥ್ರೆಟ್ ಇದೆ ಅಂತ. 3-5ಕ್ಕೆ ಹೋಗಿ ಅವನ್ನ ತೆಗ್ದೇ ಬಿಟ್ರಿ. ಈಗ ಬಂದ ಬೇಲ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀರಿ ಮತ್ತೆ. ನೋಡ್ರಿ, ಏನೋ ಅಫೆನ್ಸಸ್ ಹೇಗೆ ಅಂತಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಏನೋ ಅಲ್ಲೇನೋ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಗಲಾಟೆ ಆಯ್ತು, ಅಲ್ಲೇನೋ ತಗೊಂಡು ಹೊಡೆದ, ಇಂಥವೆಲ್ಲ ಕೇಸಸ್ ಇದ್ರೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ಯು ವೆಂಟ್ ವಿತ್ ಪೆಟ್ರೋಲ್. Already you went with petrol and poured the petrol on him and set the fire. 99 ನನಗೆ ಬೇಡ್ರಿ, ನಾನು ಪ್ರಶ್ನೆಗೆ ನೀವು ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ. ನಿಮ್ ಪ್ರಕಾರ ಅವನೇ ಪೆಟ್ರೋಲ್ ಹಾಕೊಂಡು ಅವನೇ ಸುಟ್ಕೊಂಡು ಸತ್ತಿದ್ದಾನೆ ಅಂತಾನ? ಎಲ್ಲಿ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ? ರೆಫರ್ ಆಗಿದೆ ಅದನ್ನು ರೆಫರ್ ಆಗಿದೆಯಾ? ಪೊಲೀಸ್ನವ್ರೇನು ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ವಾ? ಆಯ್ತು, ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ಮೇಲೆ ಬನ್ನಿ ನೋಡೋಣ. ಆ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ನಿಮ್ ಫೇವರ್ ಇದ್ರೆ ನೋಡೋಣ. ಯಾವ 1 ವೀಕ್? ಯಾವ್ದು ಇದು? ಈಗ ನಿಮ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕಾ? ಆಯ್ತು ನೋಡ್ರಿ, ಇದನ್ನ ಮೊದ್ಲೇ ಹೇಳ್ಬೋದಿತ್ತಲ್ರಿ, ಅರ್ಧ ಗಂಟೆ ವೇಸ್ಟ್ ಮಾಡಿದಲ್ರಿ. wasted half an hour. Heard the petitioner counsel in part. The counsel appearing for the petitioner would submit that the accused number 8 wife had lodged the complaint and matter is a private complaint, and the matter is also referred for investigation under section 156(3) of CPC, and awaiting the report, and then seeks time. And then ಆಯ್ತು, ಲೆಟ್ ದಿ ರಿಪೋರ್ಟ್ ಕಮ್. ಅವ್ರಿಗೆ ರಿಪೋರ್ಟ್ ಆದ್ಮೇಲೆ ಏನೋ ಬರ್ತೀನಿ ಅಂತಾರೆ, ಬರ್ಲಿ. ಆಯ್ತು. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲ? ಬಿಫೋರ್ ವೆಕೇಶನ್ ಇರೋದು ಒಂದೇ ವಾರ. ಒಂದ್ ವಾರದೊಳಗೆ ನಿಮ್ಗೆ ಆ ರಿಪೋರ್ಟ್ ಬರುತ್ತಾ? ಆಯ್ತು, 16th ಆಯ್ತು. ಕೊಡಿ, ತಗೊಳ್ಳಿ. MFA 5496 of 2016 and Prop 53 of 2018. These the appeal and cross objections filed challenging the judgment and award passed in MEC number 96 of 2010 dated 11th day of January 2016 on the file of senior civil judge and MACT 9 at Harpanahalli. Questioning the judgment and award on the ground that
negligence aspect may not be
negligence only quantum.
ಅದೊಂದು ಸೆಂಟೆನ್ಸ್ ತಾವು ಹೇಳಿಬಿಟ್ರೆ ಸಾಕು. In the connected appeal,
reasoning. Negligence and quantum of compensation granted, and claimant also in the CRAB contend that compensation awarded is very meager. The factual matrix of case of the claimant before the tribunal that on 14/4/2010 he himself and his father have taken the Tata Indica car for hire basis for the purpose of treatment at Manipal Hospital. On the same day, the petitioner and his father have travelled in the said vehicle, at about 1:20 a.m. And at that time, the respondent number 1 drove his car bearing registration number K53/551 from Harpanhalli side with high speed and in a negligent manner, and he dashed against the parked lorry As a result, the petitioner and his father have sustained blood-stained injuries in the accident. Immediately, the injured was shifted to Government General Hospital, Harapanalli, wherein he was given first aid. And on the advice of the doctor, he was shifted to Davanagere for further treatment. And he took treatment at Bapuji Dental College and Hospital, Davanagere, from 14/4/2010 to 15/4/2010. And thereafter, again, he was shifted to City Central Hospital, Davanagere, wherein he was treated as an inpatient about 15 days from 15/4/2010 to 29/4/2010. The claimant, in support of his claim, examined himself as PW1. And also examined the doctor. Your doctor are PW3 na 4? PW4. And PW4 assessed the disability of 20%. And the same is accepted by the tribunal and considered the future loss of income of rupees 8,44,800. And also awarded compensation on head of pain and suffering, loss of amenities and discomfort in life, and including medical expenses and attendance charges. In all, granted compensation of rupees 10,92,702.
I'm sorry,
Hence,
PW3 or
PW4.
PW3.
Hence, the present appeal is filed by the insurance company, contending that the tribunal committed an error in directing the insurance company to pay the compensation. And counsel would vehemently contend that there was an involvement of two vehicles in the accident, and the driver of the car went and hit the station lorry, and the negligence on the part of the driver of the lorry was not taken into consideration. It also contended that compensation awarded 8,44,800 towards loss of future earning is without any basis. The counsel also vehemently contend that the disability assessed 20% is in respect of the particular limb, and tribunal considered the same as disability to whole body, and committed an error in awarding compensation of rupees 8,44,800. The counsel also vehemently contend that the income taken 22,000 per month is also on a higher side, and no material that he was incapacitated to continue his work, and hence committed an error in taking the future loss of income, and hence it requires interference. Per contra, the counsel appearing for the claimant in section 53 of 2018 contend that tribunal committed an error in granting compensation towards future loss of income, and the same is on the lower side. And compensation granted towards attendance charges and other incidental charges is on the lower side and is liable to be announced. And compensation awarded on the head of loss of amenities is also on the lower side, and hence it requires to be announced. There are citations in our Kotangidarala. Rajkumar case. Counsel support of his argument also, the counsel appearing for the claimant also in support of his argument, he relied upon the judgment of the apex court reported in 2011 within bracket 1 Supreme Court cases 343 Rajkumar versus Ajay Kumar and another, wherein the apex court has assessed the apex court has given the guidelines in a case of considering the case of injury, assessment of loss of future earnings on account of permanent disability. Detailed principles were laid down. Functional disability as operative criterion, distinguished from physical disability. Mode of assessment based upon types of disability also distinguished. Held that in disability certificate, extent of disability of a limb cannot be assumed to be extent of disability of whole body. Tribunal should not mechanically apply percentage of physical disability as percentage of economic loss or loss of earning capacity, but must assess functional disability. And directions are given to the tribunal in respect of procedures, steps to be followed in such cases. The council relying upon this judgment to vehemently contend that even though the doctor has deposed with regard to the particular limb, court has to take note of the functional disability of the injured. Having heard the respective counsel and also on perusal of available on record, the point that would arise for the consideration of this court are whether the tribunal committed an error in not considering the negligence on the part of the stationed vehicle while directing the insurance company to pay the compensation. Point number 2, whether the tribunal committed an error in granting exorbitant compensation, whether the tribunal committed an error in not awarding just and reasonable compensation. What order? Point number 1. The main contention urged in the appeal memo that tribunal committed an error in not considering the negligence on the part of the vehicle which was stationed by the side of the road and ought to have taken the note of the same. The counsel appearing for the claimant in his argument during the argument brought to the notice of this court that when two claims are filed before the tribunal and the insurance company already complied the direction and deposited the amount, and now they cannot contend and raise the objection with regard to the negligence is concerned. The counsel appearing for the insurance company also not dispute the said fact and contend that already complied with the directions in other connected matter. When such being the material available on record, once the insurance company admitted the liability and made the payment in connected matter, now cannot raise the ground of negligence, and hence I answered the point as negative. Now coming to the point number 2 and 3. Having heard the respective counsel and also on perusal of records and material available on record, and also the principles laid down in the judgments referred supra, it is settled law that court has to take note of the functional disability and not the physical disability while assessing the compensation, and no dispute with regard to the principles laid down in the judgment of the apex court. In keeping the principles laid down in the judgment and also considering the material on record, this court has to reassess the material. On perusal of the material and record, the claimant had sustained
at page number 12 of the judgment, my lord.
14.
Page number 12 top of injuries.
Material, immediately he was shifted to the government hospital, and then he was shifted to Bapuji Dental College Hospital, and then also he was shifted to City Hospital, and wherein he was an inpatient for a period of 16 days. And nature of injuries are also deep cut injury over chin, cut injury over lower lip, abrasion wound over left cheek, tenderness over knee region, and also fracture is mentioned, dislocation of right hip joint, and sutured lacerated wound over left cheek was also found. In order to prove the nature of injuries, the claimant relied upon the evidence of the PW3. The PW3 also issued a disability certificate to the petitioner. And injured was also treated by close reduction done under close reduction was done, and he was discharged on 29/4/2010. The Dr. PW3 after the examination both clinically and radiologically, doctor has opined that the petitioner has got 20% of permanent physical disability, and even during the course of cross-examination, percentage assessed by the doctor to the particular part, if it is compared to the whole body, it will decrease as comma. Doctor has answered that there is no chance of decrease the percentage. On perusal of the evidence of PW3, In the cross examination, PW3 admits that except the tail injury, a fracture, no other fractures. And also the fracture is united. And he subjected the claimant for examination on 27/5/2011. And thereafter also visited for follow-up treatment. And it is registered in the cross-examination that the 20% of disability in respect of the particular limb. But denied the answer that if whole body disability is taken, it will be decreased, and the same is not admitted. And having considered the evidence available on record and also the nature of injuries, that is fracture dislocation of hip joint, considering the disability of 20%, when he was subjected to open reduction of surgery, I do not find any error committed by the tribunal in accepting the evidence of PW3. Though he has stated in the cross-examination that the disability is in respect of the particular limb. Also, in the cross-examination, categorically denied that the whole body disability will be reduced. When such evidence is available before the court, the very contention of the insurance company that disability assessed by the doctor is on higher side cannot be accepted. The other contention of the counsel appearing for the claimant that in view of the judgment of the apex court in Rajkumar case referred supra, court has to take note of the functional disability. The claimant is working as an engineer. Hoda, it notes tandubiಟ್ರ ಮೇಡಮ್, ನೋಟ್ಸ್ ಮಾಡಿಟ್ಟಿದ್ನಲ್ಲ ಅದೆಲ್ಲ working as mechanical engineer. ಕನ್ನಡ ಇಟ್ಟಿದ್ದೀರಾ ಏನ್ ಮಾಡೋದು? Mechanical engineer. And also to that effect, witness PW5 is also examined. The material also discloses that after the accident, he did not attend the duty, but also several requests are made to consider his employment for official work, and the same has not been considered, and ultimately does not continue the job. When such being the case, this court is also not considering the disability to the extent of 100%, and while calculating the loss of future income only taken the disability of 20%, and insurance company also not placed any material that he has continued the job after the accident. In such being the case, the partial disability which has been deposed by the doctor PW3 has to be taken note of. The PW5 evidence is also very clear that he was earning salary of rupees 24,348, and after deduction he was getting rupees 22,368. When such material available before the court, and disability is also considered only to the extent of 20%, the very contention of the claimant counsel that the same has to be enhanced to the disability cannot be accepted. The very evidence of the doctor is with regard to the particular limb, and although he was suggested that the whole body disability will be reduced, but he denied the same. But having considered the nature of injury is concerned, and also his avocation is concerned, very contention of the claimant counsel that functional disability has to be taken more cannot be accepted, and the fracture is also united, and proportionate disability has to be considered, and according to the evidence of the doctor PW3, disability of 20% is taken, and hence I do not find any ground to either to enhance the compensation or to reduce the compensation, since income of rupees 22,368, and the same income was prior to the accident, and hence the same is considered by the tribunal, and hence it doesn't require any consideration on the head of future loss of income. Now coming to the aspect of pain and suffering is concerned, tribunal awarded an amount of rupees 30,000 and he was an inpatient for a period of 16 days and he was in the hospital for, he was in 3 hospitals. And having taken note of, he was an inpatient for a period of 16 days as well as the fracture dislocation of hip joint. It minimum requires minimum, but it is appropriate to award an amount of rupees 40,000 on the head of pain and suffering. Loss of amenities and discomfort in life is concerned, the tribunal committed an error in awarding only the 10,000 when the injured, who is aged about 32 years, he has to lead his rest of life with a disability of 20%, which has been assessed by the doctor, and hence it is appropriate to award an amount of rupees 40,000 on the head of loss of amenities and discomfort in life. Medical expenses are considered to the tune of rupees 1,87,902, and the same is based on the documentary evidence, and the same doesn't require any interference. Attendance charges and other incidental charges also awarded an amount of rupees 20,000, and he was an inpatient only for a period of 16 days, and hence the same is also just and reasonable. It doesn't require any interference. Future medical expenses kela doctor helidara?
No, my lord, nothing is said about future medical expense again.
The tribunal not awarded any compensation on the head of laid up period, and he was an inpatient for a period of 16 days, and also he had sustained the fracture dislocation of hip joint, and it takes minimum 3 months for uniting of fracture and for rest. And no doubt the claimant also not produced any document for having he has suffered the loss of income. But the fact that he has not continued the job is also not in dispute, and hence by taking the income of rupees 22,368 as his income for a period of 3 months, it comes to rupees 66,000. In our claimant is entitled for compensation of rupees 67,104. In all, claimant is entitled for compensation of rupees is for total.
Make one submission.
1,99,806.
PW 5 employer evidence ಅಲ್ಲಿ 2010 ವರೆಗೂ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. There was no loss of income during that laid up period, not.
ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಹೌದು, PW 5 ಮೆಲಾಡ್ ದಿ ಎಂಪ್ಲಾಯರ್.
ಬಟ್ ನಿಮ್ ಪ್ರಕಾರನೇ ನೀವು ಈಗ ಅಕೌಂಟ್ಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಪ್ರಕಾರ ಸ್ಯಾಲರಿ ಕೊಟ್ಟ ಬಗ್ಗೆ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ, ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಬಟ್ ಎಂಪ್ಲಾಯರ್ ಅವರು ಹೇಳ್ತಾರೆ 2010 ವರೆಗೂ ನಾವು ರಜಾ ಕೊಟ್ಟಿದ್ದೀವಿ, ಅಲ್ಲಿವರೆಗೂ ಇದು ಮಾಡಿದೀವಿ.
ನೀವೆಲ್ಲಿದೆ ಮೇಡಮ್? ಅಲ್ಲ, ಇವ್ರ ಅದ್ರ ಬಗ್ಗೆ ಏನಿದೆ ರೀ ದಾಖಲೆ?
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ
ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ, ಇದು
PW 5 ಯಾರು ಇಲ್ವಲ್ರಿ? ಒಂದ್ ನಿಮಿಷ ಇದಾರೆ.
PW 5 ಎಂಪ್ಲಾಯರ್ ಮೆಲಾಡ್ he said that from ನವೆಂಬರ್ ಇಂದಾನೆ ಅವ್ರು ರಜದಲ್ಲಿದ್ರು. ಸೊ ಹಂಗಾಗಿ ಅವರಿಗೆ ರಜಾ ಕ್ಲೋಸ್ ಆಗಿ ಹೋಗಿತ್ತು ಫೆಬ್ರವರಿ 28ಕ್ಕೆ. ಆಮೇಲೆ ನಾನು ಮತ್ತೆ ರಜಾ ಕೇಳಿದ್ರಿಂದ ನವೆಂಬರ್ ವರೆಗೂ ನಾವು ವೇತನ
9ರಿಂದ ರಜೆ ಮೇಲೆ ಇರುತ್ತಾರೆ.
ಹೌದು, ನವೆಂಬರ್ ಇಂದಾನೆ 11/4/2010
ಅವರ ಪ್ರಾಜೆಕ್ಟ್ ಇನ್ಸ್ಟಾಲೇಷನ್ ವಿಭಾಗದಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ರು. ಅವರೆಲ್ಲ ಕೆಲಸ ಬೇರೆ ಬೇರೆ ಸ್ಥಳಗಳಿಗೆ ಹೋಗಿ ನಿರ್ವಹಿಸುವುದು ಇತ್ತು, ಕಚೇರಿ ಕೆಲಸವಿರಲಿಲ್ಲ. ನಮ್ಮ ಕಂಪನಿಯವರು ಸಾಕ್ಷಿಗಳು ಸಂಪೂರ್ಣ ಭಾಗದಲ್ಲಿ ಎಲ್ಲ ಕಡೆ ಇರ್ತದೆ. ಸಾಕ್ಷಿ ನಮ್ಮ ಕಂಪನಿ ದಾಖಲೆಗಳನ್ನು ನೋಡಿಕೊಡಿಸುತ್ತಾರೆ. ರಾಜರಾತ್ರಿ ವಸ್ತುಪುಸ್ತಕವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ಅವರು ಯಾವ ತಾರೀಕಿನ ರಜೆ ಮೇಲೆ ಇರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಿದ್ದೇನೆ. ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ನೀಡಿದ ವೈಯಕ್ತಿಕ ರಜೆ ಫೆಬ್ರವರಿ 28ಕ್ಕೆ ಕೊನೆಗೊಂಡಿತು. ನಂತರ ಅವರ ಖಾತೆಯಲ್ಲಿ ರಜೆ ಇಲ್ಲದ ಕಾರಣ ಅವರು ರಜೆ ಬೇಕೆಂದು ಕೇಳಿದ್ದರಿಂದ ವೇತನ ಸಹಿತ ರಜೆಯನ್ನು ನವೆಂಬರ್ 2010 ನೀಡಲಾಗಿತ್ತು. 2010 ನವೆಂಬರ್ ವರೆಗೆ ವೇತನ ಸಹಿತ ರಜೆ.
My submission is, my lord, November 2009 ಇಂದನೇ he was on leave. 11/4/2010, my lord, is the date of
accident. He was on leave, and by that time he met with an accident.
11/4/2010.
He could not report for job immediately after the accident.
Yes, yes, madam.
He was on leave on credit leave which was in his account. ಹೌದಾ?
ರಜಾನೇ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರ ಅಕೌಂಟ್ ಅಲ್ಲಿ ರಜಾನೇ ಇಲ್ಲ.
PW 5 ಏನ್ ಹೇಳ್ತಾರೆ? ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ನೀಡಿದ ವೈಯಕ್ತಿಕ ರಜೆ ಫೆಬ್ರವರಿ 28ಕ್ಕೆ ಕೊನೆಗೊಂಡಿದ್ದವು. ಅವನ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಏನಿತ್ತು ಅದೆಲ್ಲ ಕೊನೆ ಆಯ್ತು. ಹೌದಾ? Then again he was on leave without any salary up to the November. ಹೌದಾ?
ಹೌದು.
ಅವನ್ ಕ್ರೆಡಿಟ್ ಅಲ್ಲಿ ಇದ್ದ ಅಕೌಂಟ್ ಹೋಗಿದೆಯಲ್ಲ. Raja.
My contention is that, my lord, much earlier to the accident, from November 2009 itself, my lord, he was unauthorizedly absent to the.
ಅನಾಥರೈಸ್ಡ್ ಅಬ್ಸೆಂಟ್ ಅನ್ನೋದು ಕೇಳಿದೆ ನೀವು ಹೇಳ್ತಾ ಇರೋ ಪ್ರಕಾರ ಅವನು ರಜದಲ್ಲಿ ಇದ್ದ ಅಂತ ಅಷ್ಟೇ. ಅನಾಥರೈಸ್ಡ್ ಅಬ್ಸೆಂಟ್ ನವೆಂಬರ್ ಇದ್ದಾನ ಕೇಳಿದೆ ಮೆಟೀರಿಯಲ್ ಹೇಳಿ.
ಅದು ಟರ್ಮಿನೇಷನ್ ಲೆಟರ್ ಅವ್ರು ಕಳಿಸಿದ್ರಲ್ಲ ಎಂಪ್ಲಾಯರ್ ಆಫ್ಟರ್ ರಿಕ್ವೆಸ್ಟಿಂಗ್ ಬೈ ದಿಸ್ ಕ್ಲೈಮೇಟ್ ಮಲಾಡ್ ಟು ದಿ ಕಂಪನಿ he has said that you are unauthorizedly
absent even prior to the accident ಅಂತಿದ್ಯಾ?
ಇದರಲ್ಲಿ ಇವರು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನವೆಂಬರ್ ಇಂದಾನೆ ಅವ್ರು ಅಬ್ಸೆಂಟ್ ಆಗಿದ್ರು, ಲೀವ್ ಅಲ್ಲಿ ಇದ್ರು. ಎಂಪ್ಲಾಯರ್ ಎವಿಡೆನ್ಸ್
PW5 ಆ ರೀತಿ ಇಲ್ರಿ, ಅನಾಥರೈಸ್ ಅಬ್ಸೆಂಟ್ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅವನು.
ಅಲ್ಲ ನವೆಂಬರ್ ಲಾಸ್ಟ್ ಖಂಡಿಸಿ ಅನಿಲ್ ಕುಮಾರ್ ಹಾಜರಾಗಿ ಪುಸ್ತಕವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ಅವರು ಯಾವ ತಾರೀಕಿಂದ ರಜೆ ಮೇಲೆ ಇರುತ್ತಾರೆ ಎಂದು ಸಾಕ್ಷ್ಯ ನುಡಿಯುತ್ತಿದ್ದೇನೆ. ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ನೀಡಿದ ವೈಯಕ್ತಿಕ ರಜೆ ಫೆಬ್ರವರಿ 28ಕ್ಕೆ ಕೊನೆಗೊಂಡಿರುತ್ತದೆ. ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಮುಖ್ಯ ವಿಚಾರಣೆ ಹೇಳ್ತಾರೆ, ಸದರಿ ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ನವೆಂಬರ್ 2009ರಿಂದ ರಜೆಯ ಮೇಲೆ ಇರುತ್ತಾರೆ.
ಹೌದು, ನವೆಂಬರ್ 2009ರಿಂದ
ಆಕ್ಸಿಡೆಂಟ್ 11/4/2010 ಮೇಲೆ 11/4/2010 much early to the action Malad was on leave. He was unauthorizedly absent. ಅವತ್ತು ಲೀವ್ ಆಗಿದ್ರು. ಆಮೇಲೆ ಫೆಬ್ರವರಿ 28ಕ್ಕೆ ಅವ್ರ ಲೀವ್ ಕ್ಲೋಸ್ ಆಯ್ತು. Subsequently Malad again he has not gone to the Malad.
He was having leave from November to February 2010. ಹೌದಾ?
ಕರೆಕ್ಟ್. ಆದ್ಮೇಲೆ 11/4/2000 ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು. ಟಿಲ್ ದಟ್ ಟೈಮ್ ಮಾಡಿ ವಾಸ್ ಆಲ್ಸೋ ಅಬ್ಸೆಂಟ್.
ಏನ್ರಿ even prior to that you are unauthorized absent from November itself, and your leave was ended into February 2010 itself.
February 28th.
April 14th. By that time your leave was already exhausted and you are not continued the job because of accident in the month of April. Why you are absent from November 9?
That he was
your leave only up to the February. ಹೌದಾ? ಫೆಬ್ರವರಿ ಲೀವ್ ಮುಗಿದ್ಮೇಲೂ ಯಾಕೆ ಹೋಗ್ಲಿಲ್ಲ ನೀವು? ಮತ್ತೆ now you are seeking for loss of income immediately after the accident. You are not entitled. That's all. Note. ಒಂಥರ ಹೇಳಿದ್ವಲ್ಲ ಮೇಡಮ್, ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್.
That's why Malad, they have submitted only the
appearing for the insurance company brought to the notice of this court that this petitioner was on leave from November 2009 and his leave was also exhausted in the month of February 2010, and this accident was occurred in the month of April, that is on 13/4/2014. 4/10 of 13/4/2010, and he was not reported to duty even after the exhausting of his leave account. And then question of awarding any compensation on the head of loss of income during laid-up period doesn't arise. And there is a force in the contention of the council submission that he was on leave from November 2009, and even his leave was also exhausted in the month of February itself. And after the exhaustion of his leave in the month of February, he did not report to the duty, and the accident was occurred in the month of April 2010. And when such being the case, question of awarding compensation on the head of laid-up period doesn't arise. And he was on loss of pay during the time of accident till November 2010. And hence not entitled for the head of loss of income during the laid-up period. In view of the discussions made above, I pass the order. Appeal filed by the insurance company is dismissed and appeal filed by the claimant is allowed in part. Enhancing compensation of rupees mostly around 1 lakh just made.
Amount in deposit may be transferred to
the deposit is ordered to be transmitted to the tribunal. ಯಾವ್ದು ತಗೊಳ್ಳಿ ಪಾಸ್ ಓವರ್ MFN ಅಲ್ಲೂ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ? ನೋಡಿ ಯಾರು TG ಬಸವರಾಜ್ ಬರ್ಲಿಲ್ವಾ? ಅವ್ರು ಅವರೇ ಬರ್ತಾ ಇಲ್ವಲ್ರಿ? ಓನ್ಲಿ ಅನೌನ್ಸ್ಮೆಂಟ್. ಡಿಸಬಿಲಿಟಿ ಏನು ಇಂಜುರಿ ಏನು? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಮೇಡಮ್. ನಮ್ಮದೇ ಫಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು ನೋಡಿ. ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಕಾಲ್ಡ್ ಟ್ವೈಸ್. ದಿ ಅರ್ಲಿ ಮಾರ್ನಿಂಗ್ ಅಂಡ್ ಆಲ್ಸೋ ಇನ್ ದಿ ಆಫ್ಟರ್ನೂನ್. None appears on behalf of the appellant. Respondent counsel is present in both the occasion and hence this matter after winter vacation. O Mahesh, Pandra, O Mahesh or other portal argument. Suresh M. Lato?
I am here, my lord.
Our argument ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ ಬೇರೆ
ready, my lord. Argument I am ready.
Argument ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ VC ನಲ್ಲಿ. O Mahesh ಅವರು he is arguing in some other court. So, appellant counsel is present. Respondent counsel is in the VC and counsel is arguing in different court and hence list this matter after winter vacation. Vijaya MN ಇದು ಅವ್ರದೇನಾ? ಸೇಮ್ ಆರ್ಡರ್. ವಿಜಯ MN ಇದಾರ? ಎಲ್ಲ ಇದ್ದೀರಿ, ಏನ್ ಮಾಡೋದು ನೋಡಿ. Appellant counsel in MFA 8124 of 2014 is present and appellant in MFA 6538 of 2013 is also present and appellant in MFA 159 of 2015 though he is in VC is arguing the matter in other court and hence this matter immediately after winter vacation.
I am appearing for the appellant, my lord. The case of death, there is no nexus to injury and death is the appeal by the insured, filed by the appeal by insurer, my lord. No PM is conducted, no doctor examined. My lords, come to para 15, page para 54, page 37 of the learned trial court, my lord.
Para 54.
Yes, my lord.
What are the nature of injuries?
Nature of injuries, 1 to 3 are simple injuries, 4 is grievous injury, my lord. 3 simple injuries, 1 grievous injury at para 58.
What is that grievous injury? Certificate exhibit P14.
Para 58, my lord. 3 simple injuries, 1 grievous admitted as inpatient for 6 days. Total 17 days. Then come to para 59, my lord. They have not examined the doctor, nor they have conducted a PM. No medical reports are produced before the learned chest to ascertain cause of death. Para 59, my lord.
He died in the hospital or after the discharge?
After discharge, my lord. 4 months after discharge. Totally.
That's why I asked you, what is the nature of previous injury? What is that injury? Court has to examine whether that injury leads to the death. Right, tibia. Howda?
Tibia. And
tibia and fibula. Injury idea. Accident accident dated.
Accident is 6/4/2012, my lord.
For 2012.
Date of death is 14/6/13.
14?
Date of death 14/6/13.
2013.
House on.
1.5 year.
Yes, my lord.
ಎಲ್ಲಿವರೆಗೆ? In between period, treatment period end.
That is narrated at para 59, page 42, my lord. But based on the same, it cannot be said that the cause of death of disease petition is due to accidental injuries. As said that.
6/4/2012 ಅಲ್ಲಿ.
Yes, my lord.
To tibia and fibula. ಹೌದಾ? In between 6/4/2012 to 20 to 2013 ವರೆಗೆ ಎಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದಾರ? ಬೇರೆ ಬೇರೆ ಎಲ್ಲಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ಅದಕ್ಕೇನೆ. ಯಾವಾಗ ಅದು? Based on the same, it cannot be said that the cause of death of the deceased petitioner is due to the accidental injuries, as the said accidental injuries developed other diseases. As per the above said, the medical records, it clearly goes to show that deceased petitioner had taken treatment to said accidental injuries lastly at the BGS Hospital, Mysore, by admitting as an inpatient from 20 to 2013 to 24 to 2013. But he died on 14/6/2013 after lapse of nearly 4 months. No authenticated documents produced by the petitioner to show that in between the said period, the deceased petitioner had been taking regular follow-up treatment to the said accidental injuries. Admittedly, on 14/6/2003, the deceased petitioner was referred, but the petitioner have not conducted the postmortem. So even petitioner have not intimated to the said concerned police about the death of the deceased petitioner. So his cross-examination has clearly admitted that after discharge from the hospital 24/2016, his brother was expired. He has further clearly stated that also petitioner was taken hospital hours through also he has expired when he was wherein the doctor declared he already dead. He has further clearly stated that after the death they have not informed to the police reputation. Why you are not examined the doctor? But the cause of death, there must be an access to the accidental injuries and cause of death. Alva. Even PM report in the hodru, you would have examined the doctor. Fracture is also tibia and fibula. Abdominal discussion abdominal injury idruno adu only the grievous injury, simple injury at the time of the accident. Wound certificate kodi madam, nodona abdominal injury ಬಗ್ಗೆ ಏನಾರು ಹೇಳಿದಾರಾ? Multiple abrasion over an area of 5 centimeter into 4 centimeter on the back of the left hand. Reddish abrasion of 4 centimeter into 3 on the front of left knee. Middle 1/3 of the right leg with underlying comminuted fracture, tibia and fibula. Yav injury ಹೇಳ್ತಾ ಇದ್ರಿ ನೀವು? ಯಾವ ನೀವು ಎಕ್ಸಿಬಿಟ್ ಯಾವ್ದು ರಿಲೀಸ್? ಎಕ್ಸಿಬಿಟ್ P6 14. ಸೇಮ್ ಮಂಗಳ wound certificate ಎರಡನ್ನು. ಅಲ್ಲ ರೀ, ಫಸ್ಟ್ wound certificate ಅಲ್ಲಿ 11/4 discharge 11/4/2012 ಎರಡು ಕೂಡ 11/4/2012. ಇದರಲ್ಲಿ ಫಸ್ಟ್ wound certificate only 3 injuries. Same date of discharge 11/4/2012. Laceration of 9 centimeter into 4 centimeter into muscle deep on the outer aspect of upper part of right side of the abdomen. This injury is missing in exhibit P6. That is also issued at the time of both are wound certificate. ಎರಡು 6/4 date of admission discharge 11/4/2012. 11/4/2012. There are two wound certificate. I3, why it is missing in exhibit P3? P6. No such injury at all. That is also after the discharge only the wound certificate was given.
He was examined as PW2.
At least to strengthen your case that there was an injury to the abdomen. Where is the evidence? Doctor evidence is there.
No doctor examined at the judge held so. No medical records also printed to that extent.
Compensation ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Page number 46 ಬನ್ನಿ ಸ್ವಾಮಿ. 3,37,000. 396. Page 46, para 65.
Pain and suffering 1 lakh.
Awesome.
So loss of income during laid up period. 1 lakh medical expenses. 3,000 conveyance. ಎಷ್ಟು ದಿವಸ ಇದ್ದಾವೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ?
16 days, my lord. 16 days, 17 days. Total 17 days.
4,000. Attendance charges 3,000. Food and nourishment diet 5,000. ಕೊಡಿ. Paragraph. ಆಯ್ತು, ಎಷ್ಟು ಕೊಟ್ರಿ? ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೆ ನಾನು, ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇದೆ?
Para 63, page 47, my lord. As per medical bill.
Around he has relied upon one judgment of the Supreme Court.
Sir.
Paragraph number ಯಾವುದು? However, the compensation under the head pain and suffering being personal injuries is said to be unsustainable and disallowed. High Court has not awarded anything towards medical expenses despite hospitalization for 6 months. Being an admitted fact, we therefore award a sum of towards medical expenses. Hence, the reassessed total compensation would be rupees 28,42,175 calculated under annual salary future prospectus applying multiplier. This case of death ne consider ಮಾಡಿದ್ದಾರೆ. ಡೆತ್ ಗೆ ಇಲ್ಲಿ ಏನು ರೀಸನ್ಸ್ ಎಲ್ಲಿದೆ? ಆಯ್ತು ರೀ, PM report ಇದ್ರೆ I will also accept your case. What is the nexus? Here is a case of disability of 75%. Physiotherapy was assessed and 75% on 88,2000 in the interregnum. The injured resigned his job so and so. Injured was possessing professional qualification, labor and so. Narrow interpretation of that which does comment to us. Reasoning of the Gujarat High Court is more in consonance with the purpose of spirit of the act.
ಅದರಲ್ಲಿ ಆ ಕೇಸು ಅದರಲ್ಲಿ ಅವನು this was a law officer in Punjab University, my lord. Due to his 100% disability, he could not continue his job. That is case does not applicable to the case. Please, my lord. He was on a wheelchair. ಅದಕ್ಕೂ ಈ ಕೇಸು ಸಂಬಂಧ ಇಲ್ಲ, my lord.
ನಿಮ್ ಟಿಬಿಯಾ ಅಂಡ್ ಫಿಬುಲಾ ಇಂಜುರಿ ಯುನೈಟ್ ಆಯ್ತಾ ಇಲ್ಲ ಟ್ರೀಟ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ? ಆಯ್ತ್ರಿ, ನಿಮ್ಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿ 6/4/2012 ಇಂದ ನೆಕ್ಸ್ಟ್ 1 year ವರೆಗೂ ನೀವು ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಹೋಗಿಲ್ವಲ್ಲ? ಎಲ್ಲಿದೆ ಅದನ್ನೇ ದಾಖಲೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. He was in continuous treatment ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಕೊಡಿ ನೋಡೋಣ. ವಿಲ್ ಸಿ. 6/4/2012 ಬಿಟ್ರೆ ಮತ್ತೆ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿರೋದೇ 24/2/2013 ಹೌದಾ? 58 ಇದ್ವಲ್ಲ. Six 11/4/2012
for 6 days.
For 6 days, Mangala Hospital and Mangala Kidney Foundation from 13/4/2002 to 18/4/2012. 8 days.
That was 6 days.
Again for 6 days. And Unity Life Hospital and from 20 to 2013 ಹೋದ್ರ ಅವಾಗ. 13 ಅಂದ್ರೆ 18/4/2012 ಇಂದ 13 ವರೆಗೆ ನೀವು ಎಲ್ಲಿದೆ ದಾಖಲೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
That document they have not produced, my lord.
ಟೋಟಲ್ ಇರೋದು 17 ದಿವಸ.
17 ದಿವಸ, ಟೋಟಲ್ 17 ದಿವಸ.
ಹದಿನೆಂಟು 4/20/2012 ನೆಕ್ಸ್ಟ್ 2013 ವರೆಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದು ಏನಾರು ಇದೆಯಾ ದಾಖಲೆ? ಇಲ್ಲ, ಏನಿಲ್ವಲ್ಲ. ಮಾಡಿಲ್ಲ, ಮಾಡಿದೀರಾ? ಎಲ್ಲಿದೆ ಅದೇ ಕೇಳಿ, ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಏನ್ ತೋರಿಸಿ. This is petitioner had taken treatment to the business hospital also admitting by ಈಗ ನೀವು ಈ ಟ್ರೀಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ? 2013 ಇಂದ 24 to 2013 ವರೆಗೆ ತಗೊಂಡಿದ್ರಲ್ಲ, ಅದು ಕೂಡ 4 ದಿವಸ ಅಲ್ರಿ?
4 4 days, 5 days.
BGS ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಮೇಡಮ್. ಯಾವ್ದು BGS ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ ಯಾವ್ದ್ರಿ?
Alert serial number?
Oh, one I nice.
BGS ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ ಯಾವ್ದ್ರಿ? ಹಾಕಿಲ್ಲ ನೀವು?
BGS ರೆಕಾರ್ಡ್ ಹಾಕ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಟ್ಲೀಸ್ಟ್ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಅದ್ರಲ್ಲೂ ಏನಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ರಿ ಮೇಡಮ್ ಮತ್ತೆ?
ಇಲ್ಲ, BGS ಹಾಸ್ಪಿಟಲ್ ಯಾವ್ದು ಹಾಕ್ಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಆಲ್ಸೋ ಇನ್ ದಿ ಹಾಸ್ಪಿಟಲ್ ಫಾರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ 4 days ಅಂತ.
No such document marked, my lord.
Exhibit P22 na.
That is disability certificate, my lord.
So we need to treat it again.
ಬರೀ ಮಂಗಳ ಹಾಸ್ಪಿಟಲ್ ಮಾತ್ರ ಇದೆ ರೀ. BGS ಎಲ್ಲಿದೆ? AJ ಹಾಸ್ಪಿಟಲ್ ರಿಸರ್ಚ್ ಸೆಂಟರ್. ಯಾವ್ದಿಲ್ಲ. Authorization Apollo Hospital.
Such document is not forthcoming from the records marked by the learned, my lord.
ಒಂದ್ ನಿಮಿಷ ಆತರ ಪಡ್ಬೇಡ್ರಿ. Apollo BGS ಅಲ್ರಿ, Exhibit P31. Application non-union of ಇದೆಯಲ್ಲ, non-union of the TBR.
Case sheet
ಇದೆ Exhibit P. ನೀವು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಕೇಸ್ ಶೀಟ್ ಅಂತ ತೋರಿಸಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ BGS ಹಾಸ್ಪಿಟಲ್ ಅಂತ ತೋರಿಸಿಲ್ಲ. ಅದಕ್ಕೆ ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ BGS ಹಾಸ್ಪಿಟಲ್ ನಾವು ಡಾಕ್ಟರ್. ಈ ಕೇಸ್ ಶೀಟ್ ನಲ್ಲಿ ಅವ್ರಿಗೆ ಅಂತ ಸಾಯುವಂತ ತೊಂದರೆ ಆಗಿತ್ತಾ ಏನು?
With above complaint, relevant investigation was done. He underwent external fixator application on the CSC on 21/2/2013. Post-operative period was uneventful. He was treated with so discharged with following advice. Heard the appellant counsel and also the counsel appearing for the respondent. The factual matters of case of claimant before the tribunal that claimants are idರಲ್ಲಿ mother 3561 mother and 2 brothers, brother and sister. The factual matters of case of the claimants before the tribunal that on 6/4/2012 at about 6 a.m. the injured was proceeding in the motorcycle as a pillion rider, and the said motorcycle was driven by Mr. Naveen VV from Kokkada towards Dharmasthala slowly and cautiously, keeping on the left side of the road, observing all the traffic rules. When they reached near Madari Tota cross, at that time Innova car came and dashed against the motorcyclist when they took a sudden right turn. And as a result, Pillan Radon fell down and sustained grievous injuries. Immediately he was and he also sustained the injury of.
One day was submission to Swami. ಇದು ಆಕ್ಚುಲ್ ಆಗಿ ನಾನು ಹಾಕಿದ್ದ ಅಪೀಲು 2016ರಲ್ಲಿ, ಇವ್ರು ಹಾಕಿರೋದು 2021ರಲ್ಲಿ. ಡಿಲೇ ನನಗೆ ಅಪ್ಲಿಕೇಶನ್ ಕಳಿಸಿದ್ದಾರೆ, ವೈಟ್ನರ್ ಹಾಕಿ ಕಳಿಸಿದ್ದಾರೆ. ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿದೆಯಾ ಇಲ್ವೋ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಡಿಲೇ ಏನಾಗಿದೆ ನೋಡ್ರಿ.
4 ವರ್ಷ ಆದ್ಮೇಲೆ ಅಪೀಲ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದು.
Comminuted fracture of right tibia and fibula and other injuries all over the body. Immediately he was shifted to Beltangli Government Hospital, and then he was shifted to Mangalore Hospital and Mangala Kidney Foundation, Mangalore, where he was treated as an inpatient from 6/4/2012 to 11/4/2012. And again he was treated in all. He was an inpatient at the first instance for a period of. He was treated as an inpatient and subjected to surgery. That is, interlocking nailing of right tibia was done, and he was discharged. Later he was shifted to Unity Lifeline Hospital for further treatment, and he was an inpatient. And then again he was admitted to BGS Apollo Hospital since the fracture of tibia and fibula was not united, and also again surgery was conducted. That is, external fixator was done, and he was discharged in the month of February 2013, and he died on 14/6/2013. The contention of the claimant that death is on account of accidental injuries which leads to death, and also the counsel appearing, and also the contention of the insurance company that no nexus to the accidental injuries and cause of death. And hence, and the tribunal, after considering both oral and documentary evidence, allowed the claim petition granting compensation in respect of only pain and suffering and loss of income during laid up period and actual medical expenses and conveyance and food and nourishment charges. The insurance company challenged the said judgment and award, filing MFA, contending that directing the insurance company to pay the compensation amount is an erroneous order, and tribunal committed an error granting an amount of 3,37,396. And it is a case of injury who has filed the claim petition now under appeal. Compensation awarded is also on the higher side. The counsel also vehemently contend that there is no any postmortem conducted in the case on hand, and further no medical records are produced to show that nature of injuries suffered by claimant, and further no expert doctor is examined to prove nexus between the death and injuries. Why you have raised all these grounds? Because compensation is not granted on the ground of loss of dependency. No compensation is awarded. Why you have raised all these grounds?
Me, my lord.
ನೀವೇ ಕೇಳ್ತಾರೆ ನಿಮ್ಮನ್ನೇ.
ಅಯ್ಯೋ ಸ್ವಲ್ಪ ಮಾತ್ರ ಇದರಲ್ಲಿ ನಾನು ಒಂದೇ ಒಂದು ಗ್ರೌಂಡ್ಸ್ ಅರ್ಜಿ ಮಾಡಿರೋ ಬಿಫೋರ್ ದಿಸ್ ಕೊಟ್ಟು ಇಂಜುರಿಗೂ ಡೆತ್ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. 1 ವರ್ಷ 2 ತಿಂಗಳಾದ್ಮೇಲೆ ಸತ್ತಿರುವುದು.
ಆಯ್ತ್ರಿ, ಟ್ರಿಬ್ಯುನಲ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ದಿ ಕಾಸ್ ಆಫ್ ಡೆತ್ ಫಾರ್ ಅವಾರ್ಡಿಂಗ್ ಕಂಪನ್ಸೇಷನ್. ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ತೆ
ಅಲ್ಲ, ಇಂಜುರಿ ಕೇಸ್ ಆಗಿ PW ಅವನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲಪ್ಪನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ದಯವಿಟ್ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ PW ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ, ಗೊತ್ತಾಗುತ್ತೆ ಬದುಕಿರುವಾಗ್ಲೇ.
ರೀ ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಏನು ಅಂತ ಕೇಳ್ದೆ, ಕಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿರೋದಕ್ಕೆ. ಅವ್ರು ಇಂಜುರಿ ಕೇಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದೌದು, ಕರೆಕ್ಟ್.
ಡೆತ್ ಕೊಟ್ಟಿಲ್ಲ.
ಡೆತ್ ಕೊಟ್ಟಿಲ್ಲ.
Why you have filed appeal?
I think, my lord, I'm sorry for the interference, my lord.
ಹೇಳ್ರಿ ಕೇಶವ್ ಪ್ರಸಾದ್.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಇನ್ಫ್ಯಾಕ್ಟ್ AM Venkatesh is my senior, my lord. Just I wanted to disclose one thing. In view of the full bench judgment of Karnataka case as well as Uday Kumar case, my lord, if there was no nexus between injuries and death, and during the pendency of the claim petition, if he died because of not because of injuries suffered, he is not entitled for any compensation. That is what the full bench judgment.
Only medical expenses ಮಾತ್ರ.
Injuries because death because of injuries ಆಗಿದ್ರೆ ಮಾತ್ರ they are entitled for the medical expenses.
ಆಯ್ತ್ರಿ, ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲಿ. ಡೆತ್ ಕಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ.
ಅಲ್ಲ, ಇಂಜುರಿಗೂ ಬರಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಿರೋದು. That is what the full bench judgment. Last time I kindly see the ILR 2002 page 1864, my lord, which is clear, the full bench judgment of the court. That's why, my lord, I think my senior would have
ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಬಂದೇ ಬರುತ್ತಲ್ಲ.
ಇಲ್ಲ, ಇಂಜುರಿ ನೆಕ್ಸಸ್ ಇದ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ.
ಅದು ಇಂಜುರಿ ನೆಕ್ಸಸ್ ಇದ್ದಾಗ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇರ್ತಾನಲ್ಲ.
ಅಲ್ಲ, ನೆಕ್ಸಸ್ ಬಿಟ್ವೀನ್ ಇಂಜುರೀಸ್ ಅಂಡ್ ಡೆತ್, ದೆನ್ ಓನ್ಲಿ ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ದಿ
ಡೆತ್ ಬಿಟ್ಬಿಡ್ರಿ, ಇವನು ಹಿ ಹ್ಯಾಸ್ ಸಸ್ಟೈನ್ಡ್ ದಿ ಇಂಜುರಿ.
ಬರಲ್ಲ.
ನೆಕ್ಸಸ್ ಇಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಯಾವಾಗ
ಇಲ್ಲ, ಎಂಟೈರ್ ಪೆಟಿಷನ್ ವಿಲ್ ಬಿ ಅಬೇಟ್.
ಇದಕ್ಕೆ
ಹೌದು, ದಟ್ ಇಸ್ ವಾಟ್ ದಿ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್.
Because of accident only he was shifted to the hospital. He has suffered.
With due respect, my lord, with due respect,
expenses entitlement ಇದೆಯಾ ಇಲ್ಲ?
ಇಲ್ಲ. ILR 2002 page 1864, my lord, last me kindly see the judgment. That's why I think, my lord, my senior would have filed this appeal.
ಇಲ್ಲ, ಪ್ಯಾರಾ ನಂಬರ್ 7 ಒಂದು ಪೇಜ್ 12 ಅಲ್ಲಿ ನಮ್ಮ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ 2 ಜಡ್ಜ್ಮೆಂಟ್ ಕೋಟ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು. ಈ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ತಗೋಬೇಕು.
ILR 1990 page 4300, then it is referred to the larger bench, my lord. ILR 2002 1864 only it was, my lord, held that if there is no nexus between injuries and death, then my lord, entire petition will be abated. That is what the, my lord, the full bench judgment.
I have urged that ground at para 7 page 12 of my appeal.
Para 7 ಅಲ್ಲಿ ಇದೆ.
That is the judgment of full bench. If there is a nexus between injuries and death, my lord, he is entitled for the medical expenses and loss to estate. They are not entitled for loss of dependency. Legal heirs can prosecute the case, but not to the loss of dependency. It is only about, my lord, the loss to estate and medical expenses. That is what.
Last sentence ಏನು ಹೇಳಿದೆ ನೋಡಿ.
Conducted and no medical records that
The tribunal has rightly comes to the conclusion that breathlessness suffered by him is independent of the injuries sustained in the accident and erred in granting compensation to the claimants, treating the same as if it is a case of injuries. The said finding of the tribunal is erroneous and ought not to have granted compensation to the tune of rupees 3,37,396. It is also contended that claimants have failed to prove nexus between death and injury and ought to have held that they said Yellappa suffered a natural death and hence awarding of compensation of rupees 3,37,396 is erroneous. It is also contended that the full bench of Honorable High Court in Kannamma's case reported in ILR 1990 page 4300 and Uttam Kumar's case reported in ILR 2002 page 1864, wherein it is categorically held when a claim petition is filed for grant of compensation on account of injuries suffered in the accident and the injured oblique claimant dies independent of the injuries suffered in the accident, the claim petition itself is unsustainable. And hence granting of compensation of rupees 3,37,396 is erroneous. Next para. The counsel appearing for the ಏನಾರು ಹೇಳೋದಿದೆಯಾ ಹೇಳಿ. ಈ ಕೇಸಲ್ಲಿ the counsel appearing for the claimant would contend that accident was occurred on 6/4/2012 and he was an inpatient in different hospital for a period of 17 days. And he had suffered the fracture of tibia and fibula. and the fracture was not united. Once again, he was admitted to the hospital in BJS hospital, and again he was subjected to surgery in the month of February 2013. He died in the month of June 2013, and hence it is clear that from the date of accident he was in continuous treatment in the hospital for the injuries which he had sustained. Even though counsel would submit that no postmortem is conducted and report is filed, the court has to take note of material available on record. In support of his argument, he relied upon the judgment of the apex court, first in criminal appeal number 4800 of 2021, wherein the apex court, in the absence of PM report and PM report, and taking note of the nature of injuries, and the injured also resigned his job, and the same has been considered, and allowed the claim petition by setting aside the order of the High Court, and hence the said judgment is aptly applicable to the case on hand. The counsel also would submit that the trial court also, considering the judgment of Karnataka's case, considered the compensation toward any discussion. ಯಾವ್ದು ನೀವು ಹೇಳ್ತಾ ಇರೋದು? ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರೆ? ಇಂಪ್ರೂವ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ, ಎಲ್ಲಿದೆ ಅದು? ಪೋರಾ ನೀವು ಕೊಟ್ಟ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ. The counsel also brought to notice of this court paragraph number 4 of the judgment of the apex court, wherein the Kandamma case also discussed, and also Uttam Kumar judgment was also considered, and also relied upon the judgment of Rajkumar's case in a case of injury.
There are 5 may kindly be.
There are 6 also, 5 and 6.
5 only. Injured has suffered 100% physical disability adral a case allo, which my lordship has referred. Para 6 alli kuda no my lord. He suffered final shock with cervical cord injury, quadriplegia with respiratory failure. That professor was working in Punjab University. The case was referred here. This no physically it not applies to the case on hand, my lord. This is only a simple injury, a fracture of tibia and fibula. And the Honorable Supreme Court pays it to 100% motor system disability. In this case, they have not examined the doctor also. There are 9 kuda my lordships of the apex court as very clear. Such claims of personal injuries would undoubtedly abate with the death.
Kandamma case discussed in paragraph number 16. The view taken in Kandamma and Uttam Kumar that the claim would abate is based on a narrow interpretation of the act. It does not command to us. Anta bardiದ್ದಾರೆ. The reason of the Gujarat High Court is more in consonance with the aim, purpose, and spirit of the act. Further, it is intent and purpose which we therefore approve.
I agree with you. Correct.
Kannamma's judgment and Uttam Kumar's judgment.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಒಪ್ಪಲಿಲ್ಲ ಕರೆಕ್ಟ್ ಏನೇನೆ ಬಟ್ ಅದರಲ್ಲಿ 100% ಫಿಸಿಕಲ್ ಡಿಸಬಿಲಿಟಿ ಇದೆ ವೀಲ್ ಚೇರ್ ಅಲ್ಲಿ ಹೋಗ್ತಾನೆ ಇವ್ರು ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮ್ ಮಾಡಲ್ಲ ಪಿಎಂ ಮಾಡಿಲ್ಲ
Judgment which referring the judgments and also given finding in paragraph number 16 of the judgment of the apex court, wherein the apex court categorically observed that interpretation in Kannamma case and Uttam Kumar case based on a narrow interpretation of the act which does not command to us, and hence the very contention of the insurance company cannot be accepted. Having heard the ನೀವು ಮತ್ತೇನೋ ಇದು ಹಾಕಿದ್ರ ಒಂದು ಇನ್ನೊಂದೇನು ಇಲ್ಲ ಕಂಡೋನ್ ಆಗಿದೆಯಾ 149 days
ಅಲ್ಲ 149 ಅಲ್ಲ ಮೈಲಾಡ್ ಸಾರಿ ಮೈಲಾಡ್ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ನಾನು ಹಾಕಿದ್ದ ಅಪೀಲು 16ರಲ್ಲಿ ಇವರು ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿರೋದು 21ರಲ್ಲಿ
21 ಕ್ರಾಸ್ ಅಪೀಲ್
ಹೌದು ಸ್ವಾಮಿ ಕ್ರಾಸ್ ಅಪೀಲ್ 21ನೇನೆ 149 days ಪ್ರಶ್ನೆ ಬರುವುದೇ ಇಲ್ಲ ಮೈಲಾಡ್
ಆಯ್ತ್ರಿ ನೀವು ಸರ್ವ್ ಮಾಡಿರೋದು ಯಾವಾಗ ಹೇಳಿ ಫಸ್ಟ್ ಅದರ್ ಸೈಡ್ ಸರ್ವ್ ಆಗಿರೋದು ಯಾವಾಗ್ರಿ
ಸ್ವಲ್ಪ ಸರ್ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್ ಇಂದ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಗುತ್ತೆ ಸರ್ ನಾಟ್ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ದಿ ಅಪೀಲ್
ಅಲ್ಲ ಸರಿ
ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ
ಸರಿ ನೋಟಿಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ಅದರ್ ಸೈಡ್ ನೋಟಿಸ್ ಆಗಿದ್ರೆ ಹೌ ಇದು ಲಿಮಿಟೇಷನ್ ರನ್ಸ್ ನೀವು ತಗೊಂಡಿರೋದೇ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇನ್ ದ ಇಯರ್ 2020 appeal. Date of service 30 days they have to file an appeal, cross objection. ಹೌದಲ್ಲ
ಅಲ್ಲ ಸರಿ ಅದು ಸರಿ
other side how you can contend that barred by limitation. Only after 30 within 30 days they have to file the cross objection, that's all, from the date of service. Madam, the claimant also filed cross objection contending that the tribunal committed an error in not considering the nature of injuries and also he was in further treatment. But also filed cross objection challenging the judgment and award of the tribunal. Having heard the respective counsel and also on perusal of material available on record, the point that would arise for the consideration of this court are whether the tribunal committed an error in awarding compensation of rupees 3,37,000 396 in MEC number 3561 of 2012. Whether the tribunal committed an error in not awarding the compensation considering the accidental injuries led to the death of the victim as contended in the section. Whether it requires interference of this court, what order? Having heard the respective counsel and also on perusal of material available on record, it is not in dispute that an accident was occurred on 6/4/2012. The wound certificate which is produced before the court also discloses that he has suffered several injuries, and out of that one injury is comminuted fracture of tibia and fibula, and immediately he was shifted to the different hospital. He was an inpatient for a period of 6 days and again 6 days, and also he was an inpatient for a period of 5 days in the month of February 2013. The material clearly discloses that he was in continuous treatment for the accidental injuries, and nature of injuries also in terms of exhibit P3 discloses that he has suffered comminuted fracture, and also other document exhibit P14 wound certificate and discharge summary also discloses that he was an inpatient from 6/4/2012 to 11/4/2012 at the first instance for a period of 6 days, and again he was admitted to hospital on 13/4/2012 to 18/4/2012 for a period of 6 days. And Unity Lifeline Hospital from 20 to 2013 to 24 to 2013. That is for 5 days at Apollo BGS Hospital. In total is 17 days. The records reveals that he was in continuous treatment from the date of the accident, and he was an inpatient for a period of 17 days in 3 spells. And also the records exhibit P31 of the case sheet of BGS Hospital, in which he took the treatment in the month of February, discloses that fracture was not united, and hence once again he was admitted to hospital and he was subjected to surgery in the month of February 2013, and he died in the month of June, and hence it is clear that he was in continuous treatment from the date of accident, and also the accidental injury was not united, and during the month of February he was subjected to surgery of external fixator on account of non-union of the fracture of tibia and fibula, and hence the very contention of the insurance company that no nexus to the accidental injuries and he was in continuous treatment cannot be accepted. The other contention of the insurance company that documents which have been relied upon by the claimant doesn't disclose that he took the treatment continuously, and there was a gap from 24 to 2013 to 14/6/2013, and in between no documents are produced. The fact that he was subjected to surgery once again in the month of February 2013 is not in dispute, and though counsel contend that no document is produced with regard to the subsequent treatment taken at the BGS Hospital, and document exhibit P31 case sheet clearly discloses that he took the treatment in the month of February 2013. And no doubt, in the absence of PM report, the court has to caution whether the accidental injuries led to the death of a person. Having considered the continuous treatment and the accidental injury was not united, and he has suffered the comminuted fracture of tibia and fibula, which led him to go to hospital and take the treatment in 3 spells. And when such material available on record, even not examining the doctor is not a ground to disbelieve the case of claimant. Hence, having considered the material available on record, and apart from that also the respondent insurance company not examined any witnesses before the tribunal. But the fact is that when he had sustained injury and he was an inpatient in 3 spells and continuous treatment, the very contention that no nexus to the accident and nature of injuries and cause of death cannot be accepted. However, tribunal committed an error in considering the case for injury by awarding compensation towards pain and suffering, loss of income during laid-up period, and actual medical expenses, conveyance, attendance charges, food and nourishment, and diet charges. And tribunal committed an error in considering the documents of continuous treatment from 6/4/2012 to 2013. And within a span of 3 months, the 4 months, 24 within a span of 3.5 months of final surgery conducted, he died. And hence it is a case for considering the case for awarding compensation for the death. The judgment laid upon by the claimant counsel that the apex court also considered the similar circumstances when there is no any PM report and doctor evidence is also applicable to the case on hand. But counsel appearing for the insurance company would contend that that is a case of 100% disability. But in the case on hand, the continuous treatment is not disputed. And also, I have already pointed out that the injured who had sustained the injury to the tibia and fibula, and the same was not united, and the same was malunited, and hence he was subjected to surgery in the month of February 2013. When such being the case, and when the medical records clearly disclose us that he was in a continuous treatment, the very contention of the insurance company that only in a case of 100% disability, court can consider the case of death cannot be accepted. The court only to take note of the material available on record in total, whether the injured had suffered the injury in the accident and whether that injury led to the loss of his life also to be taken note of. And I have already pointed out when he has been in continuous treatment in 3 spells and even just 3 months prior to the death, he was also subjected to surgery and executor was done in respect of his accidental injuries. And hence, the very contention of the insurance company cannot be accepted. Now, coming to the aspect of quantum of compensation is concerned, the deceased was aged about just the age of 26 years, and accident was occurred in the year 2012. And notional income would be rupees 7,000. And having considered his age, 40% has to be added as future prospectus. If it is added, hmm? 9,800. Bachelor, and the claim injured is a bachelor, and claimants are mother and younger sister and brother. And hence 1/3 has to be deducted. One 1/3 bachelor, and 50% has to be deducted towards personal expenses. Having deducted 50% and applying the relevant multiplier of 17, it comes to rupees 99,600. And claimants are the mother and also the younger sister and brother. They are entitled for compensation of rupees 40,000 each on the head of love and affection. Love and affection in all 1,20,000. Wife and sister and brother. Sorry,
mother, brother or sister.
1,20,000. Claimants are also entitled for 33,000 on the head of funeral expenses and loss of estate. In all, entitled for compensation of rupees or medical expenses. Entitled for compensation of rupees so and so. Apart from that, the claimants have also filed medical expenses to the tune of rupees 1,36,396. With regard to the treatment which they have taken in 3 spells in different hospitals, and the same is also based on the documentary evidence, and hence they are entitled for an amount of rupees 1,36,396. In all, claimants are entitled for compensation of rupees 1,88,996. We have discussions made by Masti Palangwada. Appeal filed by the insurance company is dismissed, and cross objection filed by the
delay delayed itto.
Delay condone ಮಾಡಿದೆ only 149 days.
Sorry sir.
Without any conditions. No, with 6% interest. The insurance company is directed to pay the compensation amount within 6 weeks. The registry is directed to transmit the records forthwith. The amount in deposit made by the insurance company is also ordered to be transmitted to the tribunal forthwith.
That's kindly, my lord. 42 ಡಾಕ್ಟರ್ ಸಮನ್ ಮಾಡಿದ್ರು ಸರ್.
ಡಾಕ್ಟರ್ನ
ಸಮನ್ ಮಾಡಿದ್ರು ಸರ್. 42 ಅಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಏನು ಗೊತ್ತಿಲ್ಲ.
ಬಂದಿದ್ದಾರಾ ಡಾಕ್ಟರ್? ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿದೆಯಾ? ಯಾರು ಬಂದಿದ್ದಾರೆ? ಏನಂತ ಈಗೇನ್ ಮಾಡ್ತಾರೆ? ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರ ಏನು ಬರ್ಲಿಕ್ಕೆ? ಯಾವಾಗ ಬರ್ತಾರ? ಬರ್ದವ್ರು ಬರ್ಸಕ್ ಗೊತ್ತು, ಸುಮ್ನೀರ್. ನೀವ್ ಸುಮ್ನೀರ್, ನೀವ್ ಯಾಕೆ ಭಯ ಆಗ್ತೀರಿ? ವೇರ್ ಇಸ್ ಯುವರ್ ಡಾಕ್ಟರ್? ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್. ಸ್ಟೇಷನ್ ಅಂದ್ರೆ ಎಲ್ಲಿ? ಅರೆ ಅಪ್ಪ, ಯಾವತ್ ಬರ್ತಾರಪ್ಪ ನಿಮ್ ಡಾಕ್ಟ್ರು? ನಮ್ಗೆ ಇವತ್ತಿಗೆ ಬರಕ್ ಹೇಳಿದ್ದು. ಇವತ್ತೇ ಇರ್ಬೇಕು ಡಾಕ್ಟರ್ ಅಂತ ಹೇಳಿದ್ದು. ಯಾಕೆ ಬಂದಿಲ್ಲ ಡಾಕ್ಟರ್? ಎಲ್ಲೋಗಿದ್ದಾರೆ? ಕೋರ್ಟಲ್ಲ ಹಾ ದುಡ್ಡೆಲ್ಲಿ ಬರುತ್ತೋ ಅಲ್ಲಿಗೆ ಹೋಗಿದಾರಾ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ಕೆ ಹೌದಲ್ಲ ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ ಕೇಸ್ ಮಂಗಳೂರಿಗೆ ಹೋಗಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ ಹೋಗಿದಾರ ಹೌದಲ್ಲ ಆಯ್ತು ಯಾವ್ದು ಜನಪ್ರಿಯ ಹಾಸ್ಪಿಟಲ್ ಅವ್ರು ಬರ್ದಿರೋದು ನಾವು ಸಮನ್ ಮಾಡಿದ ಯಾರಿಗೆ ಡಾಕ್ಟರ್ ಯಾರು ಅಬ್ದುಲ್ ಬಶೀರ್ ಅಲ್ವಾ
ಮಂಗಳ ಹಾಸ್ಪಿಟಲ್
ಆರ್ಥೋಪೆಡಿಕ್ ಸರ್ಜನ್ ಜನಪ್ರಿಯ ಹಾಸ್ಪಿಟಲ್ ಹಾಸನ್ ತೊಳೆ ಆಯ್ತು The representative of Janapriya Hospital appeared on short time on behalf of the Dr. Abdul Bashir, wherein Dr. Abdul Bashir, in his letter dated 8/12/2022, see for need to go to Mangalore to attend the court, as it is second time they are given date as per his request, and then time is granted and directed him to appear before this court on
12
ಡಾಕ್ಟ್ರಿಗೆ ಕೊಡ್ಬೇಕ್ರಿ ಟೈಮು ನಿಮ್ಗಲ್ಲ
ಅಲ್ಲ ಎಲ್ಲ ಎಲ್ಲರೂ ಡೇಟ್ ಅವ್ರು ಕೊಟ್ಟರೆ ಯಾಕಂದ್ರೆ ನಾನು ಥರ್ಸ್ಡೇ ಟ್ಯೂಸ್ಡೇ ಮೀಡಿಯೇಷನ್ ಡೇ ಇದೆ ಅಂತ
ಚೇಂಜ್ ಆಗ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ
ಅದರ ಮೀಡಿಯೇಷನ್ ಡೇ ಏನಿದೆ
ಆಯ್ತು ಮೀಡಿಯೇಷನ್ ಡೇ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು 14th
14 ಕೊಟ್ರೆ
14 ಆಯ್ತು 14 to let him come at 10:30 no sitting in the afternoon, let him come in the early morning. ಆಯ್ತು
ಅವತ್ತೇ 39
24 ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ಇಲ್ವಾ
I am appellant, my lord, in this case connected.
ಬೆಳಗ್ಗೆನೇ ಇರ್ತಲ್ಲ ಅವರು ಆಯ್ತು ಆಯ್ತು ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಅಬ್ಸೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಯಾವ್ದೋ ಒಂದು ಕ್ರಿಮಿನಲ್ ಒಂದು ಪಾಸ್ ಓವರ್ ಆಗಿರ್ಬೇಕಲ್ಲ ತಗೊಂಡು Wednesday also only in the early morning. Early morning. Afternoon. Whole next week, no sitting in the afternoon. When your senior counsel is free. Kumar. Sorry, account. Serial number is madam? 73. The petitioner counsel seeks time on the ground that senior counsel is engaged. But hence, ನಾಳೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಆಗೋಗ್ಬಿಟ್ಟಿರ್ತೇನಲ್ಲ ಆಗಿಲ್ವಾ and hence this matter tomorrow. ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಬೇರೆ 5-6 ಮ್ಯಾಟರ್ ಇದೆ ಅಂತಿದ್ರು 2:30 ಹಾಕಕ್ಕಾಗಲ್ಲ 2:30 ಅಲ್ಲೇ ಇರುತ್ತಲ್ಲ ಆಫ್ಟರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಷ್ಟೇ ಆಫ್ಟರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಂತ ಹಾಕ್ಸಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಂತ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಬಂದು ಟೈಮ್ ಇದ್ರೆ ಮಾಡಿ ಟುಮಾರೋ ಆಫ್ಟರ್ನೂನ್ ಆಫ್ಟರ್ ದಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಕೇಶವ ಪ್ರಶಾಂತ್ ನಿಮ್ದೇ ರೀ ಕೇಶವ ಪ್ರಶಾಂತ್ ಶಶಿಧರ್ ಫಾರ್ R1 ಇದಿರಲ್ಲ ಹೇಳಿ
ಲಯಬಿಲಿಟಿ ಮಲಾಡ್ ಇಸ್ ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್
ಇಬ್ರದ್ದು ಇದೆ ಅಪೀಲ್ ಲಯಬಿಲಿಟಿ ವಾಟ್ ಇಸ್ ದ ಗ್ರೌಂಡ್
ಬಟ್
not in the cabin and he was sitting in the carriage of the
goods
lorry which was completely loaded with cotton bales in a dangerous position, which makes clear that it is a clear violation of terms and conditions. This is one of the ground honest
unauthorized passenger, that is the two grounds for diverged.
He was an unauthorized passenger anta.
There was no employer-in-employer relationship, my lord. The claim petition is filed before the commissioner for full compensation.
ECA.
ಹೌದು, ECA.
Then in any other ground, only the liability.
That is the main thing, my lord. The employer-in-employer relationship, unauthorized passengers.
Any other grounds are urged, counsel?
Rule 100. These are the 3 grounds, my lord, which I have asked.
Only with regard to the liability.
Only
ಹೌದಾ?
yes, my lord.
Loader. Loader and unloader in the lorry. You already examined. Driver examine ಮಾಡಿದಿರಾ? Employee ಮಾಡಿದಿರಿ. He was also along with the injured at the time of the accident, PW2. 28 of this judgment. The doctor who has been examined as PW2 has deposed categorically in his evidence that claimant requires an attendant and also considering 100% visibility. Then 28 ಅಲ್ಲಿ ಏನಿದೆ? ಆಯ್ತು. ನಮ್ಮ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಯಾವಾಗ ಆಗಿರೋದು? ಸೆಪ್ಟೆಂಬರ್ 29, 2020. ಆಯ್ತು. ಎನೌನ್ಸ್ಮೆಂಟ್ ಇದೆಯಾ? 2012 ಎಷ್ಟು ತಗೋಬೇಕಿತ್ತು ನಿಮ್ ಪ್ರಕಾರ? 2012 ಅಲ್ಲಿ ಅಮೆಂಡ್ ಆದ್ಮೇಲೆ 8,000 ಅಂತ. 9 ಕೊಟ್ಟಿದ್ದಾರೆ. Only those grounds. ಇದೆಷ್ಟಿದೆ? ಫ್ಯಾಕ್ಟರ್ಸ್ ಎಷ್ಟೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ ಅಂದೆ. ಏನ್ ಫ್ಯಾಕ್ಟರ್ಸ್ ಹೇಳ್ರಿ? 28 years. 211.79 ನೋಡಿ. ಇದು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರಲ್ಲ, ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. RW1 ಪ್ಯಾಸೆಂಜರ್ಸ್ ಅಂತ. Statutory liability ಬರುತ್ತೆ goods vehicle 147. Heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the judgment and award passed in PCA number 9.
ನಾನೊಂಚೂರು
ಹೇಳಿದ್ನಲ್ಲ ನಿಮ್ಮನ್ನ
ಇಲ್ಲ
ಕೇಳಿದೆ
ನೀವು ಅದ ಲಯಬಿಲಿಟಿ ಅಂತ ಹೇಳಿದ್ರು ಹ್ಞೂ ಅಂತೆ ಅಷ್ಟೊತ್ತಿಗೆ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಶುರು ಮಾಡಿದ್ರು.
ಇಲ್ಲ ನೀವು ಮೂರ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಲಯಬಿಲಿಟಿ ಒಂದೇ ಅನ್ನೋದಕ್ಕೆ ನೀವು ಕೇಳಿದ್ದೀನಿ ರಿಪ್ಲೈ ಇದೆಯಾ?
ಇದೆ ರಿಪ್ಲೈ ಇದೆ ಅಲ್ಲ ಇದರಲ್ಲಿ on the same issue my lord one more judgment is passed by this honorable court last week ಅಲ್ಲಿ ನನಗೆ ಒಂದು 2-3 days ಟೈಮ್ ಕೊಡ ಅದಿನ್ನು ಸ್ಕ್ಯಾನ್ ಆಗಿಲ್ಲ ಜಸ್ಟ್ ಐ ಆಮ್ ವೇಟಿಂಗ್ ಫಾರ್ ದಟ್ ಬಂದ್ರೆ ನಾನು ಸೇಮ್ ಇಶ್ಯೂ my lord
ಅದು 147 ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ
ಸೇಮ್ ಇಶ್ಯೂ he was traveling on the carriage
ಬರುತ್ತೆ ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಹಿಂದೆ 147 ಅಲ್ಲೇ ಬರುತ್ತೆ ಲಯಬಿಲಿಟಿ ಅಂತ ಬರ್ದಿದ್ದೀನಿ
ಖಂಡಿತ ಅದ್ರಲ್ಲ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ಲಯಬಿಲಿಟಿ ಬರುತ್ತೆ ಬಟ್ ಟ್ರಾವೆಲಿಂಗ್ ಫ್ರಮ್ ಒನ್ ಪ್ಲೇಸ್ ಟು ಅನದರ್ ಪ್ಲೇಸ್ ಅಂಡ್ ಟ್ರಾವೆಲಿಂಗ್ ಆನ್ ದಿ ಕ್ಯಾರೇಜ್ ಗೂಡ್ಸ್ ಆಫ್ ದಿ ಟಾಪ್ ಆಫ್ ದಿ ಗೂಡ್ಸ್ ದೀಸ್ ಆರ್ ದಿ ಥಿಂಗ್ಸ್ ಇಶ್ಯೂಸ್ ರೈಸ್ಡ್. ಸೊ ಅದಕ್ಕೆ ಆಗಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಸ್ಕ್ಯಾನ್ ಆಗಿಲ್ಲ ಜಸ್ಟ್ ಐ ಆಮ್ ವೇಟಿಂಗ್ ಫಾರ್ ದಟ್ ಅದು ಬಂದ್ರೆ
ಸ್ಕ್ಯಾನ್ ಆಗದೆ ಇರೋ ಚಾನ್ಸೇ ಇಲ್ಲ ನನ್ನ ಹತ್ರ
ಲಾಸ್ಟ್ ವೀಕ್ ಆಯ್ತು
ಲಾಸ್ಟ್ ವೀಕ್ ಆದ್ರೆ ಎಲ್ಲ ಸ್ಕ್ಯಾನ್ ಆಗಿರುತ್ತೆ
ಅಲ್ಲಲ್ಲ ತಮ್ಮ ಮುಂದೆ ಅಲ್ಲ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಬೇರೆ ಕೊಡ್ದ
ಹೌದೌದು ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದಕ್ಕೆ ನಾನೇ ಮಾಡಿರೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನೇ ಅದಕ್ಕೆ ಅಗೇನೆಸ್ಟ್ ಆಗಿ ಈಗ ಜಸ್ಟ್ ನೋಡ್ಬೇಕು
ಆಯ್ತು ಡಿಕ್ಟೇಷನ್ ಪೋಸ್ಟ್ಪೋನ್ ಮಾಡೋಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವತ್ ಬೇಕು
ನನಗೆ ನಾನು ದಿನ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಜಡ್ಜ್ಮೆಂಟ್
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ನೀವು ಕೇಳಿದ ದಿವಸ ಕೊಡ್ತೀನಿ ಯಾವತ್ ಬೇಕು ಬಟ್ ಬಿಫೋರ್ ವೆಕೇಶನ್ ಅದಕ್ಕಿಂತ ವೇಟ್ ಮಾಡಕ್ಕಲ್ಲ
ಒಳಗಡೆ ಆಗುತ್ತೆ ಅನ್ಸುತ್ತೆ ಅದ್ರ ಜಾಸ್ತಿ ಇಲ್ಲ
ಆಯ್ತು 15
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಆನ್ ದಟ್ ಟೈಮ್ ವಿಲ್ ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟರ್
ಅಡಿನ್ ಪಾರ್ಟ್ ಅದೇನ್ ಜಡ್ಜ್ಮೆಂಟ್ ತಂದ್ಕೊಡಿ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಡ್ತೀನಿ
ಅಲ್ಲ ರಿಸರ್ವ್ ಮಾಡ ನಾನು ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಕಸ್ಮಾತ್ ಅವತ್ತು ಸ್ಕ್ಯಾನ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟರ್
ಆಯ್ತು ಅಡಿನ್ ಪಾರ್ಟ್ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ 15-12 ಆಯ್ತು ಸಾಕು 447 ಬೇಡ ಇದೆ ಒಂದೇ ನಿಮಿಷ MFA ನಂಬರ್ ಹೇಳಿ 7502 ಆಯ್ತಾ ನೋಡಿ ಮೇಡಮ್ ಇದು ನೋಟ್ಸ್ ಇಟ್ಕೊಡಿ 32 ಯಾವ್ದು ಡಿ ಮಂಜುನಾಥ್ ಅಂತಿದೆ NR ರಂಗೇಗೌಡ ಅಂತಿದೆ ಇದು ಯಾರು ಈಗ ವಕಾಲತ್ ಯಾರಿಗೆ ಅಲ್ಲ ಇವ್ರಿಬ್ರಲ್ಲಿ ಅಪಲೆಂಟ್ ಯಾರು ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾರು ಯಾರ ಹೆಸರು ಡಿಲೀಟ್ ಆಗ್ಬೇಕ್ರಿ ಮಂಜುನಾಥ್ ಅವ್ರು ತೆಗಿಬೇಕಾ? ಹಾಗಾದ್ರೆ ತಗೊಳ್ಳಿ. ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಡಿಲೀಟ್ ದಿ ನೇಮ್ ಆಫ್ ಕೌನ್ಸಲ್ ಡಿ ಮಂಜುನಾಥ್ ಸಿನ್ಸ್ ಎನ್.ಆರ್. ರಂಗೇಗೌಡ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ವಕಾಲತ್ ವಿತ್ NOC 32. List this new respondent counsel is present. List this matter after winter vacation.
39 after vacation ಮಾಡಿ.
Like ಒಂದೇ ನಿಮಿಷ ಎಲ್ಲ ಬಿಟ್ಬಿಡ್ತೀನಿ. ಈಗ ಎಲ್ಲಿವರೆಗೆ ಆಯ್ತು ಮೇಡಮ್ ಇದು? 29 ಏನಾಯ್ತು? ಆಯ್ತು ಎಲ್ಲ ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಅವ್ರದ್ದು ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಆಯ್ತಾ. 31 ಸೀತಾರಾಮ್ ರಾವ್ ಎಲ್ಲ ವಿಂಟರ್ ವೆಕೇಶನ್ ಆಫ್ಟರ್. 33 ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಪಾಟರ್ಡ್ ಆದ್ರೆ ನೆಕ್ಸ್ಟ್ 15-12. 35 ರಘು. ಸೋದೆ ಗ್ರೌಂಡಾ? ಬಟ್ ಇವ್ರು ಕ್ವಾಂಟಮ್ ಇಲ್ವಾ? ಆಮೇಲೆ ನೋಡೋಣ ಬಿಡಿ. ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಎವಿಡೆನ್ಸ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬೇಕಾದ್ರೆ ಹಾಕಿ 15-12 ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್ ಆದ್ರೆ. 36 ರವಿ ಸಂಪ್ರತಿ.
I represent the appellant.
after winter vacation.
ಅದು ಹೆಂಗಿದ್ರು ವಜಾ ಆಗ್ಬೇಕು ಅಪೀಲ್ ಅಷ್ಟೇ.
ಮತ್ತೆ ಅಪೀಲ್ ಆಗ್ಲಿ ಈಗಲೇ ವಜಾ ಮಾಡ್ಬಿಡ್ಲಾ?
ಇವತ್ತು ಬೇಡ. 14th ಹಾಕೊಂಡ್ಬಿಡಿ. 14th
ಆಯ್ತು. ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ 37.
Appear for appellant in this case.
37 ಗಿರೀಶ್ ಬಿ ಬಳದಾರೆ, DS ಶ್ರೀಧರ್ ಇದಾರ ಯಾರು? ಇಲ್ಲ. ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ 38 ಶಶಿಧರ್ ಯಾರು?
ಹಲೋ.
ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಅಡ್ಮಿಷನ್ಸ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಇನ್ಯಾರ ಏನು ಸಬ್ಮಿಷನ್ ಇದೆ ಏನಾರು? 39 2013 ಅಡ್ಮಿಷನ್. ಆಯ್ತು ನೋಡೋದು ಕೊಟ್ಟಿದ್ದು ಡೇಟ್ ಯಾವ ತರ ಆಗೋದಿಲ್ರಿ. ಹಾಫ್ ಡೇ ಇದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ.
ಗುರುವಾರ ಅಥವಾ ಸ್ವಾಮಿ ಅದುವೇ ಬುಧವಾರ ಅಥವಾ ಸೋಮವಾರ.
ಇದ್ರಲ್ಲೂ ಗುಣಶೇಖರ್ ಇದಾರ?
ಹೌದು ಸ್ವಾಮಿ.
ಯಾವ್ದು? 14 14-12 ಆಯ್ತು. 40 ಚಂದ್ರಶೇಖರ್ ಎಲ್ ಎಲ್ಲ ಆಫ್ಟರ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. ಯಾರೋ ಇದ್ದಾರೆ ಮೆನ್ಷನಿಂಗ್ ಮಾಡೋದು ಇದೆಯಾ ಇದ್ರಲ್ಲಿ ನೋಡಿ. 43 ಏನಾಗ್ಬೇಕು ಹೇಳಿ? ಸ್ಮಾಲ್ ಅನೌನ್ಸ್ಮೆಂಟ್. R1 ಅನ್ಸರ್ವ್ಡ್ ಅಂಡ್ ಸಮನ್ಸ್. ಅದು ಯಾರು ಅಪೇರ್ ಆಗಿಲ್ವಾ ಅದ್ರಲ್ಲಿ? ಆಗಿಲ್ವಾ? ಆಯ್ತು 15-12. ಬಾಕಿದೆಲ್ಲ ಕರೆಯೋದು ಬೇಡ ಮೇಡಮ್. ಯಾರಿದ್ದಾರೆ ಅವ್ರು ಕೇಳೋಣ, ಕೊಡೋಣ ಡೇಟ್ ಏನಾರು ಯಾವ್ದಾರು ಇದ್ರು. ಹೇಳ್ರಿ ಏನು? ಒಂದು ಡಿಸ್ಮಿಸಲ್ ಆಮೇಲೆ ಬರ್ತೀನಿ. ಬೇರೆ ಇನ್ಯಾರು ಇದಾರ ಸಬ್ಮಿಷನ್ಸ್? ಇಲ್ಲಲ್ಲ? ಹೇಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಬನ್ರಿ. ಏನಾಯ್ತು? PNP ಆಯ್ತಲ್ಲ ಅದಾ? ಎಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿ? ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ರಿ? ನಾಳೆ ಹಾಕ್ತೀರಾ? ಇವತ್ತು ಹಾಕ್ಬೇಕು, ನಾಳೆ ಹಾಕೋದಲ್ಲ. ಆಯ್ತು. ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? PF ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೋರ್ಟ್ ನೋಟಿಸ್ ಯಾಕೆ ಬಂತು ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ? ಈಗ ಓನ್ಲಿ ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಬೇಕಾ? ನೆಕ್ಸ್ಟ್ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಇವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿತ್ತು. ಆಯ್ತು, ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರ್ಕೊಳ್ಳಿ. ದಿ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ರಾಜೇಂದ್ರ KR appears and seeks time to final hearing. 6 time. Let's list this matter immediately after Dasara vacation. ಅಲ್ಲ winter vacation. ಅದು ಡಿಸ್ಮಿಸಲ್ ಇತ್ತಲ್ಲ, ಮಾಡೋದು ಬೇಡ, ಬರೆಯೋದು ಬೇಡ ಅಂತ ಹೇಳಿ. On behalf of appellant counsel, on behalf of appellant counsel appeared and seeks time ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರ್ಬೇಕು, ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇನಾ?
after vacation, sir.
68 ಎಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Okay, much of it.
ಯಾವುದು ಆಫ್ಟರ್ ವೆಕೇಶನ್? ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹಾಕುವಾಗ 230 ಅಂತ ಹಾಕ್ಬಾರ್ದು. ಹಂಗ ಹಾಕ್ತಾರಾ? 230 ಆಫ್ಟರ್
completion division.
ಇವತ್ತೇನು ಫುಲ್ ಡೇ ಆದ್ರೂ ಇವತ್ತು ಬರೀ ಎಲ್ಲ ಕಾಂಪ್ಲಿಕೇಟೆಡ್. ನಾನೇನು ಫುಲ್ ಡೇ ಇರುತ್ತೆ, ಒಂದು 20 ದಾಟ್ಬೋದು ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೆ. 11ಕ್ಕೆ ನಿಂತ್ಕತಾ ನೆನ್ನೆ ಹಾಫ್ ಡೇನೆ 13 ಮಾಡಿದ್ವಿ. ತರ್ಲಕ್ಕೆ ಕೇಸ್ಬೇಡ ನಮ್ಮ ಮುಂದೆ ಬರೋದು.
Court officer.
Madam.
Ma'am, serial number 51 ಏನಾಯ್ತು?
After vacation.
5150. After vacation, ma'am. Okay, thank you, ma'am.
Excuse me, ma'am.
ಹೇಳಿ.
Ma'am, serial number 20 ಏನಾಯ್ತು? Serial number 20. Suresh Yamlathur.
After winter vacation.
Okay.
ಅದೊಂದು ಇವ್ರಿಗೆ ಮಾಡದ್ ಬೇಡ. ಸೀರಿಯಲ್ ನಂಬರ್ 1. ಹೇಳಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ. ಸ್ವಲ್ಪ